Commissioners Kimberly W. Duffley, Jeffrey A. Hughes, Floyd B. McKissick Jr., Karen N. Kimmerite, William M. Brawley, and Tommy Tucker. I now call for hearing docket number E7 sub 1297 in the matter of application of Duke Energy Carolinas LLC for a certificate of public convenience and necessity to construct an 850 megawatt natural gas fired combustion. Strike that. Before we proceed further, and as is, actually, let's strike the whole thing and start over. Apologies, guys. All right, Renee, you with me? Okay. Good morning. Let's come to order and go on the record. I'm Charlotte Mitchell, Chair of the North Carolina Utilities Commission. With me today are Commissioners Kimberly W. Duffley, Jeffrey Hughes, Floyd B. McKissick Jr., Karen M. Kimmerite, William M. Brawley, and Tommy Tucker. I now call for hearing docket numbers E-2 sub 1318 and EC-67 sub 55 in the matter of joint application of Duke Energy Progress LLC and the North Carolina Electric Membership Corporation for a certificate of public convenience and necessity to construct a 1,360 megawatt natural gas fueled combined cycle electric generating facility in Person County, North Carolina. Before we proceed further, and as is required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any member of the Commission has a known conflict with respect to the matters coming before us in this docket. All right, the record will reflect that no conflicts have been identified, so we will proceed. On September 1st, 2023, DEP filed, consistent with Commission Rule R861 sub A and docket number E2 sub 1318, preliminary plans to construct a new advanced class combined cycle electric generating facility at the existing Roxborough steam plant in Samora, Person County, North Carolina. Thereafter, on March 28, 2024, DEP and the North Carolina Electric Membership Corporation, NCEMC, together with DEP, I will refer to as the joint applicants, filed with the Commission a joint application pursuant to North Carolina General Statutes, Section 62-82, 62-110.1, and Commission Rule R861B for a certificate of public convenience and necessity to construct and operate a natural gas-fired generating facility at the site of its existing Roxborough plant. The application proposes a dual ownership scenario with DEPs owning approximately 1,135 megawatts of the capacity and NCEMCs owning the remaining approximately 225 megawatts. The application asserts the following. Placing the proposed facility into service by January 1st, 2029 will enable DEP to permanently retire coal-fired units 1 and 4 at the Roxborough site. Citing the proposed facility will allow for the efficient utilization of existing infrastructure currently supporting Roxborough units 1 and 4. Connecting the proposed facility to DEP's transmission network will require limited transmission network upgrades, as shown by the interconnection study processes undertaken on the proposed facility. And constructing the proposed facility will provide DEP with generating capacity that is more efficient and more flexible than Roxborough units 1 and 4. The application also provides that the proposed facility will rely on natural gas as a fuel supply, is hydrogen capable, and will utilize ultra-low sulfur diesel stored on site as backup fuel. In support of the application, the joint applicants filed the direct testimony of 5 witnesses, portions of which are confidential. The testimony accompanying the application discusses the need for and the cost of the facility. On April 10th, 2024, the Commission issued an order scheduling hearings, establishing procedural and filing requirements, and requiring public notice. The scheduling order scheduled 2 public witness hearings to be held on June 12th and on June 13th, 2024, for the purpose of receiving testimony from public witnesses. The scheduling order also scheduled an expert witness hearing to commence subsequent to the expert witness hearing held in dockets number E100 sub 190 and E7 sub 1297. On June 6th, 2024, DEP filed its affidavits of publication confirming that public notice was provided as required by Commission order. On June 10th, 2024, NCEMC filed its affidavits of publication confirming that public notice was provided as required by Commission order. Public witness hearings were held as scheduled on June 12th by way of WebEx and on June 13th in Person County. The public staff, which represents the using and consuming public, has been made a party to this proceeding in accordance with North Carolina General Statute, Section 62-15 sub D. In addition, the following parties have petitioned to and were allowed to intervene in this proceeding: the Carolina Industrial Group for Fair Utility Rates 2, the Carolina Utility Customers Association Incorporated, the Environmental Defense Fund, the Southern Alliance for Clean Energy, the Sierra Club, and the Natural Resources Defense Council. On June 24th, 2024, the following parties filed direct testimony and exhibits: SACE et al., and the Environmental Defense Fund, and the public staff. On July 18th, 2024, DEP and NCEMC filed rebuttal testimony and exhibits. That brings us to today. I now call upon counsel for the parties to introduce themselves for purposes of the record. We'll begin with the joint applicants.
Thank you. Good morning, Chair Mitchell, Commission Jack Jurack on behalf of Duke Energy Carolinas, Duke Energy Progress in this proceeding. I'm joined today by my co-counsel Jason Higginbotham, along with Brett Breischwert and Brian Franklin.
Good morning, Mr. Jurack.
Good morning, Chair Mitchell, members of the commission. I'm Tim Dodge, appearing on behalf of North Carolina's electric cooperatives, joint applicants in this proceeding. Thank you.
Good morning, Mr. Dodge.
Good morning, Chair Mitchell, members of the commission. Tom Felling. I'm joined by Will Freeman on behalf of the public staff with the using and consuming public.
Good morning, Mr. Felling and Mr. Freeman.
Good morning, Commissioner Ben Smith on behalf of the Environmental Defense Fund.
Good morning, Mr. Smith.
Morning, Chair Mitchell, Commissioners. I'm David Neal, the Southern Environmental Law Center. On behalf of SACE et al., with me is Christina Tidwell, appearing pro hoc vice, also of the Southern Environmental Law Center from our Alabama office.
All right. Good morning, Mr. Neal and Ms. Tip.
Morning, Chair Mitchell, members of the commission. I'm Bo Summers with the law firm of Lawrence B. Summers, PLLC, and I'm here today on behalf of Person County.
Good morning, Mr. Summers.
Good morning, Chair Mitchell, Commissioners. I'm Martin Strafe from the law firm of Pierce, appearing for CPCN.
Good morning, Mr. Trathan.
Good morning, Chair Mitchell and members of the commission. My name is Ashley Van Slyke with the law firm of Bailey and Dixon, appearing this morning on behalf of Sigford 2.
Good morning, Ms. Van Slyke. All right. Are there any preliminary matters that we need to take up before we begin?
Yes, thank you, Chair Mitchell. DEP has a few matters to address. First, we asked that Duke Energy Progress's notification to the North Carolina Utilities Commission of preliminary plans to construct an electric generating facility in Person County, North Carolina, consisting of exhibits 1 through 3, filed on September 1st, 2023, be entered into the record and copied into the record at the appropriate time. Next, we ask that the joint application of Duke Energy Progress LLC and North Carolina Electric Membership Corporation for Certificate of Public Convenience and Necessity to construct a 1,360 megawatt natural gas fueled combined cycle electric generating facility in Person County, North Carolina, filed on March 28th, 2024, be entered into the record and copied into the record at the appropriate time. We also ask that exhibits 1 through 4 of Duke Energy Progress and North Carolina Electric Membership Corporation's March 28th, 2024 joint application for Certificate of Public Convenience and Necessity be entered into the record and copied into the record at the appropriate time. Finally, we would like to note that on August 1, 2024, DEP filed a motion to substitute Mr. Glenn Snyder as the sponsor of the direct testimony of Mr. Michael Quinto, and to streamline Mr. Quinto out of the rebuttal testimony of DEP's IRP panel. And the commission granted DEP's motion on August 5th, 2024. Accordingly, Mr. Snyder will be appearing today in the place of Mr. Quinto to answer questions during DEP and NCEMC's direct case, and Mr. Quinto will not be appearing with the IRP during DEP and NCEMC's rebuttal case. That's all.
All right. Thank you, Mr. Higginbotham. I will take your motions. I will address your motions in the order in which you made them. So the notification filed by DEP as to the preliminary plans to construct the proposed electric generating facility that was filed in the docket on September 1st, 2023, along with the exhibits there too, will be admitted into the record, as I've heard no objection from any of the parties. My notes indicate that there's confidential information in that filing. Is that in fact the case?
That is correct.
Okay, well, we will make sure that the confidential portions are redacted in the public facing transcript. I'd ask that you all work with the court reporter to make sure that happens appropriately and correctly. The joint application for the CPCN that was filed in this docket on March 28th, 2024, and the exhibits thereto will be admitted into the record as well, as I've heard no objection to your motion. And there are portions of that filing that are confidential, so those portions will be marked appropriately. And I ask again that you work with the court reporter to make sure that that happens as it should. And thank you for reminding us that Mr. Snyder will be here in place of Mr. Quinto. And with that, are there any preliminary matters from this side of the room?
Chair, we have observed that no parties have cross-examination reserved for public staff witness Daryl Brown, and we had filed a motion to excuse. If the chair would like to address that motion now. He's sitting in the back, but if we can excuse him, and
All
we
right.
can go ahead and move his testimony into the record, or we can wait till our case in chief.
Let me check with my fellow commissioners to make sure that none of them has questions for Mr. Brown. I'm not seeing any questions for Mr. Brown. All right, so we will allow the motion. Mr. Brown's testimony consists, let me get, make sure.
Would you like me to make a motion on that point?
Please do, yes.
The public staff would respectfully move the corrected testimony of Daryl Brown as filed on July 30th, 2024 into the record, including the appendix attached thereto. That testimony consisted of 6 pages of direct testimony and additionally an appendix A consisting of 1 page that set forth the qualifications and experience of Mr. Brown. And I would note for the commission that the corrections made on July 30th were to include page numbers and footers that were inadvertently omitted from the June 24th, 2024 filing, but all the other content remained unchanged. We would ask that that be moved into the record.
Okay. There being no objection to your motion, I will allow it, and the direct testimony of Mr. Daryl Brown on behalf of the public staff filed in the docket initially on June 24th, 2024, and then as corrected by the July 30th, 2024 filing, which consists of 6 pages and 1 appendix, will be copied into the record as if delivered orally from the stand.
And also in the sub A docket, we caused to be filed a summary of the testimony of Mr. Brown on August 1st, 2024.
And all right, I will treat that as a motion, and the summary of Mr. Brown's testimony will be copied into the record. The summary of Mr. Brown's testimony will be copied into the record at the appropriate time as if delivered orally from the stand. Mr. Brown's testimony will be copied into the record at the appropriate time.
Thank you, Chair.
All right. Any additional preliminary matters?
Chair Mitchell, yes. David Neal on behalf of SACE et al. Our out-of-town witness, Mr. James, is here and ready to testify. We have a request to the parties to allow him to appear out of order, given inclement weather that's coming, to allow him to get back on a flight this afternoon to Houston. My understanding is no parties have objected except DEP has said they would object if it interrupted their direct case. But we would ask that if we get to lunch and we have not gotten through Duke Energy Progress's direct case, that the commission consider allowing Mr. James to appear and take the stand before lunch.
All right, Mr. Neal, I'll take the motion under advisement. Let's see where we are
Thank you.
as we head towards lunch, and we'll address the matter at that time.
Thank you.
Anything else from council before we get started?
Nothing else.
Okay. All right. Then with that, Duke and NCEMC, you all may call your first witness.
Thank you. The company calls Mr. Glenn Snyder to the stand, and I'm Brett Breichwart on behalf of DEC or Duke Energy Carolinas. Good morning.
Good morning, Mr. Snyder.
Good morning, Chair Mitchell.
All right, let's get you sworn in. Raise your right hand, please. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good morning, Mr. Snyder.
Good morning, Mr. Breichwart.
Would you please state your full name and business address for the record?
Yes, my name is Glenn Snyder. My business address is 525 South Tryon, Charlotte, North Carolina, 28202.
Thank you. And by whom are you employed and in what capacity?
Duke Energy as Managing Director of Integrated Planning and Analytics for the Carolinas.
And can you briefly describe your role and responsibilities at Duke Energy?
Yes, I am responsible for the development of the DEC and DEP IRPs, along with associated analytic functions such as CPCNs, as this proceeding, avoided cost, and other such matters.
Thank you. And Mr. Snyder, as Mr. Higginbotham addressed to the commission earlier, as of the commission's August 5th, 2024 order, you have adopted the pre-filed direct testimony of Mr. Michael Quinto consisting of 33 pages, correct?
That is correct.
And do you have any changes to your direct testimony at this time?
I do not.
And if I were to ask you those same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Thank you. And did you also pre-file a summary of your direct testimony for the commission?
Yes, we did.
Thank you. Chair Mitchell, at this time, I would ask that Mr. Snyder's pre-filed direct testimony and summary be entered into the record as if given orally from the stand.
All right. Mr. Breichwart. Oops. That motion will be allowed.
Thank you. Mr. Snyder is now available for cross-examination by the parties and questions from the commission.
Thank you, Chair Mitchell. Good morning, David Neal for Sace et al. Good morning, Mr. Snyder.
Good morning, Mr. Neal.
Long time no see. Starting with your direct testimony, you cite the Commission's carbon plan order issued December 30th, 2022. And at the bottom of page 5 of your direct, you cite specifically pages 76 through 77 of the inaugural carbon plan order. And I believe you quoted it at the bottom there of page 5, indicating that the Commission gave substantial weight to the company's testimony that Duke's planned coal retirements require replacement resources that can provide firm, dispatchable, and equally reliable capacity, like baseload CCs. I had a little ellipsis there, but do you see where you cited the order?
I do see that.
And you would agree you didn't cite all of the relevant provisions of the Commission's inaugural carbon plan order on this topic?
No, I cited just that subset.
And so you recall that page 79 of that order, of the Commission's order from December of 2022, also said at page 79 that if and when Duke applies for a CPCN for any new natural gas-fired generating facility, the Commission will evaluate the need for the facility using this 2022 carbon plan as one factor in determining the need.
Subject to check. That sounds correct.
And it further, the Commission stated that it will, quote, evaluate the projected costs of the facility, including all the costs associated with the construction of the facility itself.
Again, subject check. That sounds correct.
And, quote, it would not be appropriate to give the Commission's approval for planning purposes of 800 megawatts of CTs and 1,200 megawatt of CC dispositive weight in the future related CPCN proceedings.
Yes, it said it was one factor.
And you would agree that the Commission's order predated both the proposed and final EPA 111 rules restricting carbon emissions from new gas-fired electric generating units.
It did predate the Clean Air Act 111.
Now, turning your attention to page 27, lines 3 to 4 of your direct, you testified, quote, the proposed facility is projected to operate as a base load resource with flexibility to operate efficiently around the clock. Correct?
I do testify.
And then the next lines, you note that one of the purposes of the Roxborough CC is to, quote, provide emissions reductions relative to the replacement energy available to the system. And you would agree that the DEP units that this would replace, Roxborough 1 and Roxborough 4, have not in recent years operated as baseload resources.
Yeah, and I think, we use the term baseload a lot. It's in EPA 111. We've used it in different terms. One of the things I tried to point out in the CPIRP is there's baseload on an annual basis, and then there's there's different temporal time steps you can look at. So there may be a week or a month where a unit runs base load, but then not for the rest of the year. So on an annual basis, a unit may have a relatively intermediate or low capacity, but it might run flat out for 8 straight days if we're in a very cold weather or hot weather period. And let's say we have a nuclear plant in planned maintenance or in a fuel outage. And so baseload can be viewed from different time horizons. And I think it's important to note that one of the things that this facility can do is whether it's immediately upon commissioning or into the future when we have more renewables, it's capable of running flat out for days or weeks on end in a manner that other resources simply can't. And so it can run base load for 2 weeks straight at very efficient, low fuel, low carbon output compared to the rest of the system. And if it only does that a few weeks here and a few weeks there, it still may be intermediate or peaking on an annual basis, but it runs base load for short periods of time when the system is in need. And that's the reason we do 8760 or every hour of the year planning, is to look at needs operationally at different time horizons. So I would agree that on an annual basis, both the coal and the combined cycle may or may not run baseload depending on market conditions, but they will run baseload when needed at different time steps. And so they can run baseload for 1 or 2 weeks if needed.
Mr. Snyder, maybe I'm having a definitional problem, but having a power plant that's capable of running at a higher capacity factor for a short amount of time, isn't that a definition of a peaking resource?
No, it actually isn't. Because if you think about it, a battery is a peaking resource and it has no ability to run baseload for a week, right? I call batteries peaking resources, but they can meet peak needs for 4 hours during the day. Then they need to consume energy sometime in the day so that the next day they can provide peak needs 4 hours the next day. The difference is a peaker or a combined cycle can run throughout the day, both the morning, the night, the peaks, and into the next day in a way that batteries, DSM, load control programs, they simply can't. They're short hourly durations where these resources are days on end if needed.
And again, maybe I should have been clear. A peaking combustion turbine would fit the same definition of a peaking resource, of a what you called a baseload resource for a week.
Yes, a peaker could run for a week straight. It would have a higher heat rate, a higher carbon output than the facility we're talking about here, but it has the capability to run for multiple days on end if needed.
Now, the winter nameplate capacity of Roxborough Unit 1 is 380 megawatts. Is that right?
Well, rather than look it up, I've got it in front of you. I'll say subject to check.
Yeah,
I'm sure it's
I'm
in front of you.
going off
I
my
just don't
notes.
know it sounds correct. Yes.
And well, then subject to check, the nameplate capacity for winter of Roxborough Unit 4 is 711 megawatts.
Yes, I can confirm both of those.
Now, if I could turn your attention to potential cross exhibit 40, and this is one we submitted on Monday, and if it's not, as when we revised our potential cross exhibit. So if the commission doesn't have it, I have paper copies. Chair Mitchell, do you have SACE at all potential cross exhibit 40?
Let me open I do not.
We updated, we filed an updated cross exhibit index on Monday and shared it with the parties and the commission on Monday. And I'm happy to.
All right. So is this, Mr. Neal, are you telling me that this exhibit came in sort of outside of the parameters of the commission's order?
Yes, Chair Mitchell, we found some things we could take out, and one thing we wanted to add, and I will just admit it was because I was in the carbon plan proceeding and hadn't seen that this information wasn't in the record and thought it was.
All right. Understood. All right. So, Mr. Neal, we've said, you were in the previous
Yes.
proceeding, and we've said, you know, we established these procedures for the provision of the cross or the potential examination exhibits in advance for a reason. We've asked the parties, or we've directed the parties to comply with that. You all have done, for the most part, a good job of complying with that order and helping to facilitate the efficiency of the proceeding. Here, you know, there have been instances where a party has asked to have an exhibit admit or be allowed to use an exhibit outside of the requirements that we just established, and we want there to, we've asked for good cause to be shown for us to allow you to do that. Now, what I'm hearing you say is that you've provided this exhibit, this potential exhibit to the parties. Is that
On
correct?
Monday, yes.
And am I hearing an objection from any parties to Mr. Neal's use of this potential exhibit?
So I'm trying to download it from our repository, and it seems the file is corrupted that we have. So, Mr. Neal, if you could provide a copy of
This
that.
is
would
the
be
EIA
appreciated.
capacity factor chart.
Yes, it is it's just a summary from S&P Capital showing the annual capacity factors for Roxborough units.
Person County.
Again,
Oh, there. Oh, yeah. Okay.
No objection.
So I'm hearing no objection from Duke, any objection from any of the other parties. All right. Mr. Neal, I'm going to allow you to use it in this instance because I'm not hearing an objection. But I remind you all, please, you know, come prepared. If you're going to ask to use exhibits, examination exhibits outside of the procedures that we've established, you have to show good cause. And I'm not hearing good cause. I mean, we were all in this hearing. But I'm also not hearing an objection, so I'll be lenient in this instance, let you use it. But for the future, for purposes of, you know, this instance recurring in the future, let's you all are going to be asked to demonstrate good cause. All right, with that, go ahead, Mr. Neal.
thank you, Chair Mitchell. Do you need paper copies of?
We've got it up
Okay,
there.
thank you. So we would ask that SACE et al. Potential cross exhibit 40 be marked SACE et al. Cross Snyder direct exhibit 1.
All right, the document will be so marked.
So again, Mr. Snyder, this is just taken from S&P Capital, where they supply the annual capacity factors of the 4 Roxborough coal units. Recognizing you've provided testimony already a moment ago about the difference between the annual capacity factors and how a unit might run for a week or two at a stretch, you would agree that just from an megawatt hours perspective, this chart would demonstrate the amount of megawatt hours that Duke would be replacing as these units shut down for purposes of, again, replacing what they have been doing recently, not considering future load growth.
Yeah, correct. I think we've established that on an annual basis, these used to run base load. As we've added gas to the system and commodity prices have changed the way in which they have, they've converted more to intermediate to peaking on an annual basis.
Thank you. Now, and at page 19, lines 1 through 2, you testified that the proposed Roxborough combined cycle is part of Duke's all of the above approach to executing the Carolinas energy transition. Do you agree that all
Sorry,
of the...
Mr. Neal, if I could just get,
sorry. I didn't think you would...
Okay, go ahead. We'll try and move faster.
Would you, when you think of all of the above, would you agree that also Duke's considering the importance of having a diversity of resources?
Yes, I think diversity of resources to the extent is needed to meet the objectives of 951 is a consideration.
And in your attachment 1B at page 11, you showed the fuel diversity that the combined DEC DEP system would have during part of the planning period. Isn't that correct?
I'm sorry, attachment 1B to,
You sponsored it. I believe you sponsored attachment 1B to the
to
application.
the application. Gotcha. Yes, I remember that.
And so that's one lens through which you could look at fuel diversity, is that chart, just how much fuel is being relied on from
It's
different resources.
It's one lens.
And another lens would be to consider the total sort of production capacity of any given resource on the system compared to the total production capacity that Duke has in any given year.
Mr. Neal, when you say capacity, are you talking about peak capacity contribution or annual energy contribution?
I'm talking about the information that is in the CPIRP table SPA T11 for DEP that shows winter load, capacity, and reserve tables. So that shows.
Right. So that's peak capacity. Yes, I would agree with that.
Okay. And we're just going to move to the projected capacity factors of the Roxborough unit. I want to point you to a potential confidential cross exhibit, but I think I can ask these questions without revealing any confidential information. So turning your attention to SACE et al. Confidential potential cross exam exhibit 1 in that binder. I know I went from 40 to 1.
We'll get there.
And Chair Mitchell, we would ask that this be marked, that potential cross exam exhibit 1 be marked as SACE et al. Cross Snyder Direct exhibit 2, confidential exhibit 2.
All right, the SACE potential exhibit 1, which is confidential, will be marked as SACE et al. Cross Snyder Direct confidential exhibit 2.
Thank you. And Mr. Snyder, you see this is a response to public staff's data request 2-15 in this docket.
I saw that.
And again, I'm not going to ask to elicit. Is this confidential because it's output files from the Encompass?
I think so. Yeah.
And do you think that, I mean, I can leave it to counsel for Duke, but is that still confidential information?
Just capacity factors, I don't think are, but I'm going to defer to counsel on this. I don't think capacity factors are something I would normally consider confidential.
Yeah, I haven't had a chance to review it in detail and confer with others. So we can follow up at the end and say it doesn't need to be confidential, but this is the first time Mr. Neal's raised this.
All right, for now, then we'll treat it as confidential.
Thank you. So you would agree that this shows the modeling results for P3 fall, showing the projected annual capacity factors for the proposed Roxborough combined cycle unit.
And Mr. Neal, I'm going to stop you. Mr. Snyder, I know this goes without saying, but for purposes of the record, to the extent he asks you a question that would elicit confidential information in your response, do not provide that confidential information as we're in open session.
Certainly. Thank you, Chair Mitchell.
But you agree that's what it shows without asking the numbers. And again, without discussing the underlying numbers until we've resolved whether it needs to be confidential, you would agree that this shows that Duke Energy Progress is anticipating the annual production declining each year that it's in service through the 2040s.
Yes,
Again,
I think we've had a lot of testimony over the last 3 weeks that that's always been the anticipated role of these facilities, is to start off as both capacity and energy in this critical transition period, and then over the coming decades to decline in capacity factors and become more of reliability resources. And that was fully envisioned when the model selected that. So the model understood that the energy value was going to decline over time. And that was completely part of the economic analysis that was envisioned when the selection. So the notion that somehow declining capacity factors mean declining value is a little bit inerrant because that was fully baked into the life cycle economics of these units when they were selected as part of the most reasonable least cost plan within this docket or within the IRP docket.
And Mr. Schneider, you would agree that a significant reason why Duke anticipates that decline in annual usage is that zero carbon, zero fuel resources will be coming online in greater amounts throughout the 2030s and 2040s that would displace some of the energy that would otherwise be provided by that facility, right?
Yeah, and that is certainly our hope and our plan, right? And hope is not a plan, so that is our plan. So I had to get that in. I didn't get to say that just time. So, but that is our plan. And I would say though that as Mr. Thomas, public staff witness Thomas pointed out, this is going to require a significant increase in the amount of renewables that are being added over the next 2 decades compared to historic, right? The amount of siting, permitting, supply chain, interconnection that we've spoken at length about. Should those resources get delayed in time, these initial facilities are not only standing by for short term if it's cloudy out, it's what if I only get 800 and not 1500? Where's that energy going to come from? So they hedge us on a forward-looking basis. If for whatever unexpected reasons, these aggressive levels of renewables that we expect to add to the grid run into problem, I've got to have something low carbon to replace that energy that we're planning on in the plan. So I look at these. Yes, we've selected them based on declining capacity factors, but I also look at them as providing critical energy in the coming 2 decades. Should that level of adoption go up or down, these units capacity factors can rise or fall to make up any excess or deficit that may manifest itself over the coming 2 decades as we look to add 17,000 megawatts of solar and 2,400 megawatts of offshore wind. If that doesn't happen at that place, the system, the customers don't know it. They still want the energy, and we still want a clean, efficient source of energy. So these resources have projected declining capacity factors. If we're successful and bring them on, that's what's going to happen. If for whatever reason those renewables come on slower, these capacity factors will stay higher for a little bit until we do get those renewables on. But they are hedging us on a multi-decade basis for this adoption of renewables, and they are always there to provide capacity in the real-time operations.
And these projections in confidential exhibit 2 were not informed by anticipated compliance with EPA's 111 rule, correct? These are just what the model initially showed.
Yes, we have the initial, and then later we provide the.
And absent some dramatic change with regard to either green hydrogen or carbon capture, the 111 rule would limit that Roxborough CC to operating at no more than 40% capacity factor starting in 2032.
Yes, we will, I'm sure, discuss that in rebuttal. We provide that analysis.
And just turning your attention to SACE et al. Potential cross exhibit 4. And we would ask that this be marked SACE et al. Cross Snyder Direct Exhibit 3. You'll see this is a report by Eric Gimon, Mike O'Boyle, and Michelle Solomon for Energy Innovations titled Meeting Growing Electricity Demand Without Gas.
All right, the document, which is the SACE et al. Potential Exhibit number 4, will be marked as SACE et al. Cross Snyder Direct Exhibit 3.
Turning to the top of page 3 in the first full paragraph, you'll see that the authors note it's important for policymakers, especially the public utility commissioners who will need to approve these additions, to remain skeptical of plans to add new gas. New gas plants represent large investments that utilities will be locked into for decades to come. This means that as the clean electricity transition accelerates, these plants could become stranded assets with costs ultimately falling to electricity customers. Now, given everything you've said already today, I take it you disagree with that statement and do not think that these units will be stranded assets, given what you just testified to about how you see their usefulness through 2050. Is that a fair summary?
Yeah, I've said in the CPIRP hearing, and I'll say it in this hearing, it is nearly impossible, highly improbable to physically strand these assets. People talk about it academically and in literature like this, but they don't have a forward path in which that's even physically possible. We have almost half the energy in the country today comes from gas. We still have 20% that comes from coal. For these assets to be stranded, which are more efficient, these assets that we're talking about in this proceeding are the most efficient in the country. These are the lowest heat rate, advanced class. We had a lot of discussion on that prior. Some technology would have to come in and displace all the coal in the country, all the gas in the country, and then come in and displace these. And that would all assume that neither hydrogen, sequestration, offset markets, reliability outs, none of those were allowed. Some new technology that's not here comes into the scene at a pace, scope, and scale sufficient to displace the entire energy infrastructure of the US in a 2-decade period, and then have enough pace, scope, and scale to displant these. There really isn't a plausible way forward in which these extremely efficient units are not going to be used and useful in the capacities envisioned over a 3.5 decade expected useful life. There's a lot of academic, arguments that they almost pre-assume that we're going to be stranded because we're going to be net zero by 50, but they don't have an engineering, here's how that's going to happen at the pace, scope, and scale, the supply chains that would be needed, the labor force that would be needed, the technologies that would actually be able to do that would run carbon free for 3 weeks straight at a pace, scope, and scale to displace that much of the nation's energy. It's simply been lauded out there as a barrier to adding these resources. But I think it's highly, highly improbable, if not impossible, for these to become stranded over the next 3 decades.
Well, as I said, I take it you disagree, and
that's a fair assessment.
You disagree. And at the bottom of page 3, under the heading resource efficiency, this is getting at sort of issues of historical look at load growth. You'll see where they wrote in 2007, the Energy Information Administration predicted nearly 1.5% annual electricity demand growth, a 21% increase over 15 years. The growth pause of these last 15 years, a whopping 785 terawatt hours of missing demand, wasn't an accident. Energy efficiency was the largest contributor to avoiding this projected growth in the power sector and was brought about by 3 major factors: utility efficiency programs, federal and local building codes, and appliance standards. Oh, and voluntary industry efforts. Now, do you agree that those factors, utility efficiency programs, federal and state building codes and appliance standards, and voluntary industry efforts played significant role in the flat load growth experienced in the Carolinas between the mid-2000s until recently?
Yeah, we certainly believe that our efficiency programs are helping to shrink the challenge that we need supply side resources for. I have no debate with that. And efficiency standards are also playing. I will say 2007 to now, you were right before the housing crisis. So it's always your start and end point, right? And so you had a housing crisis, you then had a financial crisis, and you had COVID. So there are other external factors beyond just those mentioned that can, and they exist on the other side. So we had a lot of testimony about some really big trends facing the country right now in terms of electrification of other sectors, not just the electric vehicle sector, but the heating sector, the industrial process sector, right? So as we electrify, that's going to put upward pressure. We had a lot of testimony from our economic development team about onshoring of US manufacturing. 2007 and into the teens, it was a very global economy and we were offshoring. We're now onshoring manufacturing. So that's going to have an upward force. And then, of course, all the news press, you can't hardly turn on the news without the amount of data needs as we move towards AI and cloud computing and data storage and the energy needs with that sector. So none of those existed in that time frame being referenced. And it's all the backdrop that we're facing today. So I could have picked another decade period where energy efficiency was still happening and shown tremendous growth. This particular decade period they reference in this report shows flat. That doesn't mean that when you look out over multiple decades, you should just ignore the fact that you have load growth facing you in a real and material way.
Well, in turning to the chart at the top of the next page, page 4, you see where they compared that EIA projected electric load growth to the actual U.S. consumption of electricity. And again, that's national data. You would agree North Carolina followed a similar trend in that period?
Yes, as I said, there were a lot of factors happening in that period. And some of those are there. Sorry.
Sorry.
Go
I'm
ahead.
just trying to keep us moving.
Yep.
And you would agree that in that mid-2000s, Duke was still predicting load growth that didn't materialize at that time?
Yeah, I would agree that there are periods where we have over forecasted and periods where we have under forecasted.
And I really am almost done here. Just in the middle of page 5, so the next page, there's this category voluntary efforts that, again, looking at an historical perspective, the authors note, data centers are prime examples of how voluntary efforts can lead to less demand growth than anticipated. A 2007 EIA study projected that data center use would double in a decade, extrapolating current practices to future demands for data processing. In reality, demand remained flat over that time, and a subsequent 2016 Lawrence Berkeley National Lab report demonstrated how energy efficiency gains blunted the growth of data center electricity demand from 2009 to 2016. Now, you would agree that projected load growth from data centers is a contributing factor to Duke's load growth forecast today?
It is certainly one factor, and I think we've heard testimony that they are already coming in as efficient as they can possibly be. Energy is very important to them. It's a big part of their input costs, and it's also a big part of their goals. So being as low as energy as possible. So how much further is going to be a question. And, I've heard a lot of testimony about, interrupting their load. Well, again, they're not going to stand for being interrupted for 3 days, and all data centers, in my understanding, I'm still coming up to speed talking to different data centers, have different, they're all not alike. Some data centers have the capability to reduce load for short periods of time, and some do not. And it depends on the type of, generative AI is very, very different than data mining or Bitcoin mining. And so those processes are extremely different, and their customers are very different. And their ability to shift load is very different. But again, we're talking about shifting load. The fact that they are large, high load factor customers means they're going to need energy year round. Whether they can clip peaks a little bit, that's helpful. But batteries clip peak, DSM clips peak. We heard a lot about VPPs, clip peak. At some point, you have to stop clipping peak and serve energy, because your load in the middle of the day and your load in the morning are not infinitely different. Once you've clipped the morning load, it's showing up somewhere else in the day. And then you just need resources that can serve energy. And that's why all of the above is so important. So we have a lot of peak clipping programs. These type of data centers that can peak clip add to that, but they're going to want energy over the course of that week. They're not turning off for a week. And so you've got a lot of peak clipping, a lot of time of use rates, a lot of demand response, a lot of VPP, a lot of batteries. At some point, you've got to add resources that can serve the rest of the week when this load gets moved to. And that's exactly what this facility in question does.
No further questions.
All right, public staff.
You. Good morning, Tom Felling with the public staff. Good morning, Mr. Snyder. Welcome back to your third hearing in as many weeks.
Thank you, Mr. Felling. Good to be with you.
It's good to see you. I wanted to kind of just start at what is close to the beginning of this docket with the joint application that was filed by DEP and NCEMC in these dockets. Are you generally familiar with that joint application?
Generally familiar, yes.
Okay. And would you agree that the contents of that joint application are true and accurate based on your review?
To the best of my knowledge.
Okay. And do you have that application with you?
I do have the application.
Okay, hopefully we can kind of move through this quickly, but if you look at page 1, on the bottom of the application, do you see the statement that DEP will operate the proposed facility and own approximately 1,135 megawatts of its capacity, with NCEMC owning the remaining approximately 225 megawatts? Do you see that statement?
I do see it.
Okay. And going a little bit further into the application on page 13, I'm sorry, paragraph 13, which is on page 10, it states that NCEMC jointly owning approximately 225 megawatts of the proposed facility's approximately 1,360 megawatt total capacity, and serving its existing load is neutral to the company's planning need presented in the CPRP. Did I have that correct?
You do.
And then going down just a little bit further on page 13, NCEMC's joint ownership will result in a reduction in the NCEMC wholesale requirement load the company would have otherwise been required to serve.
That is correct.
Okay. And just generally, and just based on your review of this application, it's very common in the application for it to talk about joint ownership and NCEMC using words like the joint ownership will, or NCEMC will co-own. Would you agree that those terms kind of appear throughout the application?
They do.
All right. Would you agree with me that as a regulated utility, it's very important for DEP to provide the commission with the most transparent, accurate information as possible in its filings?
We endeavor to do so, yes, sir.
Okay. And so do you recall that through discovery, the public staff learned that DEP and NCEMC have not agreed upon terms to co-own this facility?
I am sure I'm not part of that team, but it takes time to negotiate such contracts, so that does not surprise me.
Okay. Is it your understanding that there's not a current contract between DEP and NCEMC?
Not an executed one is my understanding.
Okay. And is that fact at all reflected in this application based on your review?
No, I think what's important is it's whether this happens or not is, to from an IRP perspective anyway, I'll just speak from my expertise, it's a bit irrelevant. We are going to use this facility to serve our entire obligation load, both retail and wholesale. And whether or not we were to effectuate a joint ownership in this just changes the sort of the contractual nature in which that happens. And so that's what that paragraph 13 was saying is, I'm going to either have that load served through a full requirements load that we are already in with NCEMC, or I'm going to reduce that load and have a part of that directly served by the co-owned unit. Either way, this unit is serving both Duke retail load and NCEMC load. The co-ownership is just the contractual nature by which that happens. Is it through a co-owned unit or is it through a full requirements contract? But the supply-demand balance doesn't change either way. So at least from a need perspective, the need for this unit doesn't change whether we go down path A or path B.
And just to clarify, if I heard you correctly, whether NCEMC and DEP do or don't consummate a contract is irrelevant to this proceeding. Was that what your testimony?
I'm saying it's irrelevant to the need. I don't want to speak to other aspects. Just from an IRP need, I would say the need is there either way, and how we commercially, fill that need probably is a topic of a different witness.
All right, fair enough. Mr. Snyder, in the CPRP during your testimony, I heard you make a statement. It was to the effect that you said the T's and C's are important. I don't have the exact reference to that statement, but I think it was in the context of a potential future merger or in future resource selections. But do you generally recall making that statement that the T's and C's are important?
Yeah, and I do. And I, at the risk of answering a question you didn't ask, it was in the context of the RFI. And that's a little bit different because that is a net new generator to the system. It's not a supply demand. The T's and C's will determine the price of the offshore wind is where I made that comment, is it's really important to what those T's and C's are to the cost. In this case, I think what we're saying here is that NCEMC is not just co-owning, but then they share in the costs, the capital costs, the operating costs, and without being part of the contract negotiations, I'm assuming that's at fair, just, and reasonable, prudent costs as they're incurred, then gets split between retail and wholesale. And that can happen in the full requirements. It can happen in the co-owned unit. But again, the need is still there and the costs are just shared proportionately. So I don't think the need changes, assuming the both parties are endeavoring to have fair cost sharing. I don't think the economics change on this project. So I really believe it's important to note the co-ownership, but it's not a fundamental driver for the need or the validity of this resource.
And just so we have it clear in the record, T's and C's are terms and conditions. Is that correct?
I'm sorry. Yes.
Okay.
T's and C's, terms and conditions.
Thank you for that. And so I understand that was in the context of the ARFI, and thank you for clarifying that. We're talking about, consummating an agreement on a generating resource that has the potential to have tremendous ratepayer impacts. Would you agree then that the terms and conditions of joint ownership of this facility are equally important?
Yeah, and again, I'm not a lawyer, so my lawyers can jump in if I venture where I shouldn't go. But this commission, as I understand it, regulates retail rates, right? And whether it's the 1100 and some odd or the the 112035 or the 1360, the retail portion, this commission will deem what is prudent, just, and reasonable in the context of cost recovery. And NCEMC, as a long-time, multi-decade wholesale partner, pays their costs through FERC established rates. And so I think the fact that they are co-owning this does not dramatically impact the fact that they are going to be allocated their portion either under the full requirements deal or under the co-ownership arrangement, and retail will pay for the remaining part of the asset that is not allocated to NCEMC. So I'm sure we have a long-standing relationship with them and that we will come to a resolution on a lot of the terms and conditions and get to a final rate. I just don't see it really impacting either the need or the retail portion that would be the responsibility of this commission in either way. So I don't see it as a big driver in this case. Again, from my IRP lens, and I'm not Miss Bateman or the rates analyst, but I listen to her a lot, and that's just my understanding.
And, not having had the opportunity to see what a contract between the parties could look like, I'm left to imagine what some of those T's and C's could be. And so I imagine potential terms and conditions could include matters such as allocation of plant O&M, construction costs, how to handle cost overruns, allocation of transmission costs, allocation of carbon, AFUDC, must-run agreements, future compliance costs and investments to comply with EPA 111, expenses due to hurricanes or natural disaster, and what I imagine could be a whole host of other terms and conditions. Is that a fair sort of starting list of terms and conditions we might see in an agreement, but we can't see today?
Well, I would just say, prudent, just, and reasonable costs have been allocated normally, as I understand it, on load ratio shares, sometimes capacity, sometimes energy, depending on which factor is being allocated. And I would expect that by and large, they would continue to align in that matter. So there's a lot of terms and conditions, but I think the allocation between the two would generally align with allocations that have been established, over time, and that we have dealt with NCEMC for decades.
I'm going to keep going here. Is it possible that, just talking about what the future could look like between the parties, and understanding that you have a good, DEP has a good relationship with NCEMC, it's at least possible that such an agreement may never be consummated though. Is that correct?
I suppose it's theoretically possible. And again, from an IRP perspective, we would still use this resource and allocate through the full requirements contract a portion to NCEMC's.
Mr. Snyder, I think some of the next questions I'm going to be getting into with you today are a little, you might have heard some of them from yesterday, but it's important to kind of go through this again and make the record in this matter. So I hope you'll humor me as we go through this process again.
I'll
But
try and move fast as well.
yes, that sounds good. Are you generally familiar with the commission's order adopting the initial carbon plan in the E100 sub 179 docket?
Yes, I'm generally familiar with that.
And you recall that the carbon plan order concluded that planning for a CC of up to 1,200 megawatts is a reasonable step for Duke to take at this time.
I do.
And you'd agree with me that that carbon plan order did not specifically direct Duke to pursue siting of a CC in DEP.
It did not explicitly say to cite the CC in DEP. You know, I think we spoke about in prior proceedings that it was the body of evidence suggests that's where it needed to be. It was cited in DEP in the 2020 IRP. It was in all but one portfolio cited in DEP in the carbon plan, and it was in all the portfolios in this proceeding. So in nearly for the last 3 IRPs, there is just a mountain of history that suggests that that should be cited in DEP, and we've tried to articulate that at length in the Marshall proceeding.
Would you agree that Duke's planning for citing the CC in DEP began well before the issuance of the commission's carbon plan order?
No, I think citing, as we talked about in a prior proceeding, we were always investigating what could be cited where. We look at all our options. But did you say the order or the filing? I'm sorry.
I did say the order.
I'm sorry. Yes, we did start citing work or development work before initial development work before the order.
Okay, and let me, maybe I'm using the wrong word, citing, maybe just clarify this. Would you agree that planning for the potential of a CC in DEP began well before the carbon plan proceeding? How about that?
Which the original carbon
sub
plan?
179.
Yeah, I mean, planning for, as I said, the 2020 IRP said we need a combined cycle in DEP and we need CTs in DEC. So planning, from a planning perspective, you're looking at options. You know, it's planning, as I've mentioned many times for this commission, planning is happening at the same time. It's not 18 months and we don't do any execution and then we go to execution and we come back. They're happening concurrently. And so, yes, when you have a 2020 IRP, a 2022 carbon plan, and this proceeding all saying you're certainly investigating combined cycle options. Where could they be placed? What are my options for placing them? What's the most efficient place to place them? So yes, in planning space, we have been looking at initial plans, you know, as options for a number of years.
And you can, I'm going to direct you to page 16 of your testimony, but I'm going to read it. And if you recall it, that's great. But page 16, line 4 of your direct testimony, you state, load growth in the Carolinas and the company's planned coal unit retirements over the next decade drive the need for the proposed facility. Did I have that generally correct?
Yes, we've spoken a lot about that. Load growth plus retirements.
Sorry, Chair Mitchell, Mr. Felling, I heard drive the need, direct impact on the need, just to confirm. Maybe I misheard you.
And
I apologize.
If I've not quoted to each word correctly, can we just say, just in general, that the testimony gives that general idea?
Absolutely. I thought you were quoting the language and I just wanted to be precise if we were intending to quote it. So apologies for the interruption. Thank you for clarifying.
All right, for my purposes, can you state again, Mr. Felling, the line and page, the page and line of the testimony to which you are asking Mr. Snyder to refer?
And I believe that would be page 16, line 4. I've got it in front of me, so I'll just go ahead and try to read it verbatim as best I can.
And I remind council, we do have the Elmo that you all can use. If that would facilitate things. Go ahead, Mr. Felling.
Thank you, Chair Mitchell. I've got it on my computer, unfortunately. Load growth in the Carolinas and the company's planned coal unit retirements over the next decade have a direct impact on the need for the proposed facility.
That is a true and correct statement.
Mr. Snyder, when you look at power flows between the DEP and DEC system, would you agree with me that for most hours of the day, power is flowing from the DEP system to the DEC system to serve DEC energy needs?
I think the most hours of the day are driven by the amount of renewables in the two systems. So yes, I would say that most hours of the day they are. I would not say that this facility is a fundamental driver of those flows.
But you'd agree with me that DEP resources are being used to serve DEC load. Is that correct?
I would, I guess how you characterize it's probably important. Under the JDA, there are efficiencies that were envisioned when the merger happened, such that if there is a lower cost marginal resource, and I think Witness Verderami and the IRP testified to this, that those lower cost marginal resources can displace higher cost marginal resources in the neighboring utility, and then both of those utilities share in the savings so that it lowers fuel costs for both customers. Importantly, it is a non-firm energy. So that is not a capacity transaction, right? The sending utility, the receiving utility cannot count on that for firm capacity purposes. So to the benefit of, I think there is some non-firm energy benefits. There is not a capacity benefit to be achieved due to the nature of the JDA.
Mr. Snyder, would you agree that the resource modeling performed by Duke in the carbon plan and in the CPIRP does not consider or really account for equity between DEP and DEC when selecting resources in those service territories?
I think it seeks to find the least cost independent solution for both, and it does not look in any way to try and compare the rates in one utility to the other, or determine it's seeking the least cost and resource mix to meet the capacity needs of the two individual utilities, and then through the JDA have the most least cost energy mix for the state.
But would you agree that just equity specifically on its own is not an input in that modeling?
Yes, I think, as I said in a prior proceeding, there is equity means a lot of different things to a lot of different people. And so we would need to define equity and see how equity is precisely defined to actually put it into a model. So it's not in the model as an input.
Thank you. And now going back to the commission's carbon plan order, do you recall that it states that the commission directs Duke to take reasonable steps to mitigate further exacerbation of the rate disparity between DEC and DEP attributable to the carbon plan by presenting solutions where appropriate, including but not limited to in its pending general rate case applications? Do you recall that statement?
I do recall that statement, and I believe, as we've stated in other proceedings, that we have a multi-tiered approach. Our first and foremost, we think this is a primary driver for the merger would be to efficiently deploy resources across the state in the least cost manner for the benefit of the entire state. And so the merger is our first step towards achieving that. If for whatever reason, we've heard a lot of testimony that the merger is not a sure thing. It has to go through multiple approvals. So we have committed in the stipulation to work with public staff on an ongoing basis to come up with an alternate plan for sharing of costs to the extent it makes sense for certain resources. Again, I don't view this particular asset at issue in this case as the primary driver for that. This is clearly a capacity resource replacing a capacity need that has been filled by a coal plant for 6 decades at DEP. So this is a DEP resource providing a DEP benefit. And to the extent it's really efficient and sometimes can have some residual energy benefit DEC through the JDA that was envisioned when the merger started well before 951. This all falls well squarely within that. I contrast that to something like an offshore wind facility that is largely providing energy benefits, not DEP replacement capacity needs, but no carbon energy to the state. That would be a primary example of a driver that would benefit either through a merger or an alternate mechanism. Those same facts and circumstances do not pertain to this asset.
Thank you, Mr. Snyder. I just wanted to clarify, I heard you in your response reference a stipulation, but did you mean the proposal that the companies proposed in their rebuttal testimony to work with the public staff on that mechanism? You said stipulation. but I
I'm
just wanted to
sorry. Yes,
clarify.
that's what I meant.
Okay, those are all my questions. Thank you.
All right, my notes indicate there's no additional cross for the witness. So let me just confirm that with the parties on this side of the room. Not seeing any indication of additional cross, so we'll go to redirect.
Yes, briefly. Mr. Snyder, Council for SACE spent a good amount of time speaking with you about historical capacity factors of the two retiring coal units at Roxborough and the plan or proposed capacity factors of the new combined cycle unit over its planned useful life. Do you recall those questions?
I do.
And then building on that line of questioning, they also present what I would characterize as an unaudited report by Energy Innovations, which was not specific to the company's system in the Carolinas, didn't reflect the plan for retiring 8,400 megawatts of coal generation by 2035, and didn't reflect the nation-leading economic development load growth that the companies are experiencing, to assert the point that there is a path to reliably serving the company system in the Carolinas without the need for new gas generation. Do you recall those questions?
I do, and that was the title of the report. Yes.
Okay. And to confirm, based on your knowledge, expertise, and being in this hearing room across resource planning proceeding for the last 2 weeks, as well as multiple CPCN proceedings this week, under all 50 portfolios that the companies ran and presented to this commission in the current CPRP proceeding, as well as over 20 portfolios in the 22 carbon plan proceeding, there was a well-established need for this combined cycle generating facility in Duke Energy Progress.
Yeah, that is correct. I think I mentioned it in response that for the last 3 IRPs, a combined cycle in DEP has been indicated as needed. And we are now, this is the culmination of that in the execution, that they are needed in all 53 portfolios in this, in the most recent CPIRP. They were needed in all but one of the portfolios, and that one portfolio in the original carbon plan, I will point out again, was a no MVP scenario. So the one portfolio in the carbon plan that didn't call for this combined cycle assumed that MVP did not come into fruition, which it now has. So I would argue that that portfolio wasn't even valid. So in all the valid MVP portfolios, this was selected. And then I just mentioned it goes all the way back to the 2020 IRP, where we were envisioning the need for a combined cycle in DEP.
Thank you. And referring back to the what was SACE Cross Exhibit 3, this Energy Innovations report that Mr. Neal presented to you, are you generally familiar with Energy Innovations? Have you heard of that organization before?
I have heard of them, and I'm generally familiar.
Okay. Would you characterize it as a credible and reputable source of information that the company would rely upon in developing its resource planning assumptions, modeling, or plans for new generating facilities?
I would not.
Thank you. No further questions.
All right, let me see if there are questions from commissioners for the witness. No questions. All right, or Commissioner Kimmerer, go ahead. Go ahead.
Mr. Snyder, I want to just follow up on some testimony that you provided on beginning on page 5 of your testimony. And this is in regard to a discussion about the need for the CC related to the 2022 carbon plan order.
I'm there.
And on page 5, you stated that Duke's near-term action plan and the 2022 carbon plan proceeding proposed an advanced class CC achieving commercial operation in the 27 to 28 timeframe, and that the CC would total about 1,200 megawatts. And on page 6, you talked about the carbon plan order in 2022, the December 30th, 2022 carbon plan order from the commission. And you noted the conclusion on page, I believe, 79 of the carbon plan order that stated that it was reasonable for Duke to plan for a CC of up to 1,200 megawatts. And can you just briefly provide your opinion or statement about whether proposing a CC of 1,360 megawatts with this application is consistent with the commission's conclusion in the carbon plan order of the need for a 1,200 megawatt CC facility?
Yes, thank you, Commissioner Kemmerite. It is a good question. I think we had some testimony in the Marshall proceeding about advanced class CCs and how the technology has been marching forward and improving. And so at the time of the carbon plan, the advanced class CCs were of a little bit smaller size, right? And not quite as high of an efficiency as we're able to avail ourselves of today. Much like, solar improving or batteries improving, all of these technologies seek to improve in efficiency, in their lower carbon output, lower gas consumption, and that often comes by larger economies of scale. And so I think, within all of this, there is a realm of reasonableness as to you would want to the customers of North Carolina to benefit from those improvements that have happened since the last carbon plan. Additionally, we're thankful that they're getting bigger because in this original carbon plan, we didn't have near the load growth we have now. So this larger size that wasn't available as our generic model back then, that is today, gives us some extra megawatts. So in addition to replacing, the amount of coal that's being retired, we're going to get 260 to 300 megawatts of extra generation out of these progressions in both size and efficiency of these units. And so I think it's just a matter of, again, the lag in planning versus the marketplace. The marketplace is moving forward. Planning happens, these proceedings take 12 to 18 months, but the inputs go in 6 months to a year in front of that. So when we move to execution, I would say that as these units get bigger, more efficient, we just recognize the fact that it's natural for us to include that at the execution phase and not let the procedural nature say, no, let's use an older version that's less efficient simply because 1,200 was selected in that. The need is bigger now in this carbon plan. And again, I think, it was brought up by Mr. Neal, I believe, that you said that in this order, that would be one indicia of need that would be considered in this, and when we were envisioning at that time, this very proceeding. So one part of the body of evidence would be the carbon plan. One part would be the recently filed CPIRP. And then you would have other evidence that came in through this proceeding that would all inform this commission. So I would just say that there was this is simply an evolution of the technology from back then to today, and that it makes, really good economic and physics, sense to avail ourselves as we now see the higher load growth in the state, the ability to get a unit that's larger and has higher efficiency. We're talking 6,300 or maybe even a little better full load heat rate. Just to put that in perspective, Witness Verderami talked about yesterday's gas, or a couple of days last week, $1.80 gas. $1.80 delivered gas run through this unit would produce $12 energy for for our customers. That is a tremendous and very, and he said 50% carbon reduction. That's the existing fleet. This unit has greater than 60% reduction in carbon relative to a coal unit. So, in that situation, I'm producing energy on par with the cost of nuclear energy and at 60% reduction in the carbon output from the coal plant it's replacing. So these evolution of these advanced frame turbines to this highly efficient, much larger units than we've seen a decade ago, and even that we saw 2 years ago in the IRP, has really been a good thing for the customers that we serve.
Thank you.
All right, Mr. Schneider, just very, I want to ask you 2 questions. One, load valleys. If I say load valley to you, do you know what I'm talking about?
I
Or
do.
does that make sense to you?
It
Okay.
does.
In the work that you do with the modeling team, is there more attention being paid to load valleys than there has in the past, particularly load valleys in the winter time?
Yes.
And can you explain how and why?
Yeah, so I think in the reliability panel and the operations panel, you heard a lot of discussion on net load peaks. So some days you've got a lot of solar, some days you might not, and the ramp rates are going to vary day to day. And when I say ramp rates, it's the shape of that, since we don't have that in front of us from that IRP. But if you remember the duck curve we discussed in the summer, or the valley that you're discussing in the winter, it can be very steep or it can be very shallow. So on a really, really cold day where it's cloudy out, I don't see big dips in the middle of the day. On mild, clear blue days where I don't have a lot of heating and cooling load and I've got a lot of solar coming on in the morning and then off at night, I see the system needing to ramp down and ramp up dramatically. And then you get this valley in the middle. So what all of that refers to is the ability to have flexible units on the system that can respond to both conditions. And so the all of the above provides a host of resources that can respond to that. These new units, for example, have much faster ramp rates, certainly than the coal. I mean, they're ramping hundreds of megawatts a minute, as opposed to 10 megawatts a minute or so with a coal unit. So the ability to ramp down and ramp up is tremendous benefit of these new units. The other thing is they have lower minimum loads. So these units can't run at 1 megawatt and 1360. There are minimum megawatts, and Witness Donishad and Witness Smith can give you exact ones. But if I recall, we're in the low hundreds of megawatts. So this can go from 1360 to 300 or 400 and then back to 1360 in a hurry, right? So it can respond to that winter morning peak. And then if the sun comes out and it turns out to be, cold in the morning, but gets a little mild in the day. And then when the sun goes down again, solar's gone early in the winter because we have short days, can get cold again in the evening. It can come right back up to serve that evening peak. So that flexibility to ramp out and ramp in and go down to a min load is really beneficial in these advanced class, that unit flexibility.
Okay, and I want to ask just one more follow-up question there. Of particular concern, just coming out of the work that was done to understand Winter Storm Elliott dynamics, including the load that the companies experienced and load that was seen sort of across the country, the overnight load. So we had the peak day, and then the overnight load following that peak condition. And I can't remember the date because I can't remember the specific date, but so the overnight load didn't drop as low as it as system operators anticipated, or as it typically would in a routine, cold storm during the winter. And in certain areas, and I don't remember if this was the case in either of the Duke service areas, but I know, for example, in PJM, they experienced the lowest load valley overnight that the system had ever experienced. And so my question is, a unit like this that you all are proposing to construct in this proceeding, does it give system operators the flexibility they need to respond to a dynamic like that, where they're looking at all the units that are providing service to the system, and then they see something strange happening with that load valley that they weren't anticipating? Can this unit step in and be there, or ramp up or ramp down, or whatever the case is going to be in that unanticipated moment when we need electrons?
Yes, Chair Mitchell, I think that's one of the benefits of the all of the above, right? And so we certainly see the need for batteries and DSM and EE. And so I didn't want to in any way leave the record where I think that's not important. But the unique aspect that a unit like this brings is precisely that. What I think what you were referring to is they actually saw higher mins than they've ever seen, right? So at night, the system load didn't drop enough. That becomes an issue if you're too reliant on batteries, because you're counting on leaving your units running, not to serve load, but so that you can charge the battery to then serve the morning peak. If the load doesn't drop, you need those units to serve the load. It can't go into the there's a limit to how much batteries, energy you have in those nights or during the daylight solar hours to charge the battery. And so where this complements batteries and renewables is it can run full out at the night if it needs to. We thought load was going to drop. We're going to ramp it down. It didn't drop. We're going to keep it running high. And it can ramp in and out in that evening peak, the morning peak, and the midday peak all in a row and respond to those system conditions in a manner that other units have some certain limitations on. So that's part of the all of the above and having a unit like this. And there are, again, I'll try not to overstep Mr. Donishad and Mr. Smith can tell you more about this, but it can even fire, have temporary periods when it fires above its 1360. And, when it's really cold out, you actually get extra megawatts out of the unit. The air is more dense. It goes into the turbine. You get higher output. So 1360 is sort of a expected weather peak. You may be able to push well above 1400 on a 10-degree day at Marshall and overfire so that you can actually get extra megawatts out of this unit when needed. So that level of flexibility to go above or below that 1360 very quickly and respond to those types of conditions is what makes this a great addition to the other resources in our near-term action plan.
Okay. All right. Thank you, Mr. Snyder. I have a question for you that I'd like for you to address when you come back on rebuttal. In your testimony today, you've focused on, or you've mentioned capacity resources and energy resources. And so when you come back, I'm hoping that you could just provide a brief explanation of what you mean by when you say capacity resource and when you say energy resource, so that we have a full understanding of your testimony.
I will endeavor to do so on rebuttal.
Okay. At this point, let me see, are there any other questions from commissioners? Are there questions on commissioners' questions? All right, Mr. Felling.
Tom Felling with the public staff. Mr. Snyder, there was a question from Commissioner Kimmerite turned into a larger discussion, but the question I think began with asking you about 1200 megawatts from the carbon plan order and the 1360 here. And kind of in that response, I heard you say, and if I don't have the figures correct, you can correct me, but it was something to the effect that $1.80 gas would yield $12 energy. Do you recall that question?
12, 13. If I were able to get $1.80 delivered gas to a 6,300 heat rate unit, I was trying to do the math in my head, and 1.8 times 6.3 is, I can do math, but not that well. So somewhere in the $13 range is what I was referring to.
Fair, and I'm not trying to hone in on that figure, and math on the stand, I couldn't do it. But that figure that you did quote, that price that you quote, would not be inclusive of transportation costs and fixed long O&M costs. Is that correct?
No, that's just the variable cost. And again, that's sort of the energy versus capacity. That's just my energy cost. You have the fixed cost to get the firm capacity.
Thanks for that clarification. No other questions.
Any other questions on commission questions? All right. Then at this point, Mr. Snyder, you may step down. We will see you again on your rebuttal testimony, and we will take our morning break. We're going to be quick. We'll take 10 minutes, and we will be off the record now.
sorry, just really briefly, I didn't identify this at the outset, but Mr. Snyder's testimony did identify that he was sponsoring exhibits from the application. So I believe Mr. Higginbotham has already moved those into the record, so I didn't identify them when Mr. Schneider came up to the stand. So just confirming for the record, those have already been entered into the record, nothing else to be done there.
All right, and Mr. Brashworth, just so that we're all on the same page, when you all call your witnesses going forward, make sure for those witnesses that are sponsoring exhibits to the application, just remind everybody which exhibits those are so that we can be sure to ask those witnesses our questions.
Will do.
And Mr. Neal, you want to go ahead and make your motion?
Yes, please. Thank you, Chair Mitchell. David Neal for Sace et al. We would move into the records Sace et al. Cross exhibits 1, 2, and 3, recognizing that 2 was designated confidential by the companies.
Mr. Neal, was your motion? Yeah, 1, 2, and 3. All right. Having heard no objection, your motion will be allowed. All right, well, let's go off the record now, and we'll be back on at 10 after 11. You all may call your next witness.
Thank you, Chair Mitchell. Duke Energy Progress calls Mr. Daniel Donashad to the stand.
Good morning, Mr. Donashad. Let's get you sworn in, please, sir.
Good morning.
Raise your right hand. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Mr. Donashad, would you please state your full name and business address for the record?
My name is Daniel Donashad. Business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy as the General Manager of Generation Execution and Technologies.
Will you please briefly describe your role and responsibilities at Duke Energy?
Yes, I lead a team that helps prepare the generation fleet transition strategy and coordinates the execution of the generation transition.
Mr. Donashad, did you cause to be pre-filed in this docket direct testimony consisting of 18 pages?
Yes, I did.
And do you have any changes to your direct testimony at this time?
No, I do not.
If I were to ask you the same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Your direct testimony does not include any confidential information, correct?
That's correct.
And did you pre-file a summary of your direct testimony for the commission?
Yes.
And per Chair Mitchell's request, you are not sponsoring any exhibits to the CPCN application in your direct testimony, correct?
That's correct. I'm not.
Chair Mitchell, I would ask that Mr. Donashad's direct testimony be entered into the record as if given orally from the stand, as well as the summary of his direct testimony.
All right, the direct testimony of DEP witness Donashad filed in the docket on March 28th, 2024, consisting of 18 pages, shall be copied into the record as if delivered orally from the stand. And the summary of that testimony will be copied into the record as well.
Thank you. Mr. Donashad is now available for questions from the parties and the commission on his direct testimony.
All right, EDF, you're up.
Good morning. Ben Smith for the Environmental Defense Fund. Mr. Donashad, could you please turn to page 5 of your direct testimony?
Page 5, yes.
Yep. And I'm going to read something beginning at line 4, and can you just confirm that I'm reading it right? More specifically, my testimony will focus on how the proposed facility supports the company's Carolinas energy transition strategy presented in the CPIRP and aligns with the least cost path to achieve compliance with the carbon reduction mandates in NCGS section 62-110.9. Did I read that right?
Yes.
And I want to focus just a little bit on the last portion regarding that least cost path to compliance with the carbon reduction mandates. Is that generally referring to the 70% reduction in carbon emissions by 2030 and carbon neutrality by 2050?
Yes, that's talking about the planning that witness Snyder talked about.
Thank you. Could you please turn to page 11 of direct testimony?
I'm there.
And I'm going to read again, beginning at line 18. The proposed facility will also reduce carbon dioxide emission rates per megawatt hour by approximately 60% and provide approximately 33% improved efficiency at full load compared to the retiring coal units. Did I read that right?
You did.
And I just want to clarify, just make sure I have this right. The statement reduce carbon dioxide per megawatt hour by approximately 60%. That's comparing the proposed Roxboro combined cycle against the retiring Roxboro coal units, correct?
That's correct. Yes.
And the emission numbers that you're using there, are those from the same source the company used in the CPIRP, the benchmarking source for the generating resources, as you recall?
I don't recall exactly what source we had used, what year or anything like that, but it's generally right.
Okay. But the numbers are likely from some sort of generic resource or not specific to that Roxboro unit.
I think they are specific to Roxboro 1 and 4.
Roxboro coal, but couldn't be specific to the combined cycle that's not yet built though, right?
Right, and then with the combined cycle, it would be our generic combined cycle, which is proposed here in the CPCN.
And if you, and I know you're here for the CPIRP portion of things, and what I'm looking at is how to validate some of the emissions numbers. So how does DEP intend to validate the emissions numbers in its operation of this proposed Roxborough combined cycle unit?
Well, I mean, obviously, all the vendors they have their, their emissions rates that are proposed. So Witness Smith can talk about that, about what they're going to be doing. I mean, if you just look at the heat rate, like Witness Snyder talked about, I mean, the heat rate of the Roxborough units is probably 9,500 to 10,000 BTUs per kWh, whereas the combined cycle is 6,300, 6,600, something like that. So just looking at the difference in the heat rates, that it's going to be much more efficient.
Understood. And talking specifically to the validations of the emissions numbers here, operation under CAA Rule 111 and other operational considerations may affect the actual emissions that come out of the proposed Roxborough combined cycle. Isn't that right?
So, right. I mean, we talked about in the past hearing, so that the Clean Air Act 111, if it continues to be in effect, for this facility, we would be, taking capacity factors, limiting them to 40% after 2032. So that would have impact on the total emissions during the year.
In theory, it could be lower than what a generic number might be that you all are relying upon, right?
Yeah, like in the modeling, like Witness Snyder talked about, you're probably looking at a 80-85% capacity factor. So if you're running obviously at a 40% capacity factor, you'll have less emissions.
So wouldn't it be prudent to seek to quantify the actual emissions data from the emitting plant to inform the company's greater emissions data?
I'm not involved with the permitting of the air permit, but I'm sure that they had to do modeling associated with that. And I'm sure that has the emissions, projected emissions in that application.
Understood. And the reason I'm asking you is because, as you testified, you're helping to follow through with compliance requirements under HB 951. And one of the requirements are for offsets to be verifiable. Are you familiar with that?
Not very familiar with that.
Okay, so subject to check, the statute requires that the companies not exceed 5% of carbon emissions reduction requirements via offsets. Does that sound right?
That sounds right. Yeah.
So subject to check, the companies must verify that the offsets it uses in complying with HB 951 do not actually exceed 5% of their in-state generation resource output. Isn't that right?
And we're talking about for 2050, right?
Yes, sir.
Yeah, that's fine. I understand.
I'm just going to object to the extent that it's calling for interpretation of the statute, potential legal conclusions.
All right, I'm going to overrule the objection. We recognize the attorney that the witness is not an attorney. He can respond to the questions to the best of his ability. We'll give his responses and his testimony the weight that it's due.
And I think I heard your answer there, but subject to check, you all would have to verify under HB 951 for any future offset use in 2050. Isn't that right?
It's subject to check, yes.
So wouldn't it follow that DEP should be tracking emission numbers for the Roxborough combined cycle plant going forward so that you can verify in 2050 during the useful life of this Roxborough plant?
I mean, all the emissions will be tracked as part of our normal process. Yes, I mean, we're always doing that, and then obviously we have to comply with permits, and the Clean Air Act 111 is still around. We have to comply with that too. So yes, emissions would certainly be tracked. They always have been. They will be.
Thank you. All right. Could you turn to page 18 of direct testimony?
That's my last page, I believe.
Sure, I have that right page. Yes, beginning at line 2. And I'm going to read this and you can confirm that I've read it correctly. Since the EPA proposed rule allows for CCS as a potential best system of emissions reduction technology for CAA Section 111, DEP has retained a consulting firm specializing in permanent subsurface sequestration to screen the Carolinas for CCS potential. Did I read that right?
Yes, for some reason, my page numbers are different than yours, but I did find a minus on page 17, and that was line 16. But yes, that's correct. That's what it says.
I apologize if I have the numbers off, but that's part of your testimony as you recall.
Yes.
Okay, and I'm not going to quote anything else, so hopefully we won't have any more page number issues. The CCS in that quote is, could you define that acronym?
Yeah, carbon capture and sequestration.
Okay, and last question is, I just want to know what the outcomes have been so far from the consulting firm specializing in permanent subsurface sequestration.
Well, that work is on attorney-client privilege work, and it's underway, so we don't even have any results from it yet. We're in kind of phase 1 of that, so it's relatively new work.
Without getting into the attorney-client privilege portions of it, do you expect this to inform the next CPIRP filing?
We will definitely touch on sequestration in the August 25 filing. Remains to be seen how deep we'll go into it, but we'll certainly would want to bring forth to the commission any new information from that study.
No further questions.
All right, Mr. Summers.
Thank you, Chair Mitchell. Good morning, Mr. Donishad. How are you?
Good. Good morning, Mr. Summers.
Good. I'm representing, again, Bo Summers. I'm representing Person County. In your pre-filed direct testimony, you speak at length about the company's partnership with Person County, about not only this proposed new facility, but the historical Roxborough and Mayo facilities. Is that correct?
That's correct.
And in fact, since the 1960s, Duke Energy has been a critical community and civic supporter of Person County. Is that correct?
That's correct. We enjoy a very good relationship with Person County.
And in your testimony, you discuss a number of stakeholder meetings and other support that the county has evidenced for this project, including a resolution that was passed by the County Board of Commissioners in February of this year, supporting not only this Roxborough combined cycle unit, but hopefully a future combined cycle unit at the to-be-retired Roxborough site. Is that correct?
That's correct.
Are you aware that Mr. Gordon Powell, the chairman of the Person County Board of Commissioners, also testified at the public hearing that this commission held in Roxborough in support of the project?
Yes.
And are you also aware that Ms. Catherine Cathy, the county manager of Person County, also testified at the public hearing supporting this project?
Yes.
And are you generally aware that based on their testimony, Duke Energy's plants in the county represent approximately 20% of the county's entire tax base?
That number sounds correct.
And I believe my presence here today further indicates the county's support for this project, does it not?
I believe so.
On behalf of the county, we thank you very much.
Thank you.
All right, Sace.
Thank you, Chair Mitchell. David Neal for SACE et al. Good morning, Mr. Donishad.
Good morning, Mr. Neal.
In your direct testimony, you discuss the benefits of using the existing Roxborough site for the proposed facility, correct?
I do.
You note that DEP can utilize the generator replacement request process, which allows the utility to use the existing transmission rights at this site. Correct?
Yes.
And you can also leverage existing land and security at this site?
Yes.
And at page 15, you testified that Roxborough coal units sit on 3,000 acres of Duke-owned land. And
Yes, I do. That 3,000 doesn't include the water bodies, but yeah. Yes.
so you would agree that Duke owns more than 3,000 acres of land in Person County?
That's correct.
Now, you would agree that the site benefits that we just discussed, making use of existing transmission rights, the available land and security, those are not in and of themselves specific to gas generation, correct?
Right. That's correct.
So that existing transmission could be used for installing other kinds of generation as well.
It could be.
And new solar and storage resources could be built on Duke-owned property at that site, correct?
There is a moratorium, I understand, in Person County that no more than 100 acres of solar can be built.
We'll get to that in a little bit, but you would agree that even under that moratorium, or not moratorium, under that solar ordinance, solar could be built at that site.
Yes, you could do that.
And are you aware that siting renewable resources on the site of a retiring fossil plant, such as Roxbury Units 1 and 4, qualifies projects for additional energy community bonus tax credits under the Inflation Reduction Act.
Yes, I am aware of that.
And that the federal government offers low-cost financing for carbon-free replacement resources through the Energy Infrastructure Reinvestment Program.
Not as familiar with that, but something to check on.
And has Duke investigated installing solar or solar plus storage or battery storage, standalone storage on Duke-owned land at the site that could take advantage of those transmission interconnections?
We have, and like I said, we looked into the solar. There was a limit of 100 acres, and I'm not sure if that's still intact or not. I'm assuming it is, but it was a 100-acre limitation of solar. So if you take 7 acres per megawatt, that's not a whole lot of megawatts. And frankly, for the 1360 megawatts that we're proposing, if you did 7.5 acres a megawatt, you need 10,000 acres to come up with the same equivalent megawatts that our combined cycle is going to have. So, we're not talking about Mayo today necessarily, but we are looking at storage at Mayo and having Indicis own storage at Mayo. So, we recognize the value of the generator replacement request process, and so we want to leverage those interconnection rights as much as possible.
Well, I'm glad you mentioned the solar ordinance. You in your exchange with Mr. Summers talked about the collaborative partnership that Duke Energy has had with the residents and officials in Person County, correct?
Correct.
And and that good relationship has extended to, again, in the conversation you just had with Mr. Summers, the county commissions in Person County interest in replacement generation for retiring Roxbury units, correct?
Yes, the county is very interested in having replacement generation at the site.
And in the context of your conversations with officials in Person County, have you discussed the previous moratorium that stopped consideration of any utility scale solar projects in the county back in 2021?
I personally have not.
And given the volumes of solar that Duke Energy Progress and Duke Energy Carolinas are planning to procure as part of carbon plan compliance, do you know whether any Duke Energy Progress staff have discussed how the 2022 solar ordinance adopted by Person County might inhibit the execution of Duke's plans for developing solar in Person County?
I mean, I've not been involved with those conversations. I'm sure there probably have been conversations around that topic generally.
Well, going forward, would Duke consider using its collaborative partnership with Person County officials to work with the county to better allow private landowners to lease their property for additional utility scale solar in the county that would maybe facilitate compliance with carbon plan?
I mean,
I do think we're getting a little bit beyond the scope of Mr. Donishad's testimony, this line of questioning, so I am going to object.
Mr. Donishad testified about the collaborative relationship that Duke Energy has with the county extensively, had same exchange with representative from Person County, and this is relevant to the generation replacement resources that could be considered at Roxbury.
All right, I'm going to overrule the objection. Mr. Neal, Mr. Donishad, answer the question, and then Mr. Neal, try to move quickly through your questions.
Let's do it again, please.
Would Duke Energy consider using that collaborative partnership that we've been discussing with Person County officials to work with the county to modify their current solar siting ordinance to allow for additional solar to be sited in the county?
I mean, I don't know. I feel like you're wanting me to make a commitment on behalf of the company that I don't think I'm really authorized to make. I will say that, you have to look at, it's not just land area, but it's kind of, the topography plays into things as well. So, we do need a lot of solar. We need a lot of solar, and we're doing a lot of solar in our plan. A lot of solar, a lot of storage, all of the resources, that we talked about. So we're going to need a lot of solar, and we have a regulated renewable development team that scouts out properties and gets the best land for executable solar projects. So that's all I can say on that.
So turning your attention to compliance with the 111 rules that you discussed in your testimony, one of the options you're pursuing related to this facility is exploring potential operation using hydrogen, should that fuel become available. Do you recall that testimony?
I mean, we talk about hydrogen provisions to be made, and at the time of my direct testimony, we only had the proposed 111 rule and not the final. So the hydrogen was a compliance method in the proposed rule, but then that was removed as a compliance as a BSER, best system of emission reduction, on the final rule.
It's still a compliance option under the final rule.
It is. It is an allowable compliance option on the final rule.
And the company doesn't have concrete plans to convert the Roxborough CC that's the subject of this CPCN to run on 100% hydrogen at this point, correct?
Not at this point, I would say. In the modeling, though, we have those conversion costs in there. So in the long-term modeling that Witness Snyder and Witness Beatty will talk about in rebuttal, they do include the cost for those future conversions.
And the company doesn't have specific plans to install carbon capture and sequestration at this site at this time, correct?
No, when we and Witness Smith can talk about it, but in the layout of the kind of the plan view of the site, we do have an area allocated for potential carbon capture of this site. If we wanted to do that in the future, not necessarily sequestration, but we do have some space allocated for carbon capture.
Well, you would agree that for the foreseeable future, this plant will run on gas, correct?
The plant will run on gas. It has backup ultra low sulfur diesel fuel as well. And then our plan is, as we go down the road, is to incorporate hydrogen as it becomes available.
Thank you. No further questions.
All right, public staff.
Thank you, Mr. Donshad. Good morning. I'd like to discuss with you some of the siting conversations that I think this might be a bit of a retread from yesterday, but the location and the plan around where to put this CC. And I think that you would agree with me that a CC takes a little bit longer than a CT start to finish.
It's and Witness Smith can talk about it, but it's about 1 year more of construction.
And what we're aiming for here is for a CC to go into the system by the end of 2028.
That's correct.
And so, and I think we talked yesterday about greenfield, and when I would define greenfield as undeveloped land without existing plant infrastructure. Is that a good definition?
Yes, I would say so.
So I think that you testified that greenfield adds even more time onto this lengthy time it takes to build a CC. Is that what I understood?
Yes. Yeah. You're looking about 1 to 2 years for due diligence for a greenfield site in addition to the construction.
And I heard Mr. Snyder say just a few minutes ago, hey, in 2020, our IRP identified the need for a CC in DEP. And in fact, I think even the 2019 IRP identified the need for a CC in DEP. Am I remembering correctly?
That is correct.
So help me understand why, and here we need this plan at the end of 2028. Why were greenfields not evaluated at all?
I don't agree that they weren't.
When I read your testimony, I read it to say, we didn't evaluate greenfields because it would take too long.
Right.
So, sorry, could you just point to that specific reference, Council?
I would look at page 14, lines 9 to 13. I'd also look at the application, Exhibit 2, page 13 of 297.
Right. No, I was, you were talking about 2020 and 2019. So earlier back then, and I don't have the time exactly right, but we were looking at the Cumberland site, which was a greenfield site to be served by Atlantic Coast Pipeline. So that was a greenfield site. When that project went away, you still have the needs in DEP. And so that's when, in 2020, you've got a combined cycle in DEP for 28 and one for 29. And at that same year, the DEC IRP had no CCs at that timeline. So when we look at retirement of these coal units, optimized retirement, when you look at the coal units and you're going to retire these, it makes total logical sense to replace the generation right there on site, because you have a whole transmission system that was built decades ago around these assets being there, generation being there. And so when you think about, replace before retire and wanting to retire two coal units to help the energy transition at Roxborough, it makes complete sense to locate the generation there to minimize costs for customers, because I don't have to backfill the transmission, right? I'm bringing generation in, I'm supporting the growing Wake County area, and we can just reuse that existing transmission and eliminate further projects. So I think that's some of the very large value in replacing there. So when you look at Greenfield, my Greenfield can't do that, right? My Greenfield, if I go anywhere else, then I've got to do projects to backfill the transmission there at Person County and in the system. So, and Witness Roberts can cover that on rebuttal as well. So I don't need to look at a Greenfield because I have this retiring coal. If I didn't have retiring coal, then I think things are different, right? From a growth CC, things are different, right? In our CC3, which is going to be in South Carolina, we are looking at a Greenfield site. Okay.
Well, that just raises two things I'd like to discuss with you, if you don't mind. First, I read the application in your testimony to say we didn't evaluate Greenfield because we didn't have time, not because it was a poor choice. So help me understand.
Well, I mean, you're looking at replacing at the end of 28, right? So, as we're working through the plans, I mean, it takes 6 years to build a combined cycle. So, if I'm looking at the timeline, and I'm not gaining anything by going to look at a Greenfield, because I need to replace this generation to allow it to retire. So
I guess it's tough for me to compare this to a Greenfield because I don't know how you go back in time and get permitting, land, how long the pipeline had to be, all of those options. So it's tough for me to audit and say, this is the best choice, because I don't think that work was done. And so help me understand.
Sorry, is there a question?
Yes, please. If you just help me understand did we take the easiest route or did we take the least cost route?
I think when you look at wanting to perform the energy transition, right? You want to get out of the coal units and get it retired, and we're going to keep the system reliable. We have to keep the system reliable. And so if I'm looking at, okay, I've got a model from Glenn's team, Witness Snyder's team, that has combined cycles in DEP at the time frame that was needed. I've got retirements of Roxborough in the time frame needed, right? I've got alignment on those. I've got generator replacement requests. I can use the transmission for ROX 1 and 4 for this new combined cycle. I've got water supply. Witness Mitchell will talk about the gas supply to the site. I've also got a very engaged workforce that wants to continue working with Duke Energy. We've got the Person County community support, right? And the supporting of the tax base and jobs. We've got the existing permits that we can reuse. So we don't have to go and get new permits, just modify the existing permits. We've got access to rail where we can bring transformers and turbines on. And then we talked about the greater Wake County system voltage support. So you put all those together, this is an elegant solution. This is a good solution for the customers. This is the best site for meeting that DEP combined cycle need.
Thank you. If I can have one moment. Just one final thought on this topic is, I hear all these statements, but I don't have an audit or I don't have a comparison that I can audit and compare and quantify in dollars. And I guess that doesn't exist. Is that right?
I'm just going to object. I think this is beyond the scope of his testimony.
I think a valuation of the Greenfield is, he talks about Greenfield in his direct. I think this is within the scope.
All right, I'm going to overrule. You can answer the question, Mr. Donashad.
Please again.
Yeah, I apologize. We're talking about I heard everything you said and I understand that, but there's no dollars where I can say, this is the cost of Roxborough at Brownfield. This is the cost of a CC in other parts of the state. There's
Right.
no way for the public staff to audit that, right?
I mean, certainly you guys have issued a lot of data requests, in that light. I don't know. I think you just, when you just look at all of the benefits, it's almost common sense that Roxborough is the best location. And as we work, and you can't really have all the dollars because they don't all exist, right? The DICES process is a long process, right? We're still getting cost estimates for DICES from the 23 DICES, but I will say that the transmission cost for the additional 313 megawatts is like $12.7 million, right? So it's a good value from the transmission standpoint. The gas asset, wherever it's located, is going to be the same cost. And Witness Mitchell can talk about the great deal he's got on the gas supply. So I think this is, you know, in our opinion, this is the best site, and so we stand by that.
One more minute, Commissioner. Thank you very much. I appreciate the indulgence. I don't have any more questions.
All right, redirect.
Thank you. Mr. Donashad. In general, would you classify solar generation as a dispatchable generation resource?
I would not.
And Council for SACE asked you about potentially citing solar or solar plus storage in Person County in lieu of the proposed facility, correct?
Yes.
Is it correct to say that there's a need for dispatchable generation in Person County to replace the retiring coal units?
Absolutely.
Would citing solar or solar plus storage at Roxborough accomplish the need to replace the retiring coal units with dispatchable generation?
It would not.
You were also asked about the company's concrete plans to run the plant on hydrogen fuel supply. Do you recall those questions?
Yes.
Would you agree that in the CPIRP, Duke Energy is committed to continue exploring the availability of hydrogen as a fuel source?
Yes, I would.
And the companies will provide updates around its assumptions regarding hydrogen as a fuel source in future CPIRPs?
Yes.
And is it correct to say the companies have agreed to work with the public staff on a hydrogen pilot, the results of which will be provided prior to or in the next CPRP filing?
Yes, as part of the settlement.
You were also asked some questions about CCS. It's fair to say the companies are committed to exploring CCS in the Carolinas,
We are exploring it.
and the companies will provide updates to the commission on the viability of CCS based on its efforts, correct?
Yes.
Is it fair to say that in general, constructing a new generation facility at a brownfield site with existing transmission infrastructure and existing fuel supply and other existing assets will create greater efficiencies than constructing a facility at a greenfield site?
Certainly.
And in your opinion, is it consistent with prudent utility practice to identify efficiencies that can be achieved in the site selection process?
Yes.
No further questions.
All right, Mr. Donashad, let me see if there are questions from commissioners for you. Commissioner McKissick, go ahead.
It's just one question, sir, and goes back when I was reviewing your testimony originally. It's one of the corners that I turned back, and it relates to statement made on page 15. And it addresses the need to proceed with this project because it states that, and I'm looking at lines like 9 through 13 there, that there are system voltage problems in this particular service area. I guess it's referring to the northern portion of DEP's service territory. What kind of system voltage problems exist today that are of a magnitude that, this particular project would provide, benefits? Obviously, it talks about it being existing problem, but it only talks about, and it also talks about the problem being exacerbated when the pole units are retired. But could you speak to this voltage problem that exists and the magnitude of that problem?
It's a great question, Commissioner McKissick. Witness Roberts will be able to handle that in rebuttal in great detail.
All right, thank you. I'll wait till that time.
All right, Mr. Donashad, I don't think I have much for you. I do want to follow up with you on questions you were asked, both on cross and redirect about solar at solar generation in general. The company's agreed to work with the public staff and study the use of interconnection capacity for the siting of certain resources, and I think solar is included among those resources. And that was that agreement is set forth in the settlement agreement that's been filed in the CPIRP proceeding. Are you aware of that settlement agreement?
Yes.
And I understand all of the testimony given today that there's a moratorium on solar development in Person County, and that there are siting constraints at the Roxborough site that would bear on siting solar generation there. But based on what you know about the Roxborough site, is the Roxborough site one such location where the companies might be able to consider siting solar there, or proximate to the Roxborough site as it works with the public staff on this issue?
It could be a potential site. I don't recall when our regulated renewable developer guys, when they looked at it, what they had said about it. Mayo might be better. I know we're looking at storage options for Mayo. It's 15 miles further for gas, and so that's why we're thinking more of some other generation there. But we got 710 megawatts of interconnection rights that we want to be able to leverage when that retires in 31. So, I mean, there's opportunities.
And when you say that retires, you mean Mayo?
When Mayo retires,
Right.
yes.
Okay. All right. So what I'm hearing you say is the potential exists to examine the interconnection capacity for solar generation in this area as you all move forward with your plans to retire and replace.
Yes.
Okay. All right. Let's see. I think that's all I have. Any other questions from commissioners? All right, Mr. Donashad, you may step down. Thank you very much.
Thank you.
Chair Mitchell, if I could just briefly have a question on commission questions, or?
Oh, I'm sorry. I forgot question. I apologize. Yes, let's see if there are questions on commissioners' questions, and we'll start on this side of the room. Public staff, do y'all have any?
No questions.
Okay. Go ahead.
Just briefly, on Chair Mitchell's question about the potential of siting solar plus storage at the facility, Chair Mitchell mentioned the moratorium, and I also mentioned that. Just to be clear, is it your understanding the moratorium ended at some point in 2021 or 2022?
It's been a while since I looked at it. If it has, I'd be surprised that it ended that. You're saying that's when it ended?
That's my understanding, and I guess maybe one way to approach this would be if the chair would take judicial notice of Person County Solar Energy System Ordinance amended on the 7th day of February 2022, which I believe is what superseded the moratorium as an updated solar siting ordinance.
Oh, ordinance, okay.
All right, the commission will take judicial notice of the Person County ordinance, assuming you've appropriately identified it so that we can actually find it. And I've heard no objection to the commission's doing that. All right, Mr. Neal, is that all from you?
That was all. Thank you.
Okay. Duke, any questions on commissioners?
No questions. Thank you.
Okay. All right, Mr. Donashad, you may step down, but you are not excused quite yet.
Thank you.
Okay, Duke, you can call your next witness, please.
Chair Mitchell, Duke Energy calls DEP witness H. Lee Mitchell IV to the stand.
You come from a long line of Lee Mitchells.
I'm aware.
All right, Mr. Mitchell, if you would, raise your right hand, left hand on the Bible. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay.
Thank you, Chair Mitchell. Mr. Mitchell, would you please state your full name and business address for the record?
My name is Lee Mitchell. My business address is 525 South Trowland Street, Charlotte, North Carolina, 28202.
All right, and by whom are you employed and in what capacity?
Duke Energy is the Director of Fuel Strategy and Planning.
And can you please briefly describe your role and responsibilities at Duke Energy?
Of course, my responsibilities generally include directing enterprise fuel strategy for all regulated Duke Energy electric utility subsidiaries, and specifically supporting Duke Energy's transition away from coal to cleaner burning fuels such as natural gas and other developing alternatives. This includes the management of long-term fuel planning, implementation of fuel-related initiatives, and leading the execution of strategic transactions to improve fuel security and supply to reliably and affordably serve Duke Energy's customers.
All right, and are you the same H. Lee Mitchell that caused to be pre-filed on March 28th, 2024 in this docket, direct testimony consisting of 16 pages?
Yes, sir.
And was that testimony prepared by you or at your direction?
Yes, sir.
Do you have any changes to your direct testimony at this time?
No, sir.
And if I were to ask you the same questions today that appear in your pre-filed direct testimony, would the answers be the same?
Yes, sir.
And portions of your direct testimony included confidential information, is that correct?
Correct.
And did you also pre-file a summary of your direct testimony for the commission?
Yes, sir.
And just to be clear, you are not sponsoring any exhibits to the application, correct?
No, sir.
All right, Chair Mitchell, at this time, I would move that Mr. Mitchell's direct testimony be entered into the record as if given orally from the stand, as well as a summary of his direct testimony, and that his testimony be marked as confidential.
All right, the direct testimony of DEP witness Mitchell filed in the docket on March 28th, 2024, consisting of 16 pages, will be copied into the record as if delivered orally from the stand. The confidential portions of that testimony shall be so marked in the transcript. The summary of the testimony will be copied into the record as if given orally from the stand as well.
Thank you, Chair Mitchell. Mr. Mitchell is now available for questions from the parties and the commissions on his pre-filed direct testimony.
All right, EDF.
Thank you. Ben Smith from Environmental Defense Fund. Mr. Mitchell, can you turn to page 3, line 16 of your testimony, direct testimony?
Yes.
And in that you say the purpose of your testimony is to provide the commission an overview of DEP's strategy and executable plan to fuel the estimated 1,360 megawatt combined cycle gas turbine facility, the proposed facility that DEP proposes to construct at the site of the existing Roxborough plant, Roxborough in Person County, North Carolina. Did I read that right?
Yes.
I'm going to ask you some questions specific about strategy and executable plan to fuel the estimated 1,360 megawatt facility. And realizing you're not an attorney, and it might seem like what I'm asking you is that going off of your knowledge and some of the challenges. Are you aware of the recent decision by the DC Court of Appeals to overturn a FERC ruling allowing the build of an additional Transco natural gas pipeline in the New Jersey Conservation Foundation versus FERC?
Yes. Are you specifically talking about REA?
I believe so. It was I think.
Regional Energy Access.
Yes.
Expansion. Yes, I'm somewhat aware.
And are you generally aware that part of the basis for the DC Court of Appeals to overturn that decision was based upon New Jersey state emissions requirements?
Yeah, but to be clear, that's for local distribution companies, not for power generation. So your reference is very apples and oranges.
Sure. And I guess I'm not really specifically talking about apples and oranges to this case versus that case, and I'll get to what I'm asking here. Are you also aware that just 2 days ago, the DC Court of Appeals overturned a FERC permitting approval for LNG trains and pipeline infrastructure in the next decade Rio Grande project?
Yes, I'm aware, but again, not sure how LNG exports have anything to do with power generation.
Fair enough. I guess what I'm getting to is, can you comment how Duke Energy is informing the natural gas pipeline build process contemplated to bring fuel to the Roxborough CCs? And specifically, what steps are the companies taking to inform FERC processes of state emissions reduction requirements so that you're not susceptible to being overturned on appeal?
Sure, it's a great question. And, I think GHG emissions and need are front and center of any FERC docket right now. And when you look at the projects we did, we worked with our counterparties at Mount Valley Pipeline and Transco with that in mind. And when you specifically look at what we're trying to accomplish, both in the greater CPRP, which again, these interstate projects we refer to, they're not just for Person County, they're for the entire fuel security of the fleet. When we look at that, the whole crux of GHG emissions is to decrease. I think we've had multiple witnesses talk about reducing 50, even 60% with these new turbines, the GHG emissions. So yes, from a GHG perspective, we're reducing that amount. I believe there are other FERC dockets with power generators that have shown that. And then from a need perspective, as we show in the CPRP, again, this is for the CPCN, we have contracted needs for 3 CCs. We still have to do more. So from a need perspective, I feel very strongly, and so do our providers of pipeline services, that we have a very strong need case.
And I don't know that I'm getting to the need point, but your point's taken. I think what I'm more speaking to is the risk of relying upon a FERC approval for something that might require transparency as to the emissions reductions taken in North Carolina. So do you understand my question to be, what is Duke doing to inform the FERC overview of the North Carolina emissions reductions?
Well, I'd say a few things. I think Witness Snyder talks about the risk of all the assets in this plan, multiple risk across each class of generating assets. Additionally, gas is not the only FERC, CPCN or FERC need certificate you're going to need for executing this plan. But specifically to constructing that FERC certificate, I think it's important to note Duke is not the one submitting that FERC certificate. It's Williams, the pipeline provider for SSC. It's Mountain Valley Pipeline, the provider for Southgate. So it's not Duke doing that. And it's not only our case for need and our reduction of GHG, there's other utilities in the Southeast that are doing the same thing.
Of course, and no dispute there. I think all the utilities should be reporting their emissions reductions required by applicable laws to stop any sort of processes. But I guess what I'm asking is, wouldn't you agree it would be the best interests of DEP and the companies generally to provide information to, for instance, Williams and their application regarding ongoing emissions reductions, including the ongoing trajectory of the company's emissions reductions?
Yeah, I think just talking high level, yes. We are executing these agreements to help retire coal to lower emissions. And, trying to stay out of confidential information here, but, generally speaking, when you execute a firm transportation agreement, that's for 20 years. So let's just say hypothetically a pipeline was to go into service 2027, 2028. That's even before 2050. So one could argue HB 951 rules aren't even applicable to that because it's not even the primary term of such an agreement.
When is the Roxborough combined cycle scheduled to go into service?
I believe, subject to check, it's by end of year 2028.
And is it your understanding that the companies have a requirement to reduce emissions by 70% of their 2005 levels by 2030?
That is my understanding, and that's one of the reasons why this project we're here today is to help retire coal and lower emissions.
No further questions.
All right, Sace, you're up.
Good afternoon, Mr. Mitchell. Christina Tidwell, representing SACE et al.
Good morning. Or good afternoon, excuse me.
Currently, Duke has firm gas supply agreements for less than half of the peak demand of its existing gas fleet. Is that correct?
No, because you use the words gas supply. If you're referencing firm transportation rights on interstate pipelines per our testimony, then yes.
And the companies need additional interstate firm transportation capacity to support their existing combined cycle fleet. Is that correct?
Yes, to reliably retire coal, we need to acquire incremental interstate firm transportation capacity to ensure reliability.
And in order to burn gas at the proposed Roxborough facility, Duke will need even more additional firm transportation capacity. Is that right?
Yes, if we incrementally expand the system requirements of natural gas, we believe it's prudent to further enhance the fuel security of the fleet. And one way of doing that is expanding interstate firm transportation routes.
I believe that you state the Mountain Valley Pipeline has recently been placed into service. But in your direct testimony, page 7, lines 2 to 4, you state that additional expansions from the terminus of MVP will be required for its full benefit to be realized in the Carolinas. Do you see that?
Yes, I believe the time I did the direct testimony, MVP was not in service, which I think I updated at a later point. But yes, that is a correct statement from my testimony.
And those additional expansions that you're speaking about are the Transco Southeast Supply Enhancement Project and the MVP Southgate Project. Is that right?
Yes, per my testimony, that is correct.
And you state that DEC and DEP have contracted for firm transportation rights on both of those expansion projects. Is that right?
Technically, Duke Energy Carolinas contracted for those on behalf of the companies. We have an asset management agreement that the commission has approved and is familiar with, and that governs that optimization between the two companies.
You've contracted with, or the companies have contracted with the Public Service Company of North Carolina to redeliver gas from these two pipeline expansions to the proposed facility, correct?
Yes, and just to be clear, the company, as in Duke Energy Progress, at the CPCN here, yes, I know it can be confusing. DEP has contracted with PSNC, yes.
Okay, but you just stated a moment ago that DEC, Duke Energy Carolinas, had contracted with for the two pipeline expansions, right? I just want to make sure I'm clear.
Yes, again, for clarity, Duke Energy Carolinas is what we call the face to the market. So that way we can get customer efficiencies by bringing the total demand of both companies together when we go seek supply. So that's why from an interstate perspective, Duke Energy Carolinas contracts for that interstate. But when we allocate that on the back end, that's based off usage. So from a system need perspective, it's Duke Energy Carolinas representing the companies. But for a site-specific resource, such as the one we're here to talk about today, it's Duke Energy Progress contracting, since this is a Duke Energy Progress unit and CPCN proceeding.
The target in-service date of the Transco Southeast Supply Enhancement Project is by the end of 2027. Is that right?
That is their current expected date, correct?
And the in-service date for the proposed Roxborough facility is the end of 2028. Is that correct?
Best of my knowledge, that is the current expected time.
So the target in-service date for the Transco SSE project is about a year before the in-service date of the proposed facility, right?
From targeted dates, I would say that math is correct.
And the Southgate expansion has a targeted completion date of the middle of 2028?
Yes, that is their most recent expected in-service date.
So that's about 6 months before the in-service date of the Roxborough facility, correct?
Yes, that math makes sense.
And DEP is also relying on the completion of the T15 pipeline reliability project before it can operate the proposed plant, correct?
Yes, the T15 reliability project brings the natural gas from the interstate system to the plant, correct?
Would you agree that delays are not uncommon with new pipeline projects?
I think we have seen some delays in various pipeline projects in recent history, yes.
Like, for instance, the MVP was originally expected to be operational in 2018?
I think MVP is a greenfield interstate project that traversed federal land. So it's a little bit of, again, apples and oranges versus the projects that you just mentioned.
And it just began operating in June, right?
Again, it's apples and oranges, but yes, it began operating in June.
If these gas pipeline projects are delayed, past the targeted in-service date for the Roxborough facility, that would affect Duke's ability to operate this proposed facility, correct?
The T15, yes, the T15 project specifically needs to be in service to operate the Person County facility.
Mr. Mitchell, make sure you're hitting the mic for the court report.
For the interstate gas delivery to the proposed facility, you state that the Public Service Company of North Carolina was already planning on constructing additional pipeline facilities through Person County. Is that right?
Yes, that is correct.
But the PSNC has agreed to change the scope of the project to accommodate the proposed facility, correct?
Yes, I think it's an absolute great story. I believe I hit that in my testimony. I can't recall if it's my rebuttal or my direct, but yes, we worked with them to align the needs just like we did for the Asheville combined cycle. So that way we don't have to have two pipelines. We could have one where they incrementally grow the diameter of the pipeline to meet our need while at the same time meeting their retail customers' need.
And so they're going to increase the diameter of the pipeline that they plan to construct for approximately 37 miles, right?
That is correct.
And they're going to construct a new 9-mile lateral pipeline that goes to the east of Pico Lake to deliver gas to the plant.
Correct. They will do an incremental lateral and existing energy infrastructure corridor to the site.
And where this new pipeline is going to be constructed, there aren't any existing pipelines, are there?
To the comment I just made, there's no existing pipelines, but there's existing energy infrastructure in that corridor.
This new pipeline will not be capable of transporting hydrogen, correct?
Not necessarily. The initial agreement does not include hydrogen transportation, but Dominion actually came out. PSNC is currently a Dominion subsidiary. That may change here shortly, but they have a goal of allowing up to 5% in their LDC system by 2030. So that's their current planning assumption.
Okay, you said 5%?
Yes, ma'am. Okay. I believe so, subject to check. And I believe that that was in a data request as well. You may have even had that as an exhibit.
No further questions. Thank you.
All right, my notes indicate no additional cross-examination for the witness, just making sure that that is in fact the case. All right, redirect.
Yes, Chair Mitchell, thank you. So, Mr. Mitchell, do you recall the questions that EDF counsel was asking you regarding various pipelines and court rulings?
Yes, State's counsel, I believe.
I think this was.
Oh, yes, sorry.
EDF counsel.
Yes.
Thank you.
Apologies.
So notwithstanding his delving into the various whims of the judicial branch at any given time, what's the main point that you want this commission to understand about fuel supply to this facility?
Yes, I think at the end of the day here, why I'm up here is to show that we have contracted adequate fuel supply to have a reliable supply 365 days a year, both on an interstate and intrastate level, to show that this combined cycle is usable.
Thank you. And also, Mr. Mitchell, do you recall the question where counsel for SACE, Ms. Tidwell, asked you about firm transportation and MVP?
Yes, sir.
And do you recall the question where you responded about DEC being one face to the market for DEP?
Yes, sir.
About how long, if you know, has that arrangement been in place where DEC has been one face to the market for DEP in this regard?
Cannot recall the exact month or year, but after the merger, I know that was one way that they could find more value for the customer, was to have that one face to the market. So that was something that was quickly done and has been around for many years.
All right. And when you reference merger, you're referencing the merger between Duke Energy Corporation and Progress Energy, Inc., correct?
Yes, sir. Thank you for the clarification. And those are the two companies part of that asset management agreement.
And subject to check, would you agree that that merger occurred in 2012?
Yes, sir.
And is my understanding that based on what you just said, that one face to the market agreement was entered into shortly thereafter?
Yes, sir.
Okay. And do you also recall the question that Ms. Tidwell asked you regarding DEP's engagement with PSNC with respect to the T15 project?
Yes, sir.
Can you explain more, if you know, what you know about the level of collaboration between DEP and PSNC working together to bring gas to the proposed facility?
Absolutely. And that's one thing I'm proud to represent the companies. We have very strong working relationships with both the primary LDCs in North Carolina, both Piedmont and PSNC. And, you know, we already talked a little bit about Asheville combined cycle, and that was in my testimony. But I think it's just important to highlight the dialogue that we continuously have with these LDCs, not only for continuing operations of existing assets, but as we look for new assets. There was data requests given, and we showed that, you know, we also always didn't have an aligned need date with PSNC. We were looking at what's the cost, what's the considerations if we have to build a dedicated line to the Roxborough site, and those costs were higher. And we worked with PSNC, the stars aligned, we were able to do a joint project together and what we've contracted, and ultimately the customer is the beneficiary of that.
No further questions.
All right, Mr. Mitchell, let me see if there are questions from commissioners for you. All right, I don't see any questions. I want to ask you, just following up on T15, do you know where T15 interconnects, the interconnection point on Transco?
Yes, ma'am.
Can you tell me what that point of interconnection is?
Yes, so the technical interconnection with Transco is called Dan River number 2.
Okay.
But it is about approximately 3 miles southeast of the town of Eden in Rockingham County.
And that point of interconnection is a PSNC delivery point. Is that correct?
Yes, ma'am.
Okay. You reference an agreement between PSNC and DEP that was filed in docket G5 sub 668 in your testimony, and portions of that filing are confidential. So I don't want you to get into confidential information. If I ask you a question that leads you to a confidential response, tell me and we'll figure out another way to get to the information. But how much compression does the agreement between Duke and PSNC involve compression?
Yeah, so to your point, I don't want to get into too deep of confidential information, but I do think it is appropriate in a non-confidential session to say it is a one brownfield location that will provide the compression necessary to redeliver gas from the interstate pipeline infrastructure to the site. So it's just a singular brownfield location that will be inclusive of the compression.
A singular brownfield location for compressor station.
Correct.
Okay. And what, if anything, can you tell me about whether there's a pressure guarantee for PSNC at that point of interconnection on to Transco?
So I think the commission has seen historical pressure guarantees that PSNC may have. Cannot dive into to confidential information, but what I can say is.
Let me ask the question this way. I am aware of the pressure commitments that PSNC has with Transco. Has there been any additional developments post Winter Storm Elliott related to pressure guarantees, to your knowledge? And I recognize that you do not work for PSNC and that you are not in that company's business, but just to the extent that you know.
So I'll say this, I can't speak on behalf of PSNC, but the companies controlling what we can control have taken in that concern and that thought into account and what we have contracted. So even though it is a PSNC facility that is taking that redelivery service, the companies have been very thoughtful and deliberate in assuring we have the appropriate pressures from interstate pipelines going.
Okay. So do I hear you saying that the companies, meaning PSNC and DEP, have mitigated have worked to mitigate problems that were experienced during Winter Storm Elliott at this particular receipt?
What I can say in this setting is that DEP took that into consideration in their contracting to ensure there was a higher threshold and facilities to accommodate higher pressure requirements.
And could it be that MVPs being in service ameliorates pressure concerns at this receipt point?
I wouldn't go that far. It definitely helps. But it's more about the facilities of MVP Southgate and the Transco SSE expansion that will help make the pressure in that part of the state more resilient and stronger.
Okay. Okay, I understand that, but will MVP alone, will the gas coming in from MVP alone to that area of the states help with pressure issues that have been experienced on Transco right there?
So it definitely helps the Transco system without getting too technically detailed. Transco does not run at the same high operating pressure as Mountain Valley Pipeline. So when you have that Southern Virginia receipt of Mountain Valley Pipeline gas and it has to traverse those approximately 30 miles into the state, you see the pressure decline on the system. So you don't have the same pressures on Mountain Valley Pipeline in Rockingham County, North Carolina. There is a pressure decrease. However, the Southgate facilities and Transco SSE facilities will help improve the pressures in Rockingham County from where they are today.
Okay. All right, thank you, Mr. Mitchell. That's all I have. Let's see if there are questions on commissioners' questions, side of the room. Duke.
No question.
All right, Mr. Mitchell, you may step down. Thank you very much. All right, Duke, you may call your next witness.
Chair Mitchell, before we move on, Tim Dodge with North Carolina's Electric Cooperatives. Before we move on to the next witness, if I could make a procedural or scheduling request.
You may.
NCEMC filed a motion for substitution on August 5th to substitute witness James Wilkins in place of Amadou Fall, which the commission granted yesterday. So accordingly, Mr. Fall will not be appearing and Mr. Wilkins will appear in his place. I note that the public staff has requested 5 minutes on cross time for direct and 5 minutes on rebuttal. No other parties have continued to request cross-examination at this time. To streamline the process, NCMC would request that to the extent the public staff or commission have questions that Mr. Wilkins be allowed to present his direct and rebuttal testimony together. Counsel for Duke and NCMC have discussed this, and that can be done as part of the direct or rebuttal at the preference of the commission.
No objection from the staff to that request.
Okay. All right. Well, I will allow your request, Mr. Dodge, and Mr. Wilkins can testify, can be presented for cross-examination on both the direct and rebuttal testimonies that NCEMC has offered in this docket. And what I would like to do, because I see Mr. Neal standing up, is I'm going to ask that Mr. Wilkins be presented for cross-examination at time of rebuttal, just to save time here. Mr. Neal, did you want to be heard?
Just briefly, just renewing I don't know what the commission's plan is for a lunch break, but if it was possible to have Mr. James appear out of order, this might be a good time. I know that Duke continues to object, but.
Yeah, Mr. Neal, what I would say is at this point, I'd like to get through Duke's direct and then get into the intervener testimony. I recognize the constraints that your witness is working with. My hope is that we can get through Mr. Smith's testimony and then we can have your witness come up subsequent to Mr. Smith, and then we can take a lunch break. It's 12:20, so y'all will have to hang in there until we can get to lunch because we need to hear from Mr. Smith and then we'll need to hear from your witness. Let me make sure that that works for the court reporter. Okay, I see her head nodding, so. All right, so with that then, Mr. Smith, let's get you sworn in. There you go. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good afternoon, Mr. Smith. Would you please state your full name and business address for the record?
My name is John Robert Smith Jr., typically called Bobby, and my business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services, and I'm the general manager of New Gas Development.
Will you please briefly describe your role and responsibilities at Duke Energy?
So the main things we do are the front end activities related to any of the new generation sites that are identified. I'll highlight the 4 areas that we focus on the most, and that's identifying permits and jurisdictional approvals necessary, and we obtain those. We solicit and award the major equipment and the engineering and construction contracts. We develop a the initial project estimate, and then we take those work products, including the estimate, for internal board approval of the project and funding approval.
Mr. Smith, did you cause to be pre-filed in this docket direct testimony consisting of 16 pages?
Yes, I did.
Do you have any changes to your direct testimony at this time?
I do not.
If I were to ask you the same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Your direct testimony did not include any confidential information, correct?
That is correct.
And is it correct that your direct testimony sponsors exhibits 2, 3, and 4 to the joint CPCN application?
That is correct. I would note that all 3 of those are confidential.
Thank you. And did you also pre-file a summary of your direct testimony for the commission?
Yes, I did.
Chair Mitchell, I would ask that Mr. Smith's direct testimony be entered into the record as if given orally from the stand, as well as the summary of Mr. Smith's direct testimony.
All right, the direct testimony of DEP witness Smith filed in the docket on March 28th, 2024, consisting of 16 pages, will be copied into the record as if delivered orally from the stand. And the summary to that testimony will also be copied into the record as if delivered orally from the stand.
Thank you. Mr. Smith is now available for questions from the parties and commission on his pre-filed direct testimony.
All right, Sace, you're up.
Good afternoon, Mr. Smith.
Good afternoon.
I'm Christina Tidwell, representing SACE et al. In your direct testimony, you state that the selected EPC, that's engineering, procurement, and construction contractor, will have significant influence on the project's success. Is that correct?
That is correct.
But at this point, DEP has not selected the EPC contractor.
Not selected. We have developed and issued the RFP, and recently at the end of July received bids.
And the company has developed a pre-qualified list of bidders who can submit a bid to execute the project, correct?
That is correct.
But the company has not used any of these qualified bidders as EPC contractors in the last decade.
We have used them throughout Duke Energy, not specifically in the DEP territory, but each of the providers have provided some level of service, and in some case, engineering and construction agreements in other service territories.
Okay, but not in Duke Energy Progress territory.
That is correct. In the last decade.
Is it correct that DEP has selected the design build project delivery method?
Yes, that's the approach we've undertaken.
And that will result in one party, the EPC contractor, being responsible for both design and construction of the proposed project?
Yes, that's the typical approach in energy and power projects today.
DEP expects the EPC contract to be a lump sum turnkey contract?
That is the approach we've taken with our requests for proposals. Granted, those requests go out to the various bidders that we've invited, and we've set the terms and conditions as a draft form, and they will respond accordingly to how they're comfortable bidding that project.
In a lump sum turnkey contract, the contractor would convey a facility that is ready to operate. Is that right?
Yes, they would.
Please turn to SACE et al. Potential Cross Exhibit 22. And it's in this, I believe it's in this binder that's right here. So that's potential SACE et al. Potential Cross Exhibit 22. I'm going to turn there too. And this is DEP's response to SACE et al. Data request 2-4. Are you there?
Yes, I am.
Chair Mitchell, we asked that this exhibit be marked as SACE et al. Cross Smith Direct Exhibit 1.
All right, the SACE's potential cross-exam, Exhibit 22 will be marked as SACE, cross-examination, Smith, direct, Exhibit number 1.
Thank you. In this data request, SACE et al. Asked DEP to please provide a list of any engineering studies that have not yet concluded, but which Duke intends to conclude before the issuance of the EPC RFP for the Roxborough CC project. Did I read that correctly?
You did.
And DEP's response is the company has already issued the engineering, procurement, and construction EPC RFP for the Roxborough CC project. No studies were completed prior to issuing the RFP, and no additional engineering studies will be completed prior to making an award to the EPC contractor. Did I read that correctly?
That is correct.
So is it correct that the actual design and engineering phase for this project has not yet begun?
That is correct.
And DEP is requiring the EPC contractor to complete the engineering work for the project?
Yes, that will be part of their scope.
Would you agree that DEP will have a more accurate cost estimate once engineering work is completed?
But again, the way the EPC power market works is you define the conceptual early engineering scope of deliverables. The market for especially combustion turbine combined cycle projects are so mature and understood within the marketplace that they have their historical information and they use what the owner typically requests as the required specifications, and they bid that accordingly. So they bid to their information and our understanding of scope expectations. And at that point in time, their price, assuming we stay within the requested firm price turnkey agreement, that will be their price. They will not come back after a phase of engineering or a phase of procurement for another price. That will be their price they contract for.
Okay, thank you. And you sponsored Exhibit 3 to the CPCN application, correct?
That is correct.
Okay, and without getting into any confidential information, on page 5 of that exhibit, section 3.3,
I'm there.
you state that the current cost estimate accuracy for the proposed facility is between a Class 4 and a Class 3 estimate. Is that correct?
That's how we view it, looking at the AACE standards. You know, there are metrics and criteria to classify the quality of the estimate, the quality of the front-end design, conceptual design that's been completed at that point. We're not comfortable saying we're at a Class 3, but we think we're well within the Class 4. So we feel we're somewhere in between the typical range of a Class 3 and Class 4 estimate at this stage for the application.
And a Class 4 cost estimate accuracy is within a range of, I guess, 30% less than the estimate to 50% more than the estimate, correct?
Yes, that's according to the standard of AACE.
Okay, thank you. No further questions.
All right, public staff.
Thank you. Good afternoon, Mr. Smith. My name is Will Freeman. I'm an attorney with the public staff. I heard you say just a moment ago that bids had just been received here recently.
That's correct.
It's fair to say that we do not yet know what share of expenses will be paid by NCEMC at this point. Is that right?
That is correct. Well, what share? I mean, the commercial agreement is broken up to the point where they have the right to purchase a certain percentage of base load generation. So from a share perspective, percentage basis, yes, the dollar value and the exact output megawatts, that is not yet defined.
It could range from anywhere from, I would say, about 1/6 to 0. Is that right?
Not following your question. 1/6 being 16% or less. Okay, yes, I follow you.
So would it be fair to say that NCEMC's contribution could be in the range of around 0 or around 1/6?
That's my understanding of the commercial arrangement. It would range between up to 16%.
Thank you.
Subject to check that number.
Thank you. Just moving on to another topic. Is the best place to address cost issues for Roxborough in the fuel rider or the rate case when this facility is used and useful?
I'm going to object to that question. I think that's well beyond the scope of Mr. Smith's testimony. It's asking him to opine about the appropriateness of cost recovery, which he has no background or has provided no testimony about in his testimony here.
Mr. Freeman.
Yeah, I just wanted to clarify what dockets we're going to end up talking about some of the costs that he discusses in his testimony. And if you don't know, let me add that caveat. If you don't know, that's a fine answer too.
Yeah, and that's going to be my answer. I'm not
All right,
familiar
all right,
with rate
Mr.
cases or how they're developed.
Let me rule on that objection. I'm going to overrule the objection. Mr. Freeman, you can ask your question and we'll give the witness's testimony the weight that it's due.
I think you'd agree with me that you don't know whether a fuel rider, fuel general rate case or any other proceeding is the best place to address the cost allocation.
Yeah, that is not my area, and that would be best served from the gas area or our rate recovery resources.
Thank you. A couple more topics I want to talk about. I think we heard Mr. Summers talk about Person County and its appreciation of what the facility does. Can you just generally discuss the number of employees that a coal plant such as Roxborough versus CC, such as is forecast, will be? Typically, you would expect to see the number of employees and compare which one is bigger and smaller.
I am not certain of the staffing level at the 4-unit Roxborough site. I would anticipate that number. Yeah, it's an order of magnitude different. It would be up in the 100 range-ish. I'm subject to check. I'm not sure exactly of that number. A 2-on-1 combined cycle within the Duke service territory is typically staffed between 25 and 30 staff.
Thank you. And just if I could get you to sort of generally discuss the community outreach that you've done, and I don't need a lot of detail. I just want to give the commission a flavor of what DEP has done.
So I'm turning back over to our EJ process that we use for most of our projects within Duke Energy. And it's really broken into a couple of different components. One, the first part of that EJ report and assessment covers your EPA, your federal, your demographics, and that information. The second part of that is really a community and stakeholder engagement process. And I'll just touch on a couple of things there. It's already been mentioned of the communication with the commissioners and how we deal with local city and county commissioners in Roxborough, but also working with the Piedmont Community College, making sure that we're communicating with them and having them prepared and ready for any training needs that we may have. We've had interface and interactions with residents to understand their position, close neighbors, what their response is. And again, any sort of community, larger community engagement group that we could get in front of, such as the Rotary Club and that sort of thing, talking to them and making sure we're taking and receiving their feedback. So there is a plan, there's the stakeholder engagement plan to address what's been done and what will continue to be done as we prepare for execution.
Thank you. One moment. The public staff has no more questions. Thank you.
All right, redirect for the witness.
Just a couple questions. Thank you. Mr. Smith, you were asked a question about the pre-qualified bidders, and can you just generally provide a little bit more context about their qualifications and your confidence in their abilities to provide the level of service that DEP will need for the proposed facility?
So all of the all of the entities that we invite to bid have been vetted. We will go through the process of visiting their job sites, meeting with them, understanding their execution, their access to resources, their staffing teams that they could assign to various projects. We'll visit the job sites. We'll go through how they manage environmental, how they manage safety, how they set up and structure and execute their work. And so for each of the cases where we've invited these bidders to participate in this particular event, they all have a high degree of experience installing combustion turbines in both simple cycle and combined cycle formats. So while they have not worked in the DEP territory in the last decade, one of them did construct a little better than a decade ago, did construct a couple of the combined cycle facilities that were built in the 2010, 2012 timeframe.
Thank you. No other questions. Thank you.
All right, let me see if there are questions from commissioners. Commissioner McKissick?
This is just one follow-up question. You have these pre-qualified bidders. I guess they're going to take care of engineering, construction, design, build approach. But there's testimony that you provide on page 13 about working with different, what I will refer to as equipment vendors for the CC units that you're considering utilizing. And I take that that's separate and apart from these pre-qualified bidders because you're, and maybe it's confusion in my mind, but I'm reading this to suggest that you're also working with separate bidders to find the best value bidder on the actual CC units that would be installed. Is that correct, or am I confused?
No, you're correct. The group that I manage, we pursue both the major equipment, and in this case, let's say it's the combustion turbine, the steam turbine, the transformers. As we're getting further and further into this new market, we're learning that there are other items that have long lead time that we are also taking on and engaging with those suppliers, mainly to ensure that we can make those commitments and secure that equipment with the long lead time such that it would be available for us to assign over to an EPC contractor, and he'll have that material available to install to meet our schedule. So it is a separate exercise. Not all entities operate the same. Duke has historically preferred to be able to control the broader fleet and consistency of fleet, to go ahead and purchase the gas turbine, the steam turbine, for a more of a overall system consistency. Not to say that everyone that we have purchased is consistent, but some level of consistency there from both spare parts, operations and maintenance and that sort of thing. So we do bring those larger components to the table, assign those over to the EPC contractor through that EPC agreement.
Excellent. That was the clarity I was seeking, because it seemed to me they were two separate processes.
That's correct. They
ongoing
are
simultaneously.
And I would just add that we do enter into discussions with those EPC contractors to make sure they have experience with those certain vendors, where that makes a difference to us as we look at the evaluation. Have they actually installed vendor A equipment or vendor B or C? So we also consider that as we go through the evaluation.
And that would be a very important component of the evaluation, I would assume.
That's correct.
Thank you. I don't have any further questions.
All right, any other commissioners? All right, Mr. Smith, I have a question for you regarding information provided in Exhibit 3 to the application. Let me know when you have that in front of you. And I'm specifically interested in Table 3.1, and it appears in Section 3.1 of the exhibit.
Yes,
You
I am there.
Okay. Now, Table 3.1 includes confidential information. Do you see that?
That's correct.
Okay, so I don't want to elicit confidential information from you, so be careful not to go into confidential information. If I ask you a question that requires confidential information, just let me know. All right, so that table identifies costs associated with with network upgrades, is that correct?
That is correct.
And those were upgrades that were identified both through the DICES process as well as through the GRR process, is that correct?
That's correct.
Okay, help us understand why the costs for the upgrades that were identified through the GRR process and through DICES are close in amounts. Because to the extent that the commission would have anticipated the DICES amount to be lower than the GRR amount, help us explain to us why it's not and if our assumption was not appropriate.
So to explain to you why they're close is, I'm not sure relevant that the two values happen to be close. It's relevant that we understand the scope of each of those that we estimate and projected accordingly. So the fact that those two evaluations and studies produced an estimate that's similar, I don't see the relevance there because they're two separate scopes, two separate defined scopes.
Okay, when you say two separate defined scopes, what exactly do you mean?
So there's a scope of work when you look at the DICE. So Witness Roberts probably can touch on this a little bit, but since it's in my testimony and broken into parts, I'll try to give a little more description. So there's a component of transmission interconnection that goes from the generation facility, the transformers that we're going to install over to the point of interconnect. And there's a cost estimate associated with bringing those wires over to that point of interconnect. So in this table that you're referring to, that would be the top line. The second line, the third line would be the generator replacement upgrades necessary. And so even though we're using the generator replacement queue and the advantages of that, what are the anticipated costs to physically make and modify that on-site existing switchyard to accommodate the generation from this new unit? So the projections of the modifications, in this case, we are seeing that the high voltage switchgear and the breakers are all being replaced to accommodate this larger capacity output for that substation. And then the third piece is the middle piece is that DICES, and that's really what happens from that substation out through the transmission system and what other upgrades are necessary to continue to distribute that through the transmission. So hopefully that helped.
Okay, it does. I thank you for that explanation. Mr. I think it was Donashad today referenced, and we can clear this up on rebuttal if that would be appropriate. But he referenced, I heard him say $12 million at one point, and to the to the extent that you heard him say $12 million and you know what he was testifying to, can you help me understand? Can you explain that to me?
So we did receive the phase 2 report from our DICES queue submittal, and where we were carrying 30.
That's all right. So let me ask the question this way. So was there a reduction in upgrade costs from phase 1 of the DICES study to phase 2?
That is correct. And
Okay.
Mr. Donashot's value that he presented is what we received in phase 2.
Okay, so then the cost information, at least associated with the network upgrades that can be attributed to this unit has changed from the point in time which you all made application to us until now?
That is correct.
Okay, all right, that's all I need to know. Okay, questions on commissioners' questions? Are there any?
Questions from the
Okay.
folks? No questions. Thank you.
All right, with that, Mr. Smith, you may step down and we will see you later.
Thank you, Chair Mitchell.
Thank you. All right, Mr. Neal. Let's call your witness.
I move to enter Sace et al. Cross Smith Direct Exhibit 1 into the record.
All right. Having not heard an objection to your motion, I'll allow it.
Thank you.
Okay. Y'all may call your next witness. All right, Mr. Neal, call your witness. Okay.
Sace et al. Calls Robert James to the stand.
Good afternoon, Mr. James. Let's go ahead and get you sworn in. Can you raise your right hand, please, sir? Left hand on the Bible. There you go. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Do.
Go ahead.
Good afternoon, Mr. James. Please state your name, title, and business address for the record.
My name is Robert James. I am Managing Director at Lumen PMC. And the address is 2800 Post Oak Boulevard, Suite 4100, Houston, Texas, 77056.
Will you please briefly describe your role and responsibilities at Lumen PMC?
I manage the projects that Lumen PMC does for customers. We're a small group of persons that have worked in the industry, in the construction industry in the past, and we advise owners, we advise builders, contractors in the process of constructing industrial facilities.
Mr. James, did you cause to be pre-filed in this docket on June 24th direct testimony consisting of 11 pages in both confidential and public versions?
Yes, I did.
At this time, do you have any changes or corrections to your pre-filed testimony?
No.
And if the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
They would.
Did you also have an exhibit to your testimony consisting of an expert report and attachments in both confidential and public redacted versions?
Yes, I did.
Was the exhibit to your testimony prepared by you or under your direction?
It was.
And did you also prepare a summary of your testimony?
I did.
Chair Mitchell, Sace et al. Moves to have the public and confidential versions of Mr. James' pre-filed direct testimony and his summary entered into the record as though given orally from the stand, and to have the exhibit attached to Mr. James' pre-filed testimony identified as pre-marked.
All right. The testimony of Sace et al. Witness James filed in the docket on June 24th, 2024, consisting of 11 pages, will be copied into the record as if given orally from the stand. Portions of the testimony which are confidential shall be so treated in the transcript. I would ask counsel to work with a court reporter to make sure it's appropriately redacted in the transcript. The one exhibit to that testimony shall be marked for identification as it were when pre-filed.
Thank you. The witness is now available for cross-examination and questions from the commission.
Okay. Let's see, we've got Person County.
Good afternoon, Mr. James. My name is Bo Summers. I represent Person County. Because of the way we're situated, please do not crick your neck looking sideways at me. Feel free to sit whatever is most comfortable for you. First, let me apologize to you for the weather that you're experiencing on your visit to North Carolina. Coming from Houston, you've had more than enough unfortunate experience with hurricanes and tropical storms, I can only imagine. So hopefully you'll come back another time when we have better weather for you. Having said that, have you ever been to Person County where this facility would be built?
No, I have not.
And just hypothetically, if I asked you to go over there to that map on the wall and point out Person County, do you know where it is in relation to where we are today?
Not really.
Okay. Well, open invitation for you to come visit anytime.
Thank you.
In Houston, where you live, is a very different community than Person County. Would you accept that's at least subject to check?
Yes,
And in fact, Houston is the fourth largest city in the United States, correct?
it is.
And the largest and only city in Person County is Roxborough, and it has a population of about 8,000 people. Is that right?
Correct.
I can only imagine that's probably the size of a high school in Houston. And do you understand, based on either what you've read prior to coming to Raleigh today in the record of this case or hearing questions today, how important the existing coal plants are to Person County, as well as the economic importance of the replacement generation that's being proposed in this proceeding?
Yes.
Okay. As I understand your testimony, you're not opposing the CPCN or the certificate to enable this plant to be constructed. You're recommending that this commission delay it. Is that correct?
Yes, it is.
And as I further understand your testimony, your expressed opinion is that because of the way you believe Duke has done its design engineering process, that there could be potential cost increases or changes or delays, and that's your primary concern?
Yes, the preliminary design and engineering process.
Okay. And are you familiar with the CPCN process under North Carolina law, where if this commission were to approve this project, Duke would be required to file an annual progress report that updates on the construction schedule, the permitting, and any potential changes to cost every year during construction?
Yes, I'm aware of that.
Okay. And in fact, under North Carolina law, this commission and the public staff and other parties would have the opportunity to review that. And in the event that this commission believed there was some significant change, they could even revoke the certificate. Isn't that correct?
Correct.
So your concerns are not a reason to deny this application. You're not suggesting that it should be denied, just that it should be delayed?
Yes, that's right.
Okay. Thank you very much. I hope you have a safe trip ahead of the storm.
Thank you.
All right, public staff.
Thank you. Mr. Smith, you outline a number of issues, and I think there's a good summary, like about the third page of your testimony, but
I'm Mr. James.
I apologize, Mr. James. You rubbed off on me, Mr. Smith. I apologize, Mr. James. Thank you. If help me, if you can, quantify in dollars or percent cost overrun or some methodology that you think that the process used here will increase or decrease the ultimate price paid by ratepayers.
I think that's pretty well impossible. There will be increases and decreases. They will be a function of the preliminary engineering done before tendering and awarding a contract. But that remains to be seen. I think it'll be less if DEP agrees to spend more time on the front end engineering and design.
Thank you. I don't have any more questions.
All right, redirect.
Yes, very quickly. Mr. James, do you recall Mr. Summers asking you some questions and about your recommendation in your testimony and report?
Yes.
Can you briefly explain what your recommendations to the commission are?
Yes, my recommendations are, like I just mentioned, DEP, in my opinion, has not met ordinary recommended standards in industrial construction to prepare properly for a industrial project. They have basically collected, I believe, estimates from consultants that are not in detail adequately to come up with a front-end engineering design that supports, let's say, the design build process for construction management.
And Mr. Summers also asked you about your experience with Person County and the Roxborough site. Do you recall that?
Yes,
You do have experience with power projects in general, is that correct?
I do.
No further questions.
All right, let me see if there are questions from commissioners for the witness. Check in. Go ahead, Commissioner Kimmeray.
Good afternoon, Mr. James. I just have 2 questions for you. That I wanted to mention Mr. Smith's rebuttal testimony in which he responds to a couple of the things that you have stated. And his testimony is that you have recommended that Duke complete the front-end engineering and design study. And his rebuttal testimony says that that is not an industry standard. Do you agree with him or dispute his opinion that it is not industry standard?
Well, I would say it is a standard that has developed over the last decade to do a gate-based analysis of the engineering and design necessary to reach a stage where you can offer a decent request for proposals to contractors. I think there's items missing from industry standards for preliminary design in what DEP has done.
Okay, thank you. And then just my last question to let you respond to what witness Smith has stated, but he states that the front-end engineering and design study is more often seen in construction of oil and gas, chemical and large process projects rather than the fixed price EPC project that's being proposed here. Do you want to respond to his statement or testimony about that?
Yes. Basically, I think that it definitely is applicable to refining and petrochemical projects, but I don't think that limits it to the industrial projects, including power facilities. I think the requirements to get ready with a project is the same basically for any industrial project.
Thank you.
All right, let's see if there are questions on commissioners' questions. We'll start, we'll start over here. Okay, public staff?
No questions. Thank you.
No questions.
Okay. All right, Mr. James, thank you very much, sir. You are, your day has come to an end with us finally. You may step down and be excused. We appreciate your testimony today.
Thank you, Chair Mitchell.
Absolutely. All right. With that, we will, Mr. Neal, did you have?
Oh, no, I've just forgotten that I need to move to admit his exhibit into the record.
Okay. I will allow your motion.
Thank you.
Sure. Yes. Okay. With that, are there any other matters from council before we break for lunch? All right. Well, we will break for lunch. We will take an hour for lunch. We will come back on the record at 2 o'clock. Let's go off the record, please. Public staff, you all are up. You may call your witness.
Thank you, Chair Mitchell. Tom Felling with the public staff. The public staff now calls Evan Lawrence and Dustin Metz to the stand. Mr. Lawrence, would you please state your name?
Let me get them sworn in first,
Oh,
Mr. Felling. All right, good afternoon, gentlemen. If you would, raise your right hands, left hand on the Bible. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, now you can start, Mr. Felling.
I'm trying to move quickly. Thank you for that. Mr. Lawrence, would you please state your name, business address, and current position for the record?
My name is Evan Lawrence. My business address is 430 North Salisbury Street, Raleigh, North Carolina, and I'm an engineer with the Public Staff's Energy Division.
Mr. Metz, would you please state your name, your business address, and current position for the record?
My name is Dustin Metz. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm an engineer and the manager of electric section, operations and planning of the Public Staff's Energy Division.
Mr. Lawrence, on June 24, 2024, did you and Mr. Metz jointly prepare and cause to be pre-filed direct testimony in these dockets?
Yes.
Did your testimony contain confidential information?
Yes, it did.
And on July 30, 2024, did you and Mr. Metz jointly cause to be pre-filed corrected direct joint testimony in these dockets that was reformatted to include page numbers and footers that were absent in the original filing, but which otherwise made no changes to the content?
Yes.
Did the corrected testimony contain confidential information?
Yes, it did.
Did both the June 24, 2024 testimony and the July 30, 2024 corrected testimony consist of 55 pages and also 2 appendices that included your qualifications and experience?
Yes.
And are those 2 appendices setting forth your qualifications and experience that you filed and no exhibits to your testimony?
Yes.
Do you have any additional corrections to your pre-filed direct joint testimony?
Yes, I do. While reviewing our testimony earlier today, I did notice an error that is immaterial, has an immaterial impact to our testimony. On page 7, line 17, the line that begins with G-6, that should instead read G-5.
And if I were to ask you the same questions today under oath, would your answers contained in your pre-filed testimony be the same?
Yes. Yes.
And lastly, did you and Mr. Metz prepare and cause to be pre-filed on August 1st, 2024, a summary of your joint testimony and docket numbers E-2 sub 1318 and EC-67 sub 55A?
Yes. Yes.
Chair Mitchell, at this time, I move that the pre-filed joint testimony of Mr. Lawrence and Mr. Metz with the one immaterial correction that they've identified to the docket number and the pre-filed summary of their joint testimony of Mr. Lawrence and Mr. Metz be entered into the record as if given orally from the stand.
All right, Mr. Felling, the pre-filed testimony of public staff witnesses Lawrence and Metz filed in this docket on June 24th, 2024, consisting of 55 pages and 2 appendices, is corrected by a filing made on July 30th, 2024, and then is later corrected from the stand today, will be copied into the record as if given orally from the stand. The summary of the testimony will be copied into the record as if given orally from the stand as well.
Thank you. The panel is now available for cross-examination.
Okay. EDF.
Thank you. Ben Smith from Environmental Defense Fund. Good afternoon, gentlemen. I'm going to have some questions for you that are going to sound very similar to something you heard yesterday from me. Different dockets, so different records, so I apologize for the repetition. Going to page 9 of your testimony, beginning at line 5.
Page 9, line 5.
Yes.
I'm there.
And this is a question that says, do you have any concerns with the technology of the proposed facility? Do you see that?
Yes.
And generally speaking, you don't have concern about the proposed technology, but you do voice concern about the use and potential future need for hydrogen as a fuel source, and also the viability of carbon capture and sequestration in North Carolina. Do you see that?
Yes.
Can you provide some of your concerns with regard to hydrogen as a fuel source in that answer?
Looking at the testimony, the detailed information can be found in the CPRP testimony of myself and Mr. Michna. At a very high level is the the ability to transport the hydrogen, the potential load assumptions with that hydrogen, and the potential economic viability and system operation impact to the localized plant to the extent that carbon capture and sequestration is implemented.
Thank you. And just to be sure I heard that right, would some of the aspects related to your hydrogen concerns also touch on the economic case for a hydrogen firing facility?
Yes, part of those concerns would be the overall economics of hydrogen. I believe I filed testimony in the DEC, the recent DEC general rate case MYRP, and I believe I had a detailed discussion on the proposed Clemson CHP project with hydrogen, and I provided some of the cost analysis and equivalent dollar per MMBTU in that testimony.
Thank you. And is there a chance that in an effort to meet the carbon neutrality requirement, the cost of fitting Roxborough CC, the proposed project here, with CCS technology and accompanying CCS infrastructure will cause the Roxborough CC to become so expensive that it may not be selected in later CPIRP modeling?
I think that's uncertain at this time. What I can state is based upon our modeling analysis with a Clean Air Act 40% limit, and as well as Duke's modeling results, that at least this resource was still selected, even with a binding constraint of only allowing the unit to operate at 40% annual capacity factor.
Isn't DEP asking for a resource here that may be inoperable under carbon neutrality requirements well within its useful life to be approved for construction?
Yes, I believe there was an earlier discussion day and pointing to a cross exhibit of looking at the annual degradation of the capacity factors over time.
Thank you. On page 15 of your testimony, lines 10 through 12.
Page 15, lines 10 through 12.
Second, I'm getting there too. You testified to the extent hydrogen fuel use or carbon capture and sequestration is required, the cost to operate the Roxborough combined cycle will increase. Do I have that right?
That is correct.
Do you know how much those costs to operate will increase?
On the hydrogen fuel use, I don't know how, I did not prepare an estimate to evaluate the potential retrofit or assumptions of how to potentially pipe to get that hydrogen to the plant. I have some confidential information which I'm trying to stay out of. In order to get to the actual derivation, I would have to go into confidential data.
That's okay. We don't have to go that way. Would it be fair to say that it would be, actually scratch that. Would you consider what you believe those costs would be to be a substantial increase in the cost of the asset?
From an energy standpoint, yes, it would be substantial. From looking at just hydrogen, from the capital plant standpoint and the potential either PIMS or through CCS, I would say it's substantial.
All right, no further questions.
All right, we've got Person County next.
Thank you. Good afternoon, gentlemen. I'm Bo Summers on behalf of Person County. As I explained to Mr. James earlier, please don't turn sideways and hurt your neck. Face whatever's most comfortable. A couple of questions for you today. Excuse me. Did either or both of y'all attend the public hearing in Roxborough in this matter that the commission held back in June?
Yes.
Okay. Did both of you or just you, Mr. Betts?
Both of us did.
Perfect. And whoever wants to answer a question, I'll just direct it to the panel and y'all answer it as you see fit. Was there a pretty good turnout at that hearing?
I would say so, yes.
And I know, Mr. Metz, you in particular have worked on many CPCNs over the years that you've been with the public staff. Would you say that the turnout and the support for this project were roughly equivalent to what you've seen in past public hearings for CPCNs, whether it was for a plant or a transmission line, or how would you describe that compared to your, if there is a normal experience that you've had while you've been at public staff?
I can't define what normal is per se, but I would say from an averaging standpoint, there for that public hearing, there was more local support for the proposed natural gas facility comparative to other CPCNs or transmission line public hearings I've been to.
Thank you for that. And in fact, would you agree with me that most of the people who said something in opposition to the plant really didn't live in Person County, did they?
I'd say that's yes, that would be generally correct. However, those people who were in potential opposition were also Duke Energy Progress ratepayers.
Certainly. I want to shift gears a little bit. I understand y'all answered some questions in some proceedings over the past couple of weeks that maybe got into this. My client was not a party to those. I don't mean to repeat things, but I feel like it's important on behalf of Person County to ask a couple of these questions. So if you bear with me, as I understand your panel testimony in this case, you support the commission approving this combined cycle at Roxborough with at least a condition. Is that a fair summary of your conclusion or recommendations?
One second.
Sure.
I'm looking for the exact part where we're at our recommendation statement.
If council had a page and line site or just a general area, it might be helpful just to
I'll
guide them.
find it, but I mean, I would think you wrote your testimony. You know what y'all recommended, right?
I got it. I just had a few hundred pages of testimony over the last 2 or 3 weeks.
Okay, no problem.
Looking at page 5, question, starting at line 14 through 15, there is a need for combined cycle and combustion turbine natural gas generation in DEC's and DEP service territory, and disapproval of this CPCN application could delay interim carbon emissions reduction compliance and coal plant retirement set forth in the carbon plan order. And that is in part the reason for the recommendation.
So again, your recommendation is the commission should approve it subject to a condition.
Right, but there's reasons in our testimony to explain why we have to make that recommendation because we're limited in availability.
Yes, sir. And I want to delve into that just a little bit, and I'm sure Duke's lawyers will do a better job than me, but I want to ask you a little bit about one of your conclusions is that, and I believe maybe Mr. Lawrence, you testified to this yesterday as I was observing that hearing in the Marshall case, that you couldn't determine conclusively one way or the other if this was least cost. My summary, in part because Duke did not do an evaluation of greenfield sites in addition to the Roxborough site. Is that a fair summary, or feel free to correct it however you need to?
At least for myself, that is a fair summary. Look to Mr. Lawrence.
I would say that would be expanded not to just greenfield, but other potential brownfield locations as well. I believe in this yesterday.
So, for example, one of the items under debate is why did we have to select this location? We could have actually built a generation plant with a greenfield evaluation closer to Transco within Person County. We couldn't find through our evaluation where that alternative analysis was completed. If you were to build a plant closer to Transco, you could reduce the PSNC pipeline cost that you can see in the testimony as a confidential number that I don't need to go into. Yes, it would have required transmission to connect between point A and point B. However, there's no cost evaluation to determine what would have been a better outcome for ratepayers. Also noting that to the extent that if we built more transmission, we may have been able to integrate other future resources or other resources in the future. That analysis was not completed based upon our review.
Okay, and I want to try to distinguish, if you'll agree with me, between a theoretical site in Person County that's closer to Transco than the actual real world site that's being used for power generation today that has all the infrastructure you would need and already has the land use and the permits. You would agree there's a difference between a theoretical site and a real world site that actually works.
No, I disagree in part for purposes of evaluation. Again, I'm trying to I'm very, very careful on the hundreds of millions of dollars of investments that are required for both transmission and natural gas to say the extent that, yes, there is some infrastructure there. Yes, that infrastructure would have benefits, but we could not find the cost analysis to see the pros versus the cons associated with utilization of that existing infrastructure.
Okay, and I I appreciate the position you're taking. I understand the line you're trying to draw there, Mr. Metz, but is it your opinion that a greenfield site would actually be more cost effective for customers than the site where the coal units are being retired? There's already all the infrastructure that the Duke witnesses have testified to, and it has all of the support or the support you've acknowledged from the county at an existing brownfield site.
It's uncertain at this time. I also think we're potentially conflating whether or not we should evaluate combustion turbines, the amount of combustion turbines versus the need to locate a combined cycle at this site.
Okay. I want to turn a little bit to your part of your testimony that you were reading earlier about lease costs. And I realize you're not a lawyer. You've got fine lawyers representing the public staff. I'm not asking you for a legal opinion, but you've certainly participated in many CPCN proceedings, and I believe you agree you're, at least to your own degree as a engineering section member of the public staff, familiar with the least cost test and the public convenience and necessity test that this commission uses in making these decisions. Would you agree with that?
Yes, sir.
Okay. So without asking for a binding legal opinion on behalf of the public staff, when you talk about lease costs and the standard of public convenience and necessity, that's somewhat of an elastic standard, isn't it?
Yes, it is.
Okay. And in fact, this commission has approved numerous CPCNs that were not least costs from a pure PVRR basis. Isn't that correct?
I can't speculate on all of the CPCNs that the commission has approved, but generally, yes, and subject to check.
Okay, well, I'll go through a couple examples, and if you're familiar with them, great. If not, you feel free to let me know. But for Duke Energy Carolinas, the Buck combined cycle plant that this commission approved was not the least cost option that Duke presented, was it?
That was before my time, so subject to check.
Okay. And likewise, Duke Energy Carolinas Dan River combined cycle plant was not the least cost option when Duke presented its evidence before this commission. Is that correct?
That was before my time, so subject to check.
And I know this will be before your time, but I'll ask you anyway. The Cliffside 6 coal unit that was approved on the border of Rutherford County, that was not least cost either, was it? From a PVRR standpoint.
That was not least cost in my general understanding. That particular CPCN and the proposals with that one had a whole host of other factors and events that took place following the issuance of the CPCN.
Right. And I'll add that in each one of those scenarios too, there's a specific set of facts and circumstances that have got to be evaluated. So while the PVRR is one item that goes into that analysis or the ultimate decision, there are a host of other factors as well.
I thank you for that. I agree. But would you also agree that in those cases that I mentioned, subject to check, and realize they were perhaps before your time, but unfortunately or fortunately not before my time, in those the decisions that led to the companies coming forward to the Utilities Commission, they exercised some management judgment as to what would be best for their customers and didn't look at it just on a strict definition of least cost. Is that correct?
I don't have familiarity with those dockets. They were before my time. The only thing I can speak to is the evaluation that took place within this CPCN and what evaluations did or did not take place.
Okay. And just this will be the last question on this topic, but you mentioned the Cliffside 6. Are you familiar with that order or that decision by the commission to grant that certificate?
I'm not familiar with the order. I've just had a few discussions with Mr. Hinton in regards to that plant.
I'll stipulate to Mr. Hinton's distinguished career for the public staff. If you read that Cliffside 6 order, I would encourage you to, when you have some time to read it, to see that the company witness, Janice Hager, testified that the Marshall coal plant was not least cost either, but the company decided that the PVRR analysis would have chosen an oil-fired plant, but they exercised some company management to determine what was the best option, not just looking at cost. So do you have any familiarity with that decision?
No, I'm confused by your statement. If we're If the company evaluated at some point in time whether a 300 to 600 megawatt oil fire unit was more cost effective than a coal plant, I'm just very confused to how we got here because that doesn't make any sense to me.
All right, well, I'll encourage you to read that order. Notwithstanding all that, in this case, you would agree that the commission has the authority to determine what is least cost and what is in the public convenience and necessity. And they can certainly determine whether this site is the best one or if some theoretical greenfield site somewhere else should have been chosen, right?
I don't know if this commission can make the determination if no other worthwhile analysis would actually been completed on either greenfield or associated brownfield. The reality is that we are here where we are, and we've ran out of time to explore alternative options.
And I'd just like to add, again, each of those were before my time. I'm not familiar with the circumstances in those cases, but by just on the line of questioning, by saying that there were other lower cost options that went and they were not selected, well, that tells me that there was an analysis completed to look at those, and that there, again, were other factors that were the determination and the site selection. That may have very well been the case here as well. We're not saying that there were other least cost options. We're not saying that this isn't the least cost option. We are saying that we cannot make that determination as we sit here today.
Thank you.
And to be clear, it is a logical conclusion of why to build at Roxborough in a location that it is, but as Mr. Lawrence just has stated, of what we could not validate because there was no alternative analysis.
Okay. Last question is for you, Mr. Lawrence. I know you're a proud graduate of East Carolina University. Would you have an opinion as to who your favorite engineering professor was when you were in school there?
I have a couple that were come to mind. I'd say Jeff Feller would be fairly high up there.
Thank you. No further questions.
All right. Let's see who's up next. SACE?
I'm guessing me. Thank you, Chair Mitchell. David Neal for SACE et al. Good afternoon. At page 23, lines 1 to 5, y'all, you testified that an advanced class CT will have lower costs than an advanced class CC when operating up to a 40% annual capacity factor. But when the technology is required to operate at an annual capacity factor of 50% or higher, it will be more economic for a CC to be built. Do you recall that testimony?
Yes.
Given the EPA's 111 rules that have been the subject of much discussion the last few weeks, that would limit the capacity factor of this proposed Roxborough combined cycle plant to a 40% annual capacity factor, doesn't your testimony indicate that ratepayers could be better served by advanced class CTs at this site?
The reference here, I mean, to get everyone on the same page, was based upon the looking at figure 3, which is confidential. That was making reference to the levelized bus curve of how you traditionally would screen technology resource on initial evaluation to see where it makes sense. So when we looked at fast forwarding in time, when we looked at the more detailed analysis through Encompass, even with a 40% annual capacity factor limitation on the combined cycle, the units were still selected. In part, again, going a little bit back to the CPRP and trying to move fast, is the magnitude of need in such the short amount of time that's required. There's a significant amount of energy being placed onto the system, in part for DEC and also DEP.
And again, those, you're speaking of the P3 modeling results from the fall 2023 load forecast?
Speaking generally to the Encompass modeling, more so to the public staff modeling results and looking at the detailed numbers and the push and pull relationship between generation resources throughout the whole set of portfolio runs we completed.
And you would agree that the public staff's model runs were also using the fall 2023 load forecast and the 22% planning reserve margin for the most part, correct?
That is correct.
At page 8, I'm sorry, at line 8, page 16, if I've got that right, you were asked if the annual capacity factor were reduced to 40%, whether the total annual operating costs would be reduced proportionally, and you said no. Is that right?
That is correct.
And further down on page 17, line 6 to 8, quote, even if the proposed output of the facility is halved, the total costs shown in table 2 would not be reduced proportionally because of the magnitude of the total fixed cost. Do you recall that?
That is correct.
And so those costs include the firm transportation that would persist for the life of that firm transportation contract, correct?
That is correct. When looking at table 2 and not going into the numbers.
That's right.
If you look at the gas pipeline intrastate firm transportation, that is one element of the fixed cost. Regardless if we use 1 MMBTU or the expected total amount of MMBTU, we're going to be paying that cost for the term of the contract. The same is true. What's nested within the fuel category is the interstate cost, which that number is also confidential. Those are fixed costs that we'll have for the term of the contract.
And if the Roxborough CC is limited by federal law to running no more than 40% of the time, there are other fixed costs related to construction, financing of construction, operation that also wouldn't go down proportionally, correct?
Generally, yes.
So there's been a discussion already by counsel for EDF related to the useful life of the plant. You would agree that in the inaugural carbon plan docket, in E100 sub 179, there was it was an issue of contention whether or not future gas plants, whether it would be reasonable to assume a 35-year life for a new gas plant, given that that runs past the 2050 carbon neutrality deadline set in state law, correct?
I remember those discussions or testimony and hearings.
And based on your review of DEP's application in this docket, has the company included additional information beyond what was discussed in the first carbon plan outlining why its assumption of a 35-year useful life for this Roxborough CC continues to be a reasonable assumption?
Can you restate the question, please?
Yes. Based on your review of DEP's application and discovery, the whole bit, your review of this docket, has DEP included additional information beyond what was discussed or put forward in the first carbon plan outlining why its assumption of a 35-year useful life for the proposed combined cycle plant continues to be a reasonable assumption?
I cannot recall additional information being provided other than what was asked in discovery, but I can't remember the exact discovery responses in that rationale.
And on page 9 of your testimony, lines 12 to 14, you testified that we, meaning the public staff, have concerns regarding the viability of carbon capture and sequestration in North Carolina, as well as the costs and impacts to the operation of the proposed combined cycle, or CC.
Yes, that's what testimony states.
And on that same page, lines 9 to 10, we do have concerns around the use and potential future need for hydrogen as a fuel source.
Yes, and that's one reason in part within the CPIRP that we requested the hydrogen pilot study to start gaining more insight into the potential impacts and what future things that we need to be studying for as we look toward the longer term goals of, say, 2040 to 2050 compliance.
And you would agree that those two, carbon capture and sequestration and conversion to 100% hydrogen, are two of the ways that Duke has put on the table for how the plant could potentially continue to be used for its 35-year useful life past that 2050 deadline, correct?
Within the CPIRP modeling results, there was a hydrogen assumption. However, as I stated yesterday, that the public staff did a slightly different analysis. We did not do the hydrogen conversion as Duke did and allow these resources to use a limited amount of hydrogen, not at the volumes that Duke requested, and these assets were still selected.
And I know, again, my counsel for EDF asked some of these questions. I'm trying to just dive a little deeper. I hope it's not repetitive. Nevertheless, public staff has expressed concerns with the cost and viability of hydrogen as an option, correct?
Correct.
And on page 9, lines 9 through 12 of your direct, you point to the testimony of public staff witness Blaise Mishna filed on May 28th in the CPIRP docket E100 sub 190 for more detail on those concerns, correct?
That is correct.
And again, this is what gets complicated. You point to his concerns, but his testimony is not in this docket. So I'm just going to walk through a couple of them since they're in your testimony here. Witness Mishna recommended that Duke not assume that any combined cycle plant would run on 100% hydrogen within 25 years, correct?
Subject to check.
And that's on page 7, lines 11 through 13 of his direct, and I have it here if you need it. Witness Mishna also noted that Duke is not accounting for the significant additional electricity demands that green hydrogen production would require. Do you recall that?
Yes.
And witness Mishna for the public staff expressed concerns with Duke's failure to model costs relating to green hydrogen production, storage, and transportation, correct?
Correct.
And witness Mishna did not think it was reasonable to assume that all of Duke's new gas plants would run on 100% green hydrogen by 2050, which is a significant part of how Duke models compliance with the 2050 net zero requirement, correct?
Correct.
And with regard to modeling 100% hydrogen conversion by 2050, witness Mishna stated, quote, "The public staff is concerned that this assumption may lead to a greater dependence on natural gas in the short term, ultimately resulting in stranded assets over the long term."
Yes, in context, we're talking about the overall IRP in whole.
And this gas plant is also one of the resources selected in that IRP, correct?
Correct. This is one piece of it.
And from your discussion with counsel for Person County to my left, you said that you're generally familiar with the legislation that governs certificates of public convenience and necessity for electric public utilities, correct?
Yes.
And that includes General Statute 62-110.1?
Yes.
And subsection E of that statute will speak for itself, but just reads a certificate for the construction of a generating facility by an electric public utility, ellipsis, shall be granted only if the applicant demonstrates and the commission finds that the facility is part of the least cost path to achieve compliance with the authorized carbon reduction goals in General Statute 62-110.9. Do you recall that part of the statute?
Yes.
And on page 48, lines 5 through 9, you testified in regard to this issue of uncertainty with the NCEMC contract that, quote, "This uncertain and unknown risk makes it challenging to determine whether the proposed facility should be approved by the commission in the first place, and it may cause financial harm to DEP ratepayers if NCEMC does not agree with DEP's proposal to incur certain future capital costs." Do you recall that testimony?
Yes.
And at page 49, lines 16 through 17, you testified, "The public staff cannot say definitively that the proposed Roxborough CC project is least cost for DEP's ratepayers."
Yes, and that is part to the combustion turbine conversation that we've had yesterday.
I have no further questions.
All right, Duke.
Thank you. Good afternoon, gentlemen. Brett Braceward for Duke Energy Progress. Are you?
Hello.
All right. If you could turn to page 49, section 7 of your testimony, please. And these questions will primarily be for you, Mr. Metz.
Page 49, line 7.
It's just question 7. The conclusions and recommendations technically starts at the bottom of 48, but we're going to be referring to page 49.
Okay, I understand now. Thank you.
Yep. And so lines 1 through 6, you're speaking to a modeling, we'll call it an error, because that's what your testimony says, and that's what the company's testimony says, that was identified in the supplemental planning analysis and was something that the company subsequently corrected through the discovery process relatively late in the CPIRP proceeding, so it wasn't incorporated into the public staff's modeling. Is that correct?
Correct.
And so at lines 3 through 6, you say, it is likely that a correction of this error will modify many of the public staff CPIRP portfolio outcomes and identify a need in DEP that aligns with the company's proposed CC generation. Did I read that correctly?
Yes.
Thank you. And so later on page 50, you make a recommendation at lines 7 and 8, the companies present additional modeling analysis to correct that error and update the public staff's PS1F 2034, PS3F 2037 portfolios from the CPIRP.
Yes.
And the companies completed that analysis?
Yes.
And would you agree that upon completing that analysis, it validated the need for the combined cycle facility in DEP to be constructed in 2029 as proposed in this application?
Yes, also highlighting the power flows that are occurring from DEP east to DEC in the same time period.
Understood. And turning to page 51 of your testimony, please. Lines 12 through 13, you identify certain conditions that the public staff advocates the commission should impose in conjunction with granting the CPCN. Do you see that?
Yes.
And the first condition is a recommendation the companies perform reporting and analysis on how the companies here DEP intends to comply with the Clean Air Act rule, Clean Air Act Section 111 final rule. Is that accurate?
Yes.
And the companies did in fact complete that analysis and presented it in their rebuttal testimony?
That is correct.
And would you agree that that modeling and analysis, 1, satisfies the condition the public staff recommended, and 2, confirms the need for the proposed combined cycle facility in DEP to be placed in service in 1129?
Notwithstanding potential cost sharing mechanisms that we have to review or potentially implement, yes.
So moving on, you identify 2 other proposed conditions, 2 and 3, that relate to future fuel cases, fuel cost recovery considerations the public staff were taking into account at the time you developed this testimony?
Yes, and those 2 conditions are no longer necessary.
Thank you. And so that at the bottom of page 52, you have the Q&A starting at line 12. In the event that Duke's revised modeling affirms the reasonableness of the proposed location of both the Marshall CTs and Roxborough CC, do any of these recommendations become unnecessary? And you say yes, conditions 2 and 3 become unnecessary. And so your testimony confirming today for the record is that those conditions are no longer necessary?
That is correct.
Thank you. Turning to some questions briefly from Mr. Neal on behalf of SACE, you were discussing the topic of the 35-year useful life for the proposed facility. Do you recall those questions?
Yes.
And he asked you if the company had presented analysis in support of this CPCN application that established the reasonableness of the proposed 35-year useful life as being reasonable for planning purposes. Do you recall that discussion?
Yes.
And I don't know, do you have Exhibit 1B to the company's application?
Yes. Yes, we do.
Thank you. And just if you would please, so starting on page 2, the company establishes a statement of need for the facility, and then on page 5 has in section 1.4.2.2 a section addressing the operational life of the resource.
1.4.2.2, yes.
Yes, sir. And so that analysis supports the 35-year operational life of new gas assets as reasonable for planning purposes. I think that's the introductory sentence to the section. Do you see that?
Yes.
And it walks through how the company developed that 35-year useful life, why it views the optionality of potential utilization of hydrogen production, potential CO2 offsets, potential for carbon sequestration and storage, and essentially establishes, consistent with Mr. Snyder's testimony in this proceeding, that a 35-year useful life is reasonable for planning purposes.
I believe it is fair for reasonable planning purposes at this time, yes.
Thank you. And the public staff's modeling in the carbon plan IRP also used a 35-year useful life for the proposed facility.
That's correct. And another benchmark to potentially compare this to is when the company evaluates kind of like high cost sensitivities. One could look at a high cost sensitivity as a way to look at a shortened life of the asset as well, in which these resources were still being selected.
Very good point. Thank you. No further questions.
All right, redirect.
Thank you. Yes, Tom Felling with the public staff. Mr. Metz, Mr. Lawrence, find my question here. With respect to the question from Mr. Summers, where you discussed whether CC or CT was appropriate, and then with subsequent questions from Mr. Neal on that same topic, can you discuss if models from the prior carbon plan and perhaps even the CPRP have placed a CT or CTs in DEP?
Yes, 1 second. So within our testimony, starting on page 29, we listed the SP5 and SP5A. There was some discussions today about only one out of the approximately 11 or 13 scenarios selected these resources as the public staff's position of where these resources should be located. I'd like to walk back a little bit in time and go, without going into too much detail, of the 2022 carbon plan. And we talk about the portfolios P1 through P4 in that case. This was Duke's first model run using Encompass and first time looking at carbon compliance. There was multiple rounds of comments that evaluated the potential, let's just say, improvements that we can do to P1 to P4, the modeling assumptions that went into it. It didn't mean that Duke did anything bad. This was the first attempt. We just identified, and other parties identified, ways to enhance that modeling technology. For example, I think there was a specific challenge associated with how they were modeling solar and storage and how it was fixed versus how it allowed the model to economically solve for that solution. So when I take back and reflect on, well, only 1 out of 11, I think that's a misnomer. Some of those earlier ones, it's not apples to oranges comparison. Some of those in early portfolio runs, while directional, I would say they had some deficiencies, and I believe there was letters filed by Duke within the docket on how they agreed and how the information will speak for itself. So from my view, I look at it right now, it's a jump ball between SP5 and SP5A. We saw an inflection point of where just by some modeling assumptions, it can go from one direction to the other. So what is that modeling assumption? SP5 did not assume MVP gas. SP5A did. Well, I think you heard an argument today that, well, we have MVP gas now. That may be a true statement. We don't have that price today of what was modeled then. The costs that were modeled in SP5A in 2022 are less than the cost that we actually have. So I just take issue with the consideration that 1 out of the 11 was wrong. I'd say it's between 2, and SP5 is a closer proxy to reality of where we're at today and whether or not we should have been evaluating different resource outcomes, which did not take place.
Thank you. And turning now to the questions Mr. Breitschwert asked you on the conditions that the public staff was recommending as part of their pre-filed direct testimony. And regarding the recommendation for the cost allocation methodology, in your view, would it be helpful for the commission to issue an order requiring DEP or to work with the public staff to put forth a binding methodology to address those cost sharing issues that you've addressed between DEP and DEC?
Yes, and I would like to explore that thought a little bit further to the extent that the commission order, at least on a semi-annual basis, actual cost sharing mechanisms. Don't request that we just get together and talk, because we may be talking for 2 years and not actually reach an outcome. I'm not saying that will take place. It's just, I think it'll be informative to the commission to actually show of how parties are presenting ideas and solutions, or at least the pitfalls that we identify as we go through the process as we get to 2027. I don't want to get to 2027, the merger not happen, then all lo and behold of public staff, Duke, show us what you've been working on. We couldn't agree for 2 years. I don't think that'd be very beneficial in the overall process.
Thank you. No further questions.
All right, we will move to questions from the commissioners. Let me see who has questions for the public staff. Go ahead, Commissioner Duffley.
So I'm going to follow up on that last point. Can you state, just expand on the last point that you made regarding talking for 2 years and not coming up with a solution? What are you asking the commission to do?
So the company has agreed to work with the public staff, and we're establishing quarterly meetings. And I think that is a step in the right direction. My concern would be to the extent if the public staff has an idea and the company would disagree, well, where's the referee in this overall process? Just two parties disagree. I believe the intent of it is to work together and provide a potential solution as a worst case event to this commission on essentially day one, or be day two if the merger doesn't go through, prior to the large amounts of these investments actually being sought for cost recovery. What I don't want to happen is we get into a cost recovery docket and then we have to go fight about this all over again. So the extent that the commission has insight through that process, I believe it'll be informative to the commission to be kept abreast of this dialogue, conversations, challenges, and any other events that may transpire between now and 2 years from now.
So similar to the updates that the commission received when you were working on the interconnection queue and the changes to the procedures?
Yes, Commissioner.
Okay, thank you. And then one other question with respect to it was the Stace's question, should you have CTs versus CCs at Roxborough? It's page 23 of your testimony. Could you just expound on your answer to that question, please?
Yes, so looking at page 23, it was pointing back to how you would potentially high-level evaluate technology resources based upon within the industry. You look at a levelized bus bar cost curve. Basically, it's cost effectiveness. You may have a low capital cost asset, but as Mr. Snyder was talking about earlier today, it might have a higher heat rate and cost more on an energy basis. So let's just say it's a CT and you have a slope that's here, low capital cost, but the more you use it, the higher energy costs. Well, a combined cycle starts to go like this. You have high capital cost, better heat rate, better efficiencies, overall lower costs. So when you take, when you take these two slants, what's that meaning? Pointing at my wristwatch. That's that 40, sorry, that was that 40 to 50% factor I was looking at. If you were to take a pencil and look at the bus bar curves and draw everything out like engineers like doing, that's what that was representing.
Okay, thank you for that additional explanation.
All right, gentlemen, so we've heard your testimony in this proceeding. We heard you yesterday in the context of the CPCN request for the Marshall site. And you, as I recall, your testimony given in that docket as well, and read your testimony given in this proceeding, you have the same, let me see how you phrase it. I don't want to. You make the same conclusion, which is that there is I'm paraphrasing it right now, so you can tell me if I get it wrong. There's a need for CC and CT natural gas generation in DECs and DEP service territories. And disapproval of this CPCN application could delay interim carbon emissions reduction compliance and coal plant retirements set forth in the carbon plan order. So did I summarize your testimony, first of all, correctly?
Yes.
Okay. And you came to that, or you made that same finding in the Marshall proceeding, the Marshall CPCN proceeding, correct?
Correct.
Okay. And we've heard your testimony about the analysis done by the company or lack thereof, or incomplete analysis, I think was the term you all used in the Marshall proceeding, for the Marshall site and the Roxborough site and the resources the companies have selected for these two sites. I'm not entirely clear on what the public staff would have us do in each of these proceedings. And by each of these proceedings, I mean the Marshall CPCN proceeding and the Roxborough CPCN proceeding. What do you want the commission to do?
So in the commission's order, I think it would be beneficial to identify that the utilities are joint utility planning, even if on a non-firm energy basis. I believe that will enable the ability to potentially discuss and proposed cost allocation mechanisms when cost recovery comes before this commission. If that is not included, I'll be concerned that the argument may be made that the commission found the need and therefore cost recovery is therefore moot. Then you just look at the overall reasonableness of the costs. So that'd be the primary point, is the commission find it in the order that their joint utility planning, that at least the Duke Energy Progress combined cycle plant is in part serving Duke Energy Carolina's needs. And I can explore that more in Mr. Sammy Roberts' rebuttal testimony, and I can show you where the energy is coming from and the hours of day where it's coming from.
Okay. I would like you to do that, but before you go there, I want to ask you this question so that I don't forget it. So you are asking, you're not recommending that the commission not grant these CPCNs. Am I correct?
That is correct. If we don't grant the CPCNs, then there'll be a risk of reliability on the overall system.
Okay, so let me say it in a way that does not include double negatives. The public staff is recommending that the commission grant the CPCNs in both of these proceedings. Is that correct?
That is correct.
Okay. So we've talked about, and you all, there's been a lot of testimony over the past couple of weeks about the planned merger that the company anticipates will take effect in 2027. Do you know what I'm referencing?
Yes.
Okay. Does that, let's say hypothetically the merger is achieved as the companies foresee and plan for. Does that ameliorate your concerns? Does that resolve your concerns about allocation of costs across the, well, it would then be one system, but across the separate, what had been separate systems?
It would resolve the equity concerns, yes.
Okay. And so I hear you say the equity concerns, but concerns about, does the public staff have concerns about prudence here? I mean, do you foresee coming to the commission at some point in time and making a recommendation for disallowance of costs on a prudence basis? And I'm not asking you to speak on behalf of the public staff if you're not authorized to do so, or if you haven't gotten there, but I'm just trying to understand where the public staff is going here.
I think it would be dependent upon the commission's order on whether or not we would make an argument of potential cost disallowance of imprudence.
Okay.
I don't mean to punt the ball back into your court, but it's the structure of the commission's order would be determined, would help determine or aid our next potential recommendation.
Okay. And I want to pursue this a little bit farther with you because I hear you all expressing concerns about the equity, the energy equity. We've talked a lot about that today, and we talked about it yesterday. And then you all have discussed, and Mr. Lawrence, testified to this yesterday. He's testified to it again today, and you all have touched on this in your pre-filed, the concerns you have about the siting decisions made here in this case and in the previous case. So to the extent the commission finds that the utilities are engaged in joint planning, does that absolve your concerns about the siting locations? I guess just sort of walk me through step by step your thought process here so I can understand it.
So even if the commission was to approve that or find that the utilities are joint utility planning or some derivation of it, it wouldn't resolve the items that we identified and kind of this identification of predetermination of location of where to build. So I think that's where we listed the potential ongoing reporting of the actions that the company's making for the future generation assets. However, noting that once we start down this path, the dominoes are going to fall.
And so I understand sort of you all want more, you're asking the commission to direct the companies to include the public staff earlier on in the analysis or in the decision-making process about the, well, let me say it this way. As I understand it, you're asking the commission to direct the companies to make you all aware of the work that the companies are undertaking with respect to siting earlier on in the process. Is that?
Yes, inclusive of deliverables, looking at cost benefits or cost assumptions or planning assumptions that were used as those sites or locations were in or screened out through the process. In other words, let's not get to the end where before this commission and then debating whether or not it should have been at this plant when 6 months have passed by or whatever time it is from pre-filing to the order and the company now needs to execute contract.
Okay, and I understand that. So you're saying let's from the public staff's perspective, let's not repeat the situation the public staff says it finds itself in at this point in this proceeding. Is that correct?
That's correct, but I think the reality is that we'll be in this circle for a little while.
Why do you say that?
To the extent, based upon our review and when actions were made, going back to some of the dates that I listed in my testimony, we're already going down a path of where future resources are going to be selected.
But help me understand, Mr. Metz and Mr. Lawrence, chime in here too. So the companies, as I think about it, we're up against a couple of things here. We've got H951 that says you've got to meet carbon reductions by X date, and there's an interim target, and there's a compliance deadline. So we're working towards those compliance timelines. And then we've got the natural progression of the coal facilities, and the companies have engaged in analysis about when those coal facilities need to come off, and they've presented to us evidence as to why this facility at this time. So we've got to deal with those deadlines as well. So when they need to get those plants offline. And now we have sort of this extra complicating factor of Clean Air Act 111 rule, and that may kind of tweak things a bit or maybe not. But so how do we, I'm struggling to understand as a practical matter what more you want the companies to do in terms of helping you all better understand decisions for siting locations. Because as I hear the testimony they give in these proceedings, they're taking off units, they're making the decision to bring units on in those same locations, and they've given us a bunch of reasons why, and you all note some of that in your testimony. Sort of, what more do you, well, I'm asking you to rehash a little bit, but as a practical matter, what more can they do to resolve your concerns?
So to start out, there was a lot there.
I know, I'm
To
sorry.
start out, prior to House Bill 951, we were having these conversations about coal retirements. This goes back to 2018, or I even filed comments or testimony. I can't remember saying, hey, I'm being very general here. Duke wanted to accelerate the coal retirements. Public staff said, no, you need to evaluate the transmission system before you start shutting down all these plants. Duke provided it, and we identified some localized constraints, which I'll talk to more in detail in a little bit, especially based upon Commissioner McKissick's question. As time has progressed, we continue to reevaluate the coal retirement dates. But we had a new factor in setting aside HB 951 and interim compliance and what year that exactly takes place in. Well, you can see through all the portfolios, whether it's 2030 or 2037, 2038, or even the P0 plan that we talked about in the CPRP testimony, these natural gas resources are being added, from my view, in a large portion of the near 9 gigawatts, 8.4 gigawatts of coal assets that are being retired. I mean, so stop. What is the primary driver of the gas plants, at least the initial phase, talking about the 3 combined cycles and some of the initial CTs that the companies listed in the CPRP? It's to get back to the system that we're getting ready to retire. Then we're going to be adding on the additional resources. That's more, from my view, the combined cycle 4, 5, and 6 discussion. The EPA and the interaction between the EPA or Clean Air Act and HB 951 created another quandary to work through. However, even if it means higher cost to ratepayers with the EPA Clean Air Act, sorry, I keep using those interchangeably, occurs, is still identifying these resources, at least what we're talking about today, and the model results that we have in our testimony speak for what are the common resources. These are common resources that are being selected, even if it's not ideal. When I say ideal, it's saying EPA may cause higher costs, and these new resources that we're building might actually provide benefits to ratepayers, and now we can't get them. We still have to get them. Duke's modeling and public staff modeling comes to that conclusion.
When you say we still have to get them, you mean we still have to bring these resources online?
That is correct.
Okay.
The argument then becomes of where exactly we build them and what decisions were made and when the decisions were made. I think I've explained that one thorough enough. Going a little bit on a different direction, part of the evaluation of these resources and this need in both Marshall and Roxborough is looking at the localized transmission system. Based upon our review, a CT in Roxborough would have resolved a localized transmission issue. We've had multiple discussions with the company on this matter. And the combined cycle would have resulted in near the same conclusion on the localized transmission constraint that was occurring there. So possibly going over to Mr. Summers' direction on what additional factors can the commission consider that's not least cost, or there are local transmission items that we have to consider when we're retiring this much generation, or if we look at large load customers are connecting onto the system. I consider those externalities that just aren't the foundation of these costs, but it's reasonable utility planning. I feel like there was 2 more questions that you had and I trailed off.
I mean, I think you've answered what I asked, or what I was trying to ask.
I remember, sorry. You're saying, well, what are we trying to do better, in my words? Transparency in the process so we can get through this transition in a timely manner and use all of our time effectively and for the benefit of ratepayers.
Okay, and I'm willing to bet that Duke would say the same thing. I mean, Duke would say we are trying to do the best, we're trying to do this efficiently in a way that benefits ratepayers and, configures the system in a way that it has to be configured to serve customers. But be specific. I mean, what exactly is it that y'all need to see? Or that you need the companies to do, or that you need the commission to do, to be in a position to complete the analysis that you all are going to have to complete going forward?
That is a very great question, and there's not a one-size-fits-all solution to that because it's dependent upon the facts and circumstances in that case. There could be a large load customer that caused a potential voltage condition on this part of the system. We need to look at those facts and circumstances in that case. As I talked about 2 examples in this case, there were identified transmission issues. We went through the utilities while it wasn't exactly clear in the application, but through discovery, we were able to get there. But noting that those conversations stemmed from 2018 and looking at the coal plant retirement analysis. I don't have a one-size-fits-all solution because a 1,300 megawatt plant is different than a 200 megawatt battery. It's different than a 200 megawatt solar facility. It's different than an energy complex that may have multiple SMRs. It would be different for an offshore wind facility. It's a very fair question, Chair Mitchell. I don't have a one-size-fits-all solution.
All right. Well, my hope is that, well, let me ask the question this way. I mean, do you foresee the company and the public staff having to engage going forward on a number of resources that are going to have to be constructed and brought online in a sort of relatively short period of time as a result of the retirement of these coal facilities?
Yes, we will be.
Okay, so what is it the case that what you're asking for in this proceeding, you're looking for some guidance and for some governance for those for that conversation that has to occur going forward as the company moves towards the execution phase of this transformation that its systems are undergoing?
That's correct. We found some stuff we didn't like, and we're hoping transparency and leadership of this commission will enable and mitigate that future reoccurrence.
Okay, well, you have to make sure we're entirely clear on what you are asking for so that we can provide guidance and help resolve issues that might exist between the public staff and the companies. That's so reason for my questions. Let me see if there are any other questions from commissioners. Okay, go ahead. Commissioner Duffley.
And so what I heard, what I think I heard, and I'm just clarifying, the CCs and the CTs, the first 5 you say are too far down the road, but this type of request is for any future build after those first 5 units?
Well, if I said 5, apologies, that wasn't my intent. I would say generally at least for the first 3, 2 or 3. Based upon the timing, when you look at the construction schedules that the companies filed in, you kind of benchmark that to the pre-filings for the CPCNs. I would say, yes, generally at least the first 2 are predetermined, and it's likely that third one is also now predetermined.
Okay, thank you.
Commissioner Kissick, go ahead.
And perhaps you could address this, and I raised the question a little earlier, and they said the best person to ask was going to be Mr. Roberts when he came up. But what type of voltage problems are existing in that area at this time that are problematic, that are going to be addressed by the CCs going in, but likewise, we're going to be exacerbated by the retirement of the coal generating facilities? And I'm not aware of what they are, what they consist of, the magnitude. But perhaps you can address that, because I'd like to try to put the pieces of the puzzle together and to see how that might impact siting or other considerations.
So keeping it not confidential, I'm looking over to Duke
Okay.
here. I'm going to tread very carefully.
Looked like a positive nod.
Brett became the transmission expert as Dustin goes rogue.
I usually ask people to speak rather than to nod, so they can record it in the record.
So oversimplified right now, we have a large amount of generation north of a large load center, which is Wake County and Durham. If you remove half or part of that nameplate generation, you would essentially create a low voltage scenario. There's other things that go into that as well, but in short, you'd either have to rebuild key integral parts of the transmission system to get that energy back over into this part of the system, or you replace that with the replacement generation in the northern part of the system to prevent that that voltage sag possibility.
But the way the reference was made in the testimony that I reviewed, it was indicating that that was already a pre-existing problem.
That is generally speaking, that is already, there are multiple parts, and so I'm being more careful with the confidentiality. There's multiple parts to the aspect. There are key parts of the system that have, say, tighter tolerances on this voltage deviation. Let's just say those are core elements that will always have to be addressed. There are other parts where they're important. They're not as critical, but can fall outside of this nominal bandwidth that we should be planning to during severe planning contingency, which system operators have to plan to, so they start fixing those issues before they come to reality. But you don't want to get to that one critical item that I keep hinting around.
Got it. I think that answers my question. And let me just ask this, and I guess we can wait for rebuttal, but I do have concerns about this design build approach and the implications and the complexity of it. But I suppose I'll just wait for Duke's rebuttal to come up to begin addressing those, and to see what your thoughts might be as a staff.
And sorry, going way out of turn, I believe Chair Mitchell, if you wanted me to talk about the energy flows and Mr. Roberts' rebuttal testimony.
I think Commissioner Kim Wright might ask you some questions about that.
And Mr. Metz, before I ask you those questions, following up on Commissioner Duffley's questions about transparency, I just want to make sure that my understanding is correct about the proposed CCs and CTs under the stipulation. So we have CC1, that's the application that's before us today, which is located in Person County. CC2 is another 1360 megawatt facility that is being potentially being proposed, the same location in Person County. That's my understanding as well, pursuant to the stipulation. And then CC3 is the facility that is proposed potentially to be located in South Carolina. My understanding from testimony during the CPIRP is that that it would be a greenfield site and that a location has not yet been selected. Is that your recollection as well?
Speaking for the South Carolina site, that is, again, my general observation. Then that would get back into looking at the transparency as saying, well, when was that site selected? I mean, well, I haven't done that investigation, so I can't speculate, but why didn't we investigate W.S. Lee? Why didn't we investigate these other areas? Why is it being proposed in that area? And then that goes into further when we're looking at proactive transmission upgrades. We're getting ready to build a large generator and an integral part of the system, but yet we're proposing ours at 2.0 upgrades.
Right. And then in regard to transparency, my understanding is for CT1 and CT2, locations have been generally selected, but CTs 3 and 4 locations have not been selected for CTs 3 and 4. Is that your understanding as well?
And we're talking about, if in regards to CT1 is 400 megawatts and CT2 is 400 megawatts, then yes, that would be the Marshall plants. I do not know where CT3 and CT4 would be located, just why I'm clarifying it that way. Sometimes CT1 is referred to as a block, which is 2 400 megawatt units.
Right. CT1 is 425 megawatts. CT2 is 425 megawatts, both at Marshall.
That's correct.
But I think I was just bringing that up about transparency, that there are some locations, some CCs and CTs where sites have not yet been provided to the commission for your concern about transparency of location of particular site locations.
That is correct.
And then two more questions. According to the amended stipulation and the CPIRP, Duke and the public staff have agreed that 3 CCs are reasonable for planning purposes. If CC2, which is the second CC of 1360 megawatts, is to be included in the same Person County site, can you provide your opinion on planning for CC2 after CC1 and the potential inefficiencies that this might cause with respect to additional infrastructure build out? That's a complicated question. I hope you got it all.
So maybe I can talk about the potential of synergies if, let's just say we go down the path of where Roxborough Combined Cycle 2 was built on the heels of Roxborough Combined Cycle 1. Setting aside of whether or not it should be built in that time and whether it actually aligns with the coal retirement dates or not and the actions that could have got here, apologies for all the qualifiers. I think it would be synergies to say, well, you have a construction crew. You're going to transition from point A to point B. My assumption is that Duke would leverage those synergies with the EPC contractor or the OEM vendors to say, look, can we get a quantity discount for buying a little bit more? Duke will already have their management team or project management team deployed. There will be trailers there. There will be synergies with, all right, let's just go ahead and clear the entire land for both combined cycles. So once you kind of start down this process, there could be inefficiencies if you do pivot at a later point in time, or if you don't min-max or maximize on what you can build when you're building it. For example, I think that's why we're looking at the Marshall of saying, well, on paper, it looked like there were 2 CTs in a combined cycle. Where's that combined cycle plan? Why aren't we talking about that? Where are the benefits to ratepayers if we go ahead and move forward with that combined cycle plan? We only become alerted to it because it was in the application.
And are there any additional concerns about inefficiencies that you would have for citing CC1 and CC2 on the same Person County site, just in case there's any additional concerns that you have?
No. Again, the other efficiency would be able to utilize that T15 line that was discussed today, and I have it highlighted the cost savings that would occur to the extent that combined cycle 2 moves forward at Roxborough, the confidential information.
Okay, and my last question is, if you can turn to page 16, lines 13 through 18 of your testimony.
Is it page 16?
Page 16, lines 13 through 18.
I'm there.
Okay. And on those lines, you state that prior to the CAA rule, the public staff's modeling showed that the proposed CC would run at an 80% capacity factor. And to comply with the CAA rule, the CC's output would have to be reduced to a 40% capacity factor. So from a system operation perspective, can you explain how the CC output will be limited since Duke has never had to cap the capacity factors on their CCs previously?
Not to be flippant, that's going to be one of the interesting challenges that still need to be figured out. Don't know if we have to have perfect foresight and run it over 40% over the entire year, or will, not speaking for Duke, but just looking at a hypothetical, will Duke kind of hold it in reserve to say, well, we need this asset to be available for the entire winter, and the system will run how it's run, and maybe we have to retire it for the rest of the summer. I don't know. I think a lot of guidance will also come out when the state implements its plan, which was discussed in more detail in Mr. Nader's testimony in the CPIRP. Further compound, I don't have familiarity enough with the potential state plan or the Clean Air Act. If it's on a rolling 12-month or a calendar year, there might be more details in there that might mitigate some of my observations.
Okay. Thank you. And on rebuttal, perhaps one of Duke's witnesses might want to provide their thoughts and opinion about that as well.
All right, Commissioner Tucker.
Thank you, ma'am. Mr. Mess, I'm confused. I'm new, so I'm confused. complex what we do here, and it's very difficult to try to absorb all the information. The one thing that concerns me from a high level, you constantly mention the word transparency. And transparency concerns me in the fact that you, and I don't mean to put words in your mouth, you may be alluding to the fact that Duke doesn't give you all the information you think you need, or Duke and you and the public staff can't get an agreement on what you think you need and what they think you need. And then you use the term dominoes. And I'm a debt hawk myself, having run a business for 20 years and knowing what debt can do. And Duke has enough to manage now. And you talk about it when it starts, the dominoes start falling and you start spending all the monies. And then there's not enough cash flow to cover the interest payments that are due on this massive amount of debt that 951 causes us to have to go through at a fairly rapid pace to find over 8,400 megawatts of coal retirement megawatts. What can this commission, kind of where Chair Mitchell was going, what can we do to help you and to help Duke come together to have a sensible look to where you looking out for the consumer, they're looking out for 951 because they're under the statute to resolve that. Where do you come to an agreement, or how can we help you come to that agreement? I mean, I think this commission cannot approve some things that Duke really wants badly, or we can not do some things that you adamantly suggest because you impair the ability of Duke to pursue 951. Where's that meeting in the road that you two entities can come together, and what steps can this commission take to make sure that happens?
So good questions. So on one item, I think we need to put in our proposed order a lot more context and reasons why on actual actions for what can we actually say at what points that we need for transparency. We'll take that as an action item. We'll put more detail in a proposed order to give explanations why and to increase the overall transparency. Generally, I just want to prevent getting back to this same point in time and saying, well, you should have looked at X, you should have looked at Y, and we can't make this conclusion. We could have had these conversations over the course of through this planning cycle. I have the dates. Some of the dates are listed in there, and maybe we just need to be, say, for example, for the combined cycles that are envisioned between this time period, the public staff and Duke shall work together and provide siting analysis, more information that I need to put a little bit more pen to paper to. We can limit it to certain technologies. We can limit it to a time period, and we can put pen to paper on the exact items that we want to see. Another aspect that you discussed, and it is my understanding of your question, Commissioners, well, dollars. Well, dollars aren't really falling right now, generally. What we're talking about right now is just the CPCN and looking at the potential need and the reasonableness of it. I think when we actually get the cost recovery, I think that's when it maybe, not trying to put words in your mouth, Commissioner, I think that would be more probably detrimental to the company, because the company is going to go forward with this path because it's an investment and the balance the interest between shareholders and ratepayers. Well, if we start trying to take money out of, say, Duke's pockets or shareholders' pockets, then that's a different discussion, because Duke wouldn't be getting recovery from those costs, so they're at risk. So we're trying to prevent that from even occurring. I think that's a strong message to get across here. Looking at the transition of the generation fleet is highlighted within the CPIRP, even without 951, is also identified to this commission for some of the newer commissioners. This is this launching point from something that we started, at least from my time, as back as 2018, if not prior then. We all knew that these plants are going to be reaching the end of life. Is this the company? I mean, and and giving credit to the company says, look, we need to start having these discussions. And we started really having those discussions in 2018 to how we plan for these retirements. Did I answer your questions, Commissioner?
Yeah, but I don't want Duke's always been great financially over the years. They're a good company. You're not saying that. I'm not saying that. Public staff is here for the consumer and to have the consumer look out for the consumer and what ratepayers have to endure. But if you're not getting the transparency and the answers that you need from Duke and Duke's, kind of going their way, and I know there can be disagreement. I understand that. You think there ought to be a CT in Person County, and I heard you say CC's at Marshall. Is that correct?
Yes, sir.
So, I mean, that's a major divergence of opinion, how you guys can come together rather than them making an edict. We're doing it this way, and public staff, it doesn't matter. I just, would like to see a more cohesive working relationship between the public staff, because you got to look out for the ratepayers and the public. And then we in turn are, in my mind, we are charged with the responsibility of listening to you and understanding from you and really receiving what you have to say to us with a great deal of seriousness. And then Duke on their side has that too. And then we've got the 951 pushing us all as well. So, I mean, it really, I guess I'm talking to both of you to help us understand what we need to do to make sure you guys are somewhat on the same page in what needs to be done. And then the interveners, sit and look and can poke holes in things when you guys have divergence of opinion, et cetera. So, tell Chair Mitchell as much as you can, or she between Mr. Ayers and Chair Mitchell, what, needs to be done so that we can work with Duke to be able to get there. I don't know what I've said, but I'm just caution, because I see, what debt has done to a lot of public utilities throughout the country. And, we've got to spend this money and we've got to replace those coal plants and we've got to reduce carbon and all of that. But still, is the pace too fast? Is it, getting to a point where, the rates are going to go up incredibly high for a lot of people? And many of the percentages tell us there's a great group of people who can't pay their power bill now that needs assistance. So I'm just asking for, both of the entities here, Duke and public staff, to be able to disagree, but come to an agreement and a compromise where you can make me feel good that they're not spending money that they don't need to, and they're not overbuilding. And then we want to do our very best to keep them financially solvent for the markets and for their investors so that, we've got a solid utility here that keeps moving. I mean, for years, Duke's been the most competitive in the country with electric rates, and I'd like to see that continue on as we move forward. And that's very much the reason why the load growth is here, is because they have done a good job. You've done a good job in working with them and over the years. And that's why those companies are coming, along with all the other things that we've done with taxes and regulations and all that. But we're getting overwhelmed with it. I just need to feel comfortable that you're comfortable. I enjoy Mr. Snyder and Duke folks telling us what they need to tell us, but I'm trying to dice out what's real and what's not, but I know what dollars can do. So I'm just overly cautious perhaps when I hear dominoes and lack of transparency. I can't get to feeling good about all these plans we have in front of us. So I'll stop there. Chair, thank you.
All right, Commissioner McKissick.
Yeah. And I'm going to shift gears with you a little bit and go ahead and ask you a couple questions now. Earlier today, we had Mr. Smith testifying on behalf of Duke, discussing the whole process they're going through with pre-qualified bidders, to look at, the way that the work would be done in connection with the proposed project. And likewise, they're working with, as a separate group, I guess, of what I'm going to refer to as equipment manufacturers, those who will be actually, I guess, building the CC units and to kind of come up with, what they would consider to be, I guess, the best value bidder. Now, we also had a witness come up and discuss things on behalf of, I'm trying to remember his name now, before lunch, it was Mr. James, who testified, who was somewhat critical of this design build approach, not in and of itself because it was a design build approach, but because of a lack of specificity or parameters. And it seemed that he was saying they were going out too early in the process. So could you comment upon the testimony that you've heard from those two and share with me your thoughts and observations about the design build approach that's undertaken right now, whether it has a appropriate specificity or guardrails to kind of protect the public interest, and likewise, the way they're approaching this whole situation with the best value bidders, and whether the testimony we heard from Mr. James has concerns you or the validity of what we've heard. I mean, I know that's a kind of a large question with a couple of subcomponents, but do your best to address it.
So I think both methodologies are correct, if that makes any sense. So
they deserve a degree in diplomacy. Go right ahead.
Mr. James especially has much more industry experience than myself, but how I interpreted his testimony, especially being the consumer advocate, I can see the benefits with his approach or methodology, at least my understanding. That doesn't mean that Duke is wrong per se. That absolutely. I mean, we discussed this during the MYRP. I want absolute dollar values right now in hand with estimates to move forward with projects. But where's that balance of that's a project 3 years from now? You're not going to get an estimate in hand. This is a multi-billion-dollar investment. Yeah. Should Duke come in and actually have executed all the EPC contracts and have everything in hand or done some of the studying analysis themselves? Possibly. But there is a track record of Duke and Dominion of their cost estimate methodology. While imperfect, it is industry practices to kind of look at these bounds. And that's why I listed in my testimony. I list that upper bound. But then how we evaluated is we went back to when was this need established? So we're revalidating the need in 2023. Duke ran that upper cost sensitivity, which from my view captured the upper bound of the cost estimate, which therefore validated the reasonableness to move forward with this project. So while yes, it'll be great to have more information in hand, there's also a balance of when the utility needs to come in for a CPCN and while moving in parallel and taking on that risk. So in summary is I don't find Duke's approach incorrect in this case, but I understand the rationale that Mr. James was discussing.
That's helpful. Thank you.
All right, Mr. Metz, did you want an opportunity to respond to Mr. Roberts's rebuttal testimony?
Yes.
Okay. Please do so.
Looking at Mr. Roberts' rebuttal testimony on page 9, I think it's figure 2, we look at the hourly transfers. I done similar analysis looking at the hourly transfers on a month, the hour, etc. But this is a good illustration. And I'll try to explain it of what we're looking at here. So we've had some discussion of like, well, when are the energy power transfers occurring? Apologies, let me start over. When looking, you have the hours on the bottom. So that's displaying is 1 is 1 a.m., 6 is 4 or 1600 is 4 p.m. military time. So it's just saying on a yearly basis, we sum up all the power flows per an hour. And on the y-axis, we have a limit of for modeling purposes and real world, we have a limit where we can transfer energy from DEP to DEC, the transmission system. So on the y-axis, we look at the percent of the annual limit. So if we're at 100%, that let's just say hypothetically at hour 1300, if that bar went to 100, that would mean in every hour of the entire year under study that we hit that maximum limit. So when you're looking at this chart, you can see over time. So looking at present levels, which is for my view, it's a darker blue line, you can kind of see that trend line of what hours and how much power transfer is occurring. Yes, it is a solar shape. That's just the realities of the generation assets that we have in our system, which are in part because of the successful development of QF energy, etc. That's just our system. But my takeaway from that is it's just not occurring during daylight hours. It's occurring at night. So from an economic dispatch, you can start to take away of where we sit today, approximately 2025, the energy transfers that are going from DEP to DEC are occurring in non-daylight hours. Then the different bar graphs show over time of how that trend increases. And maybe eventually, if we execute everything within the carbon plan to 2040, we would get back below 2025. But that in itself brings a lot of uncertainty. So when you're looking at 2030, so 2030, which is the teal, close to Carolina blue color in those lines, is with Roxborough 1 and Roxborough 2. You can look at the massive amount of transfers that are occurring during non-daylight hours, but then you also have to factor in when the transfers are occurring. So I think in my testimony, when I say, when looking at the Encompass modeling, which one was benchmarked to reality, I took present levels and compared it to the 2025 run. They were near identical. So it's like, hey, Encompass kind of dispatching the system how we actually work on the system today. I thought that was a very valuable tool or a very valuable data point. Over time, we're continuing using more resources that are being generation from DEP to DEC. When you're looking at the transfers, approximately 2030, 2035, 90 to 96% of all hours in the year, energy transfers are coming from DEP to DEC. It could be 1 megawatt, it can be the full limit. But you can see is like, it's not 1 megawatt. These are large percentages. When you look at the amount of total transfers based upon our analysis, that at the maximum point of time, which is approximately 2030, which aligns with this graph and that teal line, 25%, approximately 25% of the energy generated in DEP is but to serve DEC. That is that growing equity concerns. The combined cycles are a part of the equity concern. They are not the sole contributor. They are just a part of it and a contributing part of it. In pre-CAA or EPA 111 compliance, these resources are the most economic, so therefore they'll be dispatched first. They're the most economic on a DEC and DEP system, so we'll dispatch them first in DEP with all those fixed costs that we talked about, the O&M costs that we talked about, the transmission cost to maintain the transmission cost, etc. But yet DEC isn't paying for some of those base rate items. That's the heart of the equity concern. And just looking at those power transfers, from my view, the commission to take away, it's not just solar. Solar contributes. It's the aggregate of resources that exist on the system today and the additional resources that were added that are especially highly energy intensive, like combined cycles that transfer power over to DEC.
All right, thank you for that additional explanation, Mr. Matz. All right, let me see. We're getting close to our break. Why don't we go ahead and take a break now? We will take a 10-minute break, so we'll be back on the record at 3:50. Let's go off the record, please. All right, we are, questions on commission's questions. So I'll look to, let's see, Duke, any questions on commission's questions?
We do have a few.
Okay, go ahead.
Thank you. So, Mr. Metz, good afternoon again, Mr. Lawrence. Two topics. First, with some discussions you had with Chair Mitchell about prudence. Do you recall that discussion?
Generally, yes.
And you had some conversations with Mr. Summers and I think Mr. Neal earlier about the legal standard, recognizing you're not an attorney, that this proceeding is about public convenience and necessity, and evaluating the need for the facility. Is that right?
Correct.
But you opined in response to Chair Mitchell's question on the concept of prudence, and you generally understand the legal framework and standard for what prudence is intended to represent. Is that accurate, recognizing you're not an attorney and you have a lot of experience in rate cases before this commission?
Correct.
And so you were asked directly by Chair Mitchell whether the public staff recommends the CPCN be granted. Do you recall that?
Yes.
And you said yes, correct?
Correct.
And recognizing that this, as I think you later said, is a multi-billion-dollar investment that the companies are planning to make to serve the ratepayers of DEP, you understand that if the commission grants the CPCN, the companies are obligated to move forward with construction of the facility. Do you agree with that?
I would say you're obligated to move forward at all costs. You would have to check and adjust to the extent something was
Absolutely.
identified.
Yeah, and I'm not trying to trick you up on this. If the costs change materially, there will be annual updates. We established that earlier. But if it's determined to be needed by the public convenience and necessity, the company's obligated to move forward constructing this facility to serve the energy and capacity needs of the customers of DEP, correct?
In part, yes, but from my view, at least the energy is also for DEC needs in this case.
Okay, but you equivocated when Chair Mitchell asked you whether the public staff who supports the CPCN being granted today might in a future proceeding make a disallowance recommendation based on some basis of imprudence. Do you recall that conversation?
Yes.
And can you clarify the public staff's position if you're advocating the company be granted a CPCN and spend billions of dollars today to make this investment on behalf of customers? What might be the rationale in a future proceeding to argue for imprudence?
I'd just object to that question to the extent that it calls on Mr. Metz to speculate as to the position the entire public staff would take in a future proceeding, recognizing that he's an engineer, doesn't have the facts of that case in front of him for him to be able to evaluate and say what the public staff potentially could do in future dockets.
All right, I'm going to overrule the objection. Commission recognizes that the question as asked requires Mr. Metz to speculate, and will give that testimony the weight that it's due, recognizing that it's Mr. Metz's speculation.
So from speaking on one aspect of from engineering, to the extent that we evaluate the project and we find that costs were not needed, or I think the terminology is often used gold plated, or we necessarily just didn't agree, or lack of project documentation, we would recommend for potential disallowance of incremental costs associated with those identifiable items.
Okay, and so setting aside the potential that the company made some investment as part of constructing the facility that was unreasonable or excessive, just to be clear, the company's view is this is the facility that establishes the need for this major combined cycle investment, CC1, in this critical execution period the companies are moving into as part of the CPIRP, where there's going to be many investments to be made. And that's part of the conversation I think you're having with the commission. And wouldn't you agree that it's crucial as the company goes out and plans to make these investments that there is clarity on the need for this facility, the public staff's position on that need, and that there's no ambiguity that in some future rate case, there might be some allegation of imprudence, as this side of the room heard you suggest you may make in the future, based on the commission's determination of need at this point in time.
If the determination of need is joint, that the resource is for joint utility planning, which in my testimony, that it is joint utility planning, the reason need for this project, to the extent that that is providing a service to DEC ratepayers as time would move forward, it could be a possibility that we would recommend disallowance from Duke Energy Progress, and then it may entail that Duke Energy Carolinas be able to somehow recover those potential costs. However, understand that through the merger agreement that we can't do joint ownership, and there have to be other legalities that would have to be investigated and reviewed at the time that we would potentially make cost disallowances or yes.
And just point of clarification, your testimony never uses the phrase joint utility planning, correct?
That's
You-
my
you
testimony
speak-
as I'm here today. The need for the project is because DEC and DEP are on an energy basis joint utility planning.
But you speak to energy transfers flows from a combined cycle built by DEC to serve DEC's capacity need, but delivering energy to, strike that, a combined cycle facility built in DEP to replace coal generation in DEP and serve DEP's capacity needs, but delivering energy to DEC. But you don't use the phrase or establish the concept of joint utility planning in your testimony. The words on the page don't use that phrase. And you can accept that subject to check if you like, but I think it's important because the company can't enter into joint utility planning, as you noted, based on the merger proceeding, which requires each of the utilities to plan independently for their capacity resources. Would you accept that statement?
I agree with the latter. I'm looking back at for the prior.
Okay.
Mr. Bryshword, I'm gonna interrupt here. For clarity of the record, you've been referencing merger proceeding. And you might have been clear and I just missed it, but can you specify the merger that you are discussing in any relevant orders that are, to the extent you know them off the top of your head? If you
I
okay.
don't know the date specifically, but I think as there was some discussion this morning, this is a merger of Duke Energy Corporation and Progress Energy in 2012. And so the commission established merger conditions subject to check 3.4, maybe the merger condition that established independent capacity planning between the two operating companies.
Okay, thank you.
So on page 49, looking at line 11, the monitoring results in the 2022 carbon plan proceeding completed by the companies and the results from the CPIRP identify the capacity and energy needs of DEP. Noting the increasing power transfers from DEP to DEC illustrate that DEC requires significant amounts of additional energy. So based upon our analysis and our review, that the interrelationship between combined cycles and CTs on an Encompass modeling is looking at it from a joint utility. The capacity needs are resolved for DEC independently. The capacity needs for DEP are resolved independently. However, the modeling allows the economic transfer of energy, and we optimize those resources on least cost in that aggregated fashion.
Okay, thank you. And to just ask it one more time. So what would be the basis for an imprudence disallowance where the company builds this combined cycle as supported by the public staff and as directed by the commission through a CPCN order in a future proceeding?
Sorry, again, I would renew my objection to speculating on future basis that the public staff would take in a case that hasn't even been filed yet.
I'm going to overrule the objection. I hear the question as well.
If he'll withdraw the statement that may make a prudence determination, I think we would accept that. But it's concerning from the company's perspective. I'm sorry, I'm testifying.
Just respond to the objection, Mr. Bryshword.
I think you've already overruled the objection, so I'll.
Well, I overruled it once. Now he's renewed his objection, so I have to rule again.
And just for clarity, Mr. Metz did not say that we will make this. He said that we may. And so may means that we also may not. So he's asking as though it will happen.
All right, I'm going to overrule the objection. I'm going to allow the question. And Mr. Metz, do your best to help council understand what you meant when you made reference to a potential disallowance. Again, this commission recognizes that this question calls on you to speculate, but just help counsel for Duke, to the best that you can, understand what you meant when you made that testimony previously.
Please re-ask the question.
Absolutely. So setting aside any potential that the company during the construction phase takes some unreasonable action or something that the public staff in your investigation says is unreasonable or in that limited scope imprudence what would be the basis for you to suggest today as the public staff supports this CPCN application and supports commission issuance of the CPCN that in a future proceeding, the public staff might take the position that the companies were imprudent in moving forward with construction of the proposed facility? Can you clarify or explain your answer? And perhaps we misunderstood your response.
So if I did say will, that was an error on my part. It would be may, because you would have to review the facts and circumstances at that time and whether or not we could even make a cost disallowance, even if we believe that there one could be in place. I would have to consult with the attorneys, accountants, and other engineers to make that finite determination. I can't speculate as to absolutely what we'll do in the future. One, it'd be contingent upon the commission's order in this case, but then two, we'll have to review the facts and circumstances, and to the extent any circumstances had changed during that evolution. Say, for example, if Duke was to sign a large load customer tomorrow, that may mitigate the observations of the power flows. And then, yes, that resource with that change in the forecasting may result in a different outcome than we sit today.
Okay, so recognizing here as we sit today that the public staff is recommending the commission grant the CPCN and for the company to move forward with construction of this generating facility to serve customers, you don't have any basis today to suggest that you would make such a recommendation for an imprudence disallowance in the future that's based on potential change circumstances or limited scope of events that may occur in the future. Is that your clarified testimony?
That is correct.
Okay, thank you. Also, another very important topic, you had a conversation with Commissioner Tucker about transparency between the companies and the public staff. Recall that?
Yes.
And critically important issue as we are entering this critical period of significant execution for the company to have a clear and executable plan. That was a key component of the company's carbon plan IRP, and for the public staff to have an understanding of what that plan is. You agree with that?
Yes, I even believe my testimony in the CPRP or someone in the public staff used the terminology glide path. The company needs at least some, not foresight, but some directional guidance on how to implement this very aggressive and challenging plan.
Absolutely. And I think you had a conversation or some questions from Commissioner Kimwright about the level of detail in the resource plan and what CCs and CTs were being cited where based on the execution plan. Do you recall that generally?
Yes.
And would you agree with me that the execution plan in this CPRP and the supplemental planning analysis presents a really unprecedented amount of detail, especially when you compare it to the old short-term action plans the companies would present back in the day when Mr. Summers was in charge?
I have reviewed historic IRPs and they did not consist of the pages that we have today.
And so the intent of that detailed execution plan is to provide the transparency that the public staff's looking for.
In part, no. It provides high level information. The information that we're requesting and trying to clarify is when the decisions were made, what additional analysis was completed. Because, for example, I wouldn't expect the IRP to go into that level of information that we evaluated for this combined cycle for brownfield, greenfield sites 1 through A. That would be too much information. Again, the IRP is a general planning docket. The specifics as they relate to CPCNs are location specifics.
Okay, and you would agree that in the 22 carbon plan through discovery, and would you agree the public staff extensively investigated that carbon plan in 2022?
Yes.
And the company identified their plans for siting these generating facilities at these locations in 2022 as part of the discovery produced in that proceeding?
Yes, but I did not realize that the absolute decision has been made. I thought it was a topic of potential evaluation, and the company would continue to track and monitor and adjust as situations change.
Understood. And I didn't represent that it was a definitive decision at that point in time, but would you agree that steps along the way from generator interconnection requests to air permits to numerous other steps have all consistently reflected the company's planning and execution intent to site these facilities over the last 2 years at the locations that this CPCN application is supporting today?
That, yes, what the company has filed through the GRR, DICES, and et cetera represents exactly what you've outlaid here in these CPCNs.
Okay. And
but the public staff does not get to control how the company files this GRR. The public staff does not control how the company files this DICES interconnection process.
Understood. But would you agree with me that the first time the company became aware the public staff had specific concerns about the location and the power flows was in 2024?
I disagree. I believe that I have to go back to 2022 and subject to check that we were identifying the power flows issue from DEP over to DEC, at least to the extent that I completed the analysis. Fast forwarding to the 2023 carbon plan, I used the exact same spreadsheets and format that I used in the prior carbon plan. I even used the exact same discovery request, but modified for this information. And this basically got the information in the same format and plugged it into the charts that already ran. So we were evaluating this. I thought it was discussed in the prior carbon plan.
Would you accept, subject to check, that the public staff's proposed order in the 22 carbon plan did not give any specificity about where the CCs and CTs should be located?
The public staff's proposed order did not provide specificity on where those locations would be, because there should be some discretion on this kind of check and adjust and as circumstances changed. From my view, SP5 gave enough information on what decisions, directional guidance that may take place, but also identifying that the company was under negotiations or potential correction, uncertainty associated with MVP and whether or not that price point came in at the estimated price point in the 2022 carbon plan. To the extent that that price point did not match modeling results, the company should have reevaluated at that point in time, and we could not find through discovery of where that evaluation was completed.
Okay. And you would agree that the commission's carbon plan order around the need for CCs and CTs generally adopted language that was very similar to the public staff's proposed order?
Correct. And that's one reason why we provided more specificity in our 2023 carbon plan NTAP, near-term action plan.
Correct. And you would agree that companies did as well, and specifically identified in that NTAP execution plan the plans to site CC1 at Roxborough in August of 23, and then in the supplemental planning analysis specifically identified the plans to site CC1 and CC2 at Roxborough, as well as the plan for a greenfield CC in South Carolina as part of that execution plan.
Yes, and that second Roxborough plant is the one that doesn't make any sense when you take a step back and look at the retirement dates, noting that the retirement dates for the coal plants, again, going back to my prior testimony, were supposed to be flexible. They were not absolute. I believe it was an overbinding constraint from my view in the modeling to make that binary decision that we absolutely have to build that plant at that point in time. And that was discussed in great detail in public staff during the CPRP testimony.
Understood. And that's a conversation for a different proceeding. But I think that, would you agree with me that transparency and communication, to Commissioner Tucker's point, is a critically important two-way street? And we've got to understand, as the company's making these execution plans, what the public staff's concerns are. And that transparency is something that's very important as the company continues to move forward with this energy transition and execute the commission's carbon plan.
Yes.
All right. Thank you. No further questions.
All right, questions on commissioners' questions this side of the room?
Yes, Chair Mitchell.
All right, Mr. Neal.
David Neal for SACE et al. Mr. Metz, Commissioner McKissick asked you your opinion of SACE et al. Witnesses Bob James, his recommendation of this docket, you recall?
Yes.
And you would agree that a key concern that witness James raised was that DEP's failure to do sufficient front-end engineering work for this project before soliciting bids could result in higher cost estimates and could result in significant project delays. Do you recall that testimony?
Yes.
And if he's right, those higher costs and delays would ultimately could potentially harm ratepayers, correct?
That is correct.
And that's, you would agree, a concern for the public staff?
Yes, that would be a concern.
And do you recall his recommendation is to delay approval of the CPCN and require DEP to improve its front-end loading process to complete deliverables so that DEP can have a firmer Class 3 estimate before proceeding to selection of a design builder to complete the project?
Sorry, can you repeat the question?
Yes, that his recommendation to delay the CPCN was so that DEP could improve its front-end loading process and complete those deliverables, the front-end loading, to have so that DEP could have a firmer Class 3 estimate before proceeding to selection of a design builder to complete the project.
That is my understanding of his testimony, yes.
Thank you. I have no further questions.
Mr. Summers? Okay. Go ahead, public staff.
Briefly, I don't want to hold the cost recovery, prudence evaluation, hot potato for too long. But picking up on that line of questions, does the public staff always review capital projects for prudence when they are proposed for recovery in a cost recovery proceeding?
Generally, yes. For large capital plant investments like a generation plant would be yes. However, for other, say, miscellaneous projects close to plant, we would typically use percentages of looking at getting tongue-tied here. We would use samples to look at other other investments close to plant. Sorry, I was looking for the word sample.
Fair enough. And does the public staff's recommendation of approval of a CPCN guarantee that it will pre-approve cost recovery in a rate case proceeding?
No.
And then picking up on the issue of just transparency between the public staff and the companies, I'll just let you, how would you characterize the working relationship that you both have with the company, their company personnel in this proceeding, as well as just in general on the day-to-day basis?
It's a professional working relationship. The company has answered all the public staff data requests. I just want to make sure that's clear and known. We can have potential discussions of what the intent was of the question, but on every time that we've asked the company to meet and clarify, they have answered the public staff's data responses in this case. So it is a positive working relationship. Mr. Lawrence?
Yeah, I echo that, and we routinely run into issues when we're looking, investigating these cases, and especially with this new legislation that has seemingly routinely occurs now. It's a learning process for both the company and the public staff, and so they generally have been very willing to work through those issues to make sure that we're on the same foot, at the time and on a basis moving forward.
Is it fair for me to conclude that the relationships that the public staff has with the company are productive and positive?
Yes.
No further questions.
We have one more question for the witness. Commissioner, definitely go ahead and ask your question.
Okay, it's following up an exchange that you had regarding the joint utility planning, and you were talking about joint utility planning. I think you were referring to kind of meeting the Carbon Plan 951 goals, but then you talked about the modeling, that the modeling really does model for capacity in the different BAs. Could you just talk through that answer one more time?
Okay. So starting at ground zero, there are two separate balancing areas, DEC and DEP, simplified. That the Encompass model, we will solve for capacity for each of those independent balancing areas. So we're not planning for joint capacity. However, once the capacity is resolved, and grant this is a very simplistic explanation, once the capacity is resolved, then we'll look at the amount of energy. But as you know, that no resource is divorced from capacity and energy when you're trying to look at optimization. So to the extent that we build those resources, then we can allow the chain exchange of energy from one balancing area to the other, and it can go either direction. We will optimize those resources to allow an overall system lower cost. And I think that's what I'm trying to say. The Encompass model, it is a system with two separate utilities, but by definition, it is joint utility planning on the non-firm energy basis. To break that linkage, you would have to run a DEC island case, and you would have to run a DEP island case. But I believe, as Mr. Snyder or Duke witness had stated earlier, that's not really how the joint dispatch agreement works. So it would provide insight into the value to what each set of utility ratepayers are paying. It gets very complicated very fast because we don't mimic the constructs of how we actually operate the system today. Setting that aside, the joint dispatch agreement was kind of look at, well, from my understanding, well, in some years, DEC may be a benefit, and those benefits can flow over to DEC may be a benefit, and those benefits will flow over to DEP. Well, in this year, it may be DEP to DEC. Well, in this part of the season, it may be here. This part of the season, it may be over here. So it was supposed to ebb and flow, beneficial to both parties. But what we're seeing over time, it has started very slowly, but it is rapidly increasing to be one-sided. And that's what's creating the concern, what we're seeing with the power transfers. And it's bringing into questions is the JDA really capturing all of the system benefits? The JDA is isolated from the fuel aspect of it, but given the magnitude of transfers, we're starting to identify all these other issues. And if we continue down this path without addressing these issues, and if a merger does not occur, we need the ability for Duke Energy Progress ratepayers to realize or be compensated for that cost that they're being burdened with to serve another utility's ratepayers who aren't necessarily paying the all-in cost for that asset. That answer your question, Commissioner?
Yes, thank you for the more detailed explanation.
Right, but I have one follow-up, and we'll give you all a chance to ask questions on these questions. Mr. Matz, but when you were responding to questions from me previously, you said, well, what did you say about what the commission should do with respect to the utility and joint utility planning?
Identify in this order that the need for these facilities are interlinked, the Marshall CPCN and the Roxbury CPCN, and that the utilities are joint utility planning on a non-energy firm basis. That is the results of the modeling, and that is a function of why these resources are being selected.
And is it your position that should the commission take your recommendation and do so, it preserves the ability of the public staff in a later proceeding to discuss which of the BAs, where the cost should be allocated?
Where the cost and the benefits. Yes, Chair.
Okay, all right. Thank you. Thank you for responding to those questions. All right, let me see if there are any questions on the questions that Commissioner Duffley and I just asked. Okay, there are no questions. So at this point, gentlemen, you may step down. Thank you for your testimony and you are excused. We appreciate your participation in this proceeding. All right, we are with the Environmental Defense Fund.
At this point, the Environmental Defense Fund calls William B. McHale to the stand.
All right, Mr. McCaleb, if you would, raise your right hand, left hand on the Bible. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. McHale, would you please state your full name and business address for the record?
William McCaleb, go by Bill. My address of my office is 1234 Clearwater Canyon, Bandera, Texas.
And by whom are you employed and in what capacity?
I'm employed by Walker and Associates Management Consulting, and I am the Chief Executive Officer.
Thank you. And can you please, can you please briefly describe your role and responsibilities, including the basis for your expertise in this proceeding?
Yes, I've been a management consultant and expert witness for about 20 years at this point, of a 40-year career. First half of the career was spent mostly in engineering, both out in the field as well as back in the office in design, construction, operations. The expert witness testimony has been all related to energy planning, energy facilities, and infrastructure.
Thank you. And did you cause to be pre-filed in this docket confidential direct testimony consisting of 25 pages and 5 exhibits?
Yes.
And if I were to ask you the same questions today that appear in your pre-filed confidential direct testimony, would your answers be the same?
Yes, they would.
And did you also cause to be pre-filed a summary of your direct testimony?
Yes.
And is the testimony set forth in your summary true and accurate to the best of your knowledge?
It's true and accurate to the best of my knowledge.
Chair Mitchell, at this time, I would ask that the direct testimony and summary of Mr. McHale be entered into the record as if given orally from the stand.
All right, the testimony of witness McCaleb on behalf of the Environmental Defense Fund filed in the docket on June 24th, 2024 will be copied into the record as if given orally from the stand.
Thank you. And at this time, I would request that 5 exhibits filed with Mr. McHale's confidential pre-filed direct testimony be pre-marked for identification and entered into the record at an appropriate time.
All right, the 5 exhibits to Mr. McCaleb's testimony will be marked for identification as they were when pre-filed. Mr. Smith, my notes indicate that there are portions of your witness's testimony that are confidential. Is that the case?
That's correct.
Okay, well, we will make sure those portions are redacted. I need you to work with the court reporter to make sure that happens.
I will.
Okay. All right. Is your witness available for cross-examination?
He is. The last I checked, parties had waived cross-examination, so he is up for commission questions unless parties have further questions that I didn't anticipate.
All right, questions for the witness. I'm sorry, cross-examination for the witness from parties. All right, so there is no cross-examination for the witness. Let me check with commissioners to see if there are any questions for the witness. All right, Mr. McCaleb, you've been in the hearing room. I've noticed you in the hearing room over the past several days and weeks as we have held hearings in the company's CPIRP, as well as a CPCN proceeding for combustion turbine facilities located in the DEC service area. Is that correct?
That's correct.
Okay. And you, in those cases, you have expressed concerns about the company's assumption related to the hydrogen-fired capabilities of the new gas-fired assets the companies are proposing to build. Is that correct?
That's correct.
Okay. And as I understand your testimony, you raised the question of, you raised the question of whether these assets, whether these new gas-fired assets are of value to the to customers in North Carolina if they are not able to achieve 100% hydrogen-fired capability. Do I understand your testimony correctly?
I think in part, the CTs that are currently available are 50% hydrogen capable, and those are the ones that are proposed by DEP to be provided for this particular project. My concerns are, one, is hydrogen ultimately going to be used coupled with the infrastructural components that we've talked about in the previous CPCN, thank you, and also with the CPIRP. But having said that, the addition is if a robust, feasible market for hydrogen exists at some point in the future, there'll obviously be some retrofitting charges that'll have to go along with that in order to upgrade those CTs that are proposed for this particular project before that 100% hydrogen could actually be used.
In response to your concern, I've heard testimony from various witnesses, or at least I think I have, that there are other ways that natural gas-fired assets could comply with House Bill 951 and provide service to North Carolina customers or customers of the companies. Let me be specific there. Short of being 100% natural gas-fired capable. Have you heard that testimony as well?
Yes, I have.
And do you have any response to that testimony?
Yes. The CTs, as they're currently proposed, would likely start and would remain on natural gas as its general fuel until hydrogen actually became somewhat available, even at 50%. So the answer, I guess, to your question is yes, that I've heard that as well. And I've also heard a lot about the availability of natural gas through some of the expansions on both Mountain Valley Pipeline, its southern gate, as well as Transco Zone 5.
Okay. And you don't, I pressed you on this somewhat yesterday when I asked you, what is it that you express your concerns and provide us with your analysis, but you don't necessarily recommend an alternative to the generating resources that the company is providing. So can you help me understand, what would you have the commission do, assuming that there is a need for these facilities that the company must serve by 2029, both in the Marshall context and in the Roxborough context?
So while I haven't done an extensive analysis of how much reduction there is going to be by these advanced class CTs.
What do you mean by reduction?
A reduction in emissions, I'm sorry.
Oh, okay.
Did I miss the emissions part? I didn't do an extensive study with respect to how much that does drop, but clearly there's going to be an emissions benefit, that is emissions falling, less amount of emissions going forward, even when this plant is first built, if it runs only on natural gas, when you compare that to the coal units that are being displaced. Number one, I think number two is that within, kind of step back, not into specifically, I don't believe in this current testimony, but I think a step back to the CPIRP. I actually talk a little bit about what would happen and the likelihood, I think, of achieving the actual goals under the 951 rule that's out. And then that, in my opinion, it's likely to be that the emissions, the interim emissions level that are required under 951 likely won't be met. And similarly, if there's no change, all the way to 100%. Obviously, that it would not achieve the complete emissions neutrality. And three, I've also asked in the CPIRP testimony that I filed with you last week to basically go back to the companies and ask how is it that they're going to be able to respond to the requirements under 951, assuming that no hydrogen market ever does develop.
Okay. All right, Mr. McCaleb, that's all I have for you. Let me see if there are questions from other commissioners. I've got Commissioner Duffley, and then we'll go to Kim Murray.
Just a follow up to that last question. I thought I was understanding Chair Mitchell's question to be if there's a need. So we've heard testimony today about the need for this facility goes back to I think a 2020 IRP. And so I thought Chair Mitchell's, and correct me if I'm wrong, but I thought her question was to you, if not this replacement for the coal facility, what replacement megawatts would there be? What capacity would you suggest?
If that was the chair's question, then I misunderstood it, but I'm not suggesting any additional or any alternative resources going forward. I did not also do a study with respect to how many resources and the proper placement of those resources anyway. So I'm simply making the commission aware that some of the items that are included in terms of resources are, let's just call them advanced strides, technology that needs to occur in order for them to be viable alternatives. And if the additional pieces, the additional enhancements that are being made to those CTs, like hydrogen capability, whether it's the 50% or even 100%, whether or not those extra dollars or that likely extra dollars being spent on that are even worth it. In fact, if there's no market that ever shows up.
Okay, thank you for that answer.
And Mr. McCaleb, I just have a couple of questions. The first one is just to make sure that I understood your ultimate recommendation correctly. On page 9 of your testimony, you've provided 2 recommendations. And your recommendation is that the commission should not approve the application unless it directs DEP to comply with the two of your recommendations, which is the first one is to perform a 100% hydrogen reasonable demonstration study, and the second one is to perform the hydrogen blending study. If I'm understanding your testimony correctly, your recommendation is not that the commission should deny the application. It is instead that it's not that recommendation, but instead you're asking that it be conditioned upon the two studies. Is that correct?
Yes, that's correct, Commissioner. These are recommendations that we talked about even in yesterday's hearing about should be included in the stipulated hydrogen pilot, or what I might call a hydrogen study. These are important components that really do need to be kind of fleshed out to make sure that they really are something viable into the future.
Okay. And then I wanted to give you a chance to respond to Duke Witness Snyder's rebuttal testimony, and it's on pages 38 and 39, but you don't need to go to it. I'll tell you what he says. But his testimony is that the 2 studies that you've recommended are not necessary because Duke has already agreed to limited studies in the context of CPIRP execution that's related to the long-term feasibility and economics of the use of hydrogen as a fuel. So Witness Snyder is saying that the studies that you recommend are not necessary because they are already essentially accomplishing what you've asked for in the context of CPIRP. Do you agree with his statement that the studies are no longer, your recommendations are not necessary?
I'm not sure I agree with that at all. I think based upon the work that the companies had done early on with respect to the hydrogen and all of the component pieces as to not only production, but also storage, transportation, and the like. They've missed all of that sort of stuff. It's a lot. It's a lot of things that go on outside of the fence of the plants. And so even if the companies suggest that they've completely looked on the inside of the fence, which I don't believe at all, but let's just assume that to be the case, there's still a whole lot more that goes along with it with respect to what goes on outside. And we've talked a lot over the last week or so about why you might not want to use natural gas pipelines to transport hydrogen in and of itself. And yesterday I spoke in terms of a question that was posed by Commissioner Hughes when asked, is anyone doing any homework or any studies with respect to what's the proper level of hydrogen that can be accepted into a natural gas pipeline? I suggested the answer was yes, and that it had been done by, had been commissioned by the California Public Utilities Commission. That study was actually, let me correct right now, it was the University of California at Riverside, as opposed to what I had said yesterday as Cal State Northridge. But nevertheless, that issue is studied in that report, and the maximum level of hydrogen that study came up with was only 4%. It's a far cry from 50 or 100% of the pipe of the hydrogen that might be inside of a pipeline.
Okay, thank you very much.
Commissioner McKissick.
And this is just a quick follow-up to Commissioner Camerite's questions, and I asked you about it some yesterday, you know, your recommendations. And you have this recommendation, of course, that you go out there and perform hydrogen reasonable demonstration study, and likewise going out and doing the hydrogen blending study. Can you state how this would be different from what you see as being proposed in the hydrogen pilot, which has been stipulated to and recommended for the commission's consideration in the carbon plan proceedings?
So I thank you for that question. I have not extensively reviewed what is actually inside the hydrogen pilot. I have, however, suggested that the components of what I've offered in terms of a recommendation be reviewed, and if it appears in the pilot, so be it. I'm just not sure that everything inside these recommendations are in fact included in the hydrogen pilot as stipulated to.
Okay, thank you.
All right, we will take questions on commissioners' questions, starting with Duke. Any questions? Okay. Public staff, SACE, questions, Person County. Okay. Mr. Smith.
No questions.
Okay. All right, Mr. McCaleb, thank you for your testimony today. You may step down and be excused. Thank you for your participation in this proceeding.
Thank you to the admission. Thank you.
And Mr. Smith, would you like to make a motion?
Yes, please. I'd like to move the exhibits that were attached to Mr. McCaleb's confidential pre-filed direct testimony into the record. And I don't believe that any of the exhibits were confidential. I believe the confidentiality issues were just within the body of his pre-filed direct.
Okay. Well, having heard no objection to your motion, I will allow it, and those exhibits to his testimony will be admitted into evidence.
Chair Mitchell, I have a quick question, if I
Go
may.
ahead.
The commission's previously granted SACE et al.'s motion to excuse SACE et al. Witness Elizabeth Stanton, and I'm not sure if I also need to make a motion to have her testimony entered in the record at this.
Please do.
Thank you. At this time, SACE et al. would move to have Elizabeth Stanton's pre-filed testimony from June 24th of this year, consisting of 52 pages in both confidential and public versions, redacted versions, and her summary entered into the record as if given orally from the stand, and to have her one exhibit entered into the record.
All right. Your motion will be allowed, and the testimony of witness Stanton on behalf of SACE et al. Filed in the docket on June 24th, 2024, consisting of 52 pages, will be copied into the record as if given orally from the stand. The one exhibit to that testimony will be marked for identification as it were when pre-filed, and it too will be admitted into the record. The summary of Ms. Stanton's testimony will be copied into the record as if given orally from the stand as well.
Thank you.
All right. With that, we will move to rebuttal, the company's, the applicant's rebuttal case. So you all may call your first witnesses.
Thank you. The company calls Mr. Schneider and Mr. Beatty, the IRP panel, to the stand.
All right, gentlemen, good afternoon. Mr. Beatty, we've got to get you sworn in. So if you would, go ahead and raise your right hand. There you go. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And Mr. Snyder, you remember you're under oath.
Yes, Chair.
All right.
Thank you. Mr. Beatty, would you please state your full name and business address for the record?
My name is Thomas Beatty. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
Thank you. And by whom are you employed in what capacity?
I'm employed by Duke Energy Corporation as a senior engineer on the production cost modeling and data management team within the enterprise strategy and planning department.
Thank you. And can you please briefly describe your role and responsibilities at Duke Energy?
Yes, in my current position, my primary responsibility is to perform modeling and analytics to support the integrated resource planning for each of Duke Energy's regulated utilities, primarily focusing on the Carolinas. My team is responsible for the modeling performed by the companies in support of the CPIRP and the CPCNs.
Thank you. And Mr. Schneider, turning to you, pursuant to the Commission's August 5th, 2024 order in this proceeding, yourself and Mr. Beatty have adopted the entirety of the IRP panel's rebuttal testimony consisting of 54 pages and 2 exhibits that was initially pre-filed by yourselves and Mr. Quinto. Is that correct?
That is correct.
And do you have any changes to the panel's rebuttal testimony at this time?
I do not.
And if I were to ask you the same questions today that appear in your panel's pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
And your rebuttal exhibit 2 contained confidential information?
Yes, it did.
And did you also pre-file a summary of the panel's rebuttal testimony?
We did.
Thank you. Chair Mitchell, at this time, I'd ask the IRP panel's rebuttal testimony be entered in the record as if given orally from the stand, as well as the panel's summary of their rebuttal testimony also be entered into the record as if given orally from the stand.
All right. The rebuttal testimony of the IRP panel, witnesses Snyder and Beatty, on behalf of DEP, filed in the docket on July 18th, 2024, consisting of 56 pages.
As revised, it shrunk to 54.
Okay. All right, as revised on August 5th, 2024, consisting of 54 pages, will be copied into the record as if given orally from the stand. The summary to that testimony will be copied into the record as if given orally from the stand as well.
That's correct. Thank you.
Exhibit to the testimony?
There are 2 exhibits to the testimony, rebuttal exhibits 1 and 2. I'd ask them to be marked for identification and entered into the record at the appropriate time.
All right. The exhibits will be marked for identification as they were when pre-filed. My notes have 1 exhibit, so we'll just y'all check that and let's clear it up when you make a motion to move it in.
Okay.
But they for purposes of identifying all exhibits to their testimony will be marked as they were when pre-filed.
Yeah, and there's slight confusion in the header. I'll take ownership of this, that it references exhibit 1 twice, but there are 2 separate exhibits. One is 16 pages, one is 4 pages.
Okay, so then I will take that as you're clarifying that there are 2 exhibits.
Yes, ma'am.
Okay,
Thank
they
you.
will be marked for identification as indicated. And does that mean your witnesses are available for cross-examination?
They are.
Okay.
Thank you.
We will start then with EDF.
Good afternoon, Ben Smith for the Environmental Defense Fund. So since you all have been sort of labeled as the IRP rebuttal panel, I just want to sort of define that. Is the source of that sort of labeling from in your testimony on page 4? You have a summary of some bullet points for what the rebuttal testimony supports, including the need for the proposed facility in the sub 179, I believe, carbon plan order, and also the more recent CPIRP and SPA modeling.
Yes, I see those bullets.
Okay. So I'm going to be asking you some questions based upon the part of the need element of the CPCN application being based on that CPIRP order and the current CPIRP modeling that's currently at issue. You all understand in 2050, the state law, HB 951, requires Duke's in-state generation to be carbon neutral with some exceptions. Isn't that right?
I would phrase it differently. My understanding of the law is the commission is to take all reasonable steps to achieve net neutrality by 2050.
Okay. And the projected useful life of the Roxborough plant is 35 years, isn't that right?
That is correct.
And we've been over this a little bit today, I think, but I'm gonna retread a little bit differently. 35 years would put Roxborough CC past 2050 and to about 2064 would be the sort of end date for that assumed useful life. Isn't that right?
That is correct.
So that puts us 14 years past that. How you phrase the net neutrality as ordered by the commission?
Yeah, I think 95% allows 5% carbon offsets, and it also states take all reasonable steps. It does not say you cannot emit carbon in 2050.
Sure. Yeah, and that's understanding. I'm not trying to litigate that issue. I'm just trying to make sure we're all on the same page here. So under HB 951, there's a 14-year window where Roxborough CC still has useful life, but assuming reasonable steps are taken, maybe cannot emit carbon. Is that right?
No, I think I was just testifying to the law actually envisions 5% offsets, and this is going to be on this system, on the DEP system, the most carbon efficient unit of any carbon emitting units. So as of the placement of this unit into service, this would be the very last unit that would be retired of all the existing resources that are carbon emitting on the system. And so it could emit carbon up to the 5% offsets. And assuming the other thing in 951 is it allows for reliability first and foremost. So there's 951 envisions a reliable system trumping everything. So if all else fails, right, if hydrogen doesn't come to fruition, if carbon sequestration doesn't come to fruition, if renewables don't come on at the pace, scope, and scale that they're needed, nothing in 951 says you should place carbon reduction over reliability. So in addition to the offsets, if this unit is needed for reliability in 2050, whether the offsets are there, whether the hydrogen's there, whether the sequestration is there, this unit will run to keep the lights on in North Carolina.
Thank you. And stipulating reliability, because I know my client certainly wouldn't take that for granted. Does the company intend, it sounds like the company may consider deeming the Roxborough CC as part of that 5% verifiable offset in 2050. Is that what you think?
That is one potential pathway. I think I laid it out in the rebuttal testimony as well as in the CPIRP testimony that, you know, today as we sit here, maybe other pathways emerge in the next 2.5 decades. But the 4 that we've identified is yes, verifiable offsets could be one of those 4 potential pathways.
And that's what I'm getting to here. My client cares about offsets or I'm sorry, cares about emissions And so when do you think the companies will begin to plan for which of its emitting generation resources will fall into that 5% verifiable offset?
I think and again, you may not need any offsets. It should sequestration or hydrogen emerge. And again, I reiterate, as I did in the other proceedings, that this is not a Duke issue. This is a national issue. This is the nation working towards this, the federal government putting funds toward it, Duke working with peers and the federal government towards hydrogen, towards sequestration. If those come to fruition in the next 2.5 decades, we may not need offsets. I would say to the extent we do go towards offsets, it would be your most efficient units that would ultimately still be on the system at that point in time. And I certainly would think that this unit could qualify for that. If, again, there's a lot of contingencies in what I just said, but so yes, I think Duke would, as these other technologies either play out or don't, we would start to identify which pathway we might go down and whether or not offsets are even needed.
Thank you. And Mr. Snyder, I brought this up in the CPRE proceeding with you, I believe, but wouldn't it be a fair ask of the company to provide carbon accounting so that we can see sort of what the progress is on the emissions reductions as we go forward, so that we can see verifiable offsets and sort of progress?
And I think we've been talking past each other a bit, Mr. Smith, in those proceedings, and maybe what we mean by carbon, by accounting. We have, to my knowledge, emissions monitoring on all of our carbon emitting resources, and we will know how much emissions we report on our emissions. And so I'm not the expert in that. I don't, specialize in it's called SIMS monitors, simultaneous emissions. As you can tell, I'm not the expert. I don't know what SIMS stands for. But there is monitoring, emissions monitoring systems on our carbon emitting resources. And, we report on those, to my knowledge, best of my knowledge.
Thank you. And I'm going to leave some of that to the CPRE proceeding because I don't know that it speaks to the application here. But moving forward, you referenced in page 36 and 37, and I think you've earlier referenced today, 4 different avenues for the Roxborough CC's operation during a carbon neutrality requirement. Again, agreeing that there's reliability and the commission's decisions there. But can you confirm that you provided those 4 different avenues on pages 36 and 37?
I see them.
And correct me if I'm wrong, but I believe the testimony in front of the commission is that the companies have utilized a generic assumption for the costs associated with a blended hydrogen firing gas plant. Is that right?
We have incorporated, yes, we don't do project specifics for our generic technologies. We take representative technologies, and we have included hydrogen costs in those generic technologies to represent what could be one of the 4 pathways. So we didn't, I think the important point for the commission is we didn't just ignore that there might be some future cost with this resource for one of these pathways. And so we put hydrogen costs in to recognize there will be a cost. Will those costs get refined over time? They certainly will. And that's true of every technology. I mean, I'm not going to at this late date talk about it, but every single technology in our plan will have end of life costs, whether it's, decommissioning costs for solar panels, or do we have refurbishment costs correct for batteries? And have we done enough study on those to say, how do I get to the 30-year useful life of a battery that's only been in the industry for 5 years? And do I need to do more studies on what those costs are going to be? So I could go technology by technology and say there are costs as we move through the next 2 decades that we don't fully know today. So I don't fully know the exact cost of hydrogen, but it's important that we we use publicly available sources. We put a cost in for the hydrogen in 2050. We put a cost in for the hydrogen pipeline, distinct and separate from the gas pipeline, as a placeholder for those costs that will get refined over the next 2.5 decades. much like the costs will get refined for end of life for offshore wind, for batteries, for solar, all of the resources are going to need refined end of life cost assumptions as you start approaching their useful life, or what does it take to get them to their useful life?
And that's, you bring me to what I think is part of my overall point here, is that you all are asking for approval of an emitting resource that will have a useful life during a time where, subject to exceptions and commission abilities to move around as necessary, but an emitting resource that would be online still when we're supposed to be carbon neutral in the state. And so I guess what I'm wondering is do you all have an idea of what the next steps are going to be for the pathway for these emitting resources? And I know that you've given the 4 bullet points, but as you sit here today, do you think that there's going to be something that's done meaningfully in the next 12 months, that the next CPIRP that you'll be able to sort of give more on?
I would think, again, we're going to be working with the industry. The exact pace at which the industry moves on these sort of starts and accelerates at times, switches paths at times. You get new laws and regulations that provide incentives towards one versus the other. There could be additional pushes towards hydrogen. There could be additional pushes towards carbon capture and sequestration. And, Duke will stay abreast and partner with the industry as that moves forward. Exactly how that over the next 26 years as we approach 2050, either any of those paths, how fast they accelerate or deaccelerate, it's really hard to say as we sit here today in 24. But again, I say that of every resource that I'm looking at, it's hard to say where we're going to be 24 years from now or 26 years from now.
Thank you. And you mentioned the pipelines. Is the prevailing presumption inside the 4 walls at Duke that you all will bring fuel in, or that you will generate your own hydrogen fuel if you go down that course?
I don't think there's been a determination on that. I would point out to this commission, it's sort of interesting. Somebody mentioned this to me the other day, and I think it's interesting in this fact, which is 25 years ago, 30 years ago, we did not have natural gas pipelines crisscrossing this country, right? We were, as I said, we were 50% coal and 50% nuclear in 2005. That was 19 years ago, right? And we have built out a natural gas pipeline system across the country in a couple of decades. Both hydrogen and carbon would require a similar effort. To my knowledge, again, I'm not the engineer, you wouldn't use the gas pipelines for sequestration, you wouldn't use them for hydrogen, but it would take that type of an effort. Could it potentially happen over 2.5 decades? Certainly. I mean, I'm sure we didn't think, 25 years ago that we would have 45% of the U.S. Energy coming from natural gas, but that type of build out happened over that time frame. It's the type of time frame we're looking at between now and 2050, and we'll be an industry participant in one of those 2 pathways as they emerge.
Thank you. It's funny, you kind of cut off my line of questions, which were based upon some of your references earlier today to the academic challenges to the execution here. So you'd agree that there are going to need to be technological advances in the next 26 years prior to the carbon neutrality deadline to meet that deadline?
I do, and I'm just saying that the pace, scope, and scale is going to have to be pretty tremendous. And I think the 4 options that are on the table are right now what's facing us in front of us as we're making decisions, real-time execution decisions during this very critical period where we need to get moving towards execution of this energy transition. These are the types of options that we see available to help us further decarbonize. And what I do say is that the problem will shrink as we add the renewables to the system. So the annual amount of carbon we emit will go down. And then it's, what do we do with the residual? Is it hydrogen? Is it sequestration? Is it offsets? Or do you get to, at some point in time, 26 years from now, where you say, policy may change and say, 90% was good. And the rest of the world's still at 50%, and we're at 90. And who knows? Maybe they say 90% is good. Right now, we see the law, but there is a potential that the law says we are 26 years from now that 90% was quite an achievement and we can live with 10%. I'm not saying that's what we're planning on right now. Our plans go to the full 95% reduction, but there's a lot of things. My whole point here is there's a lot of things that can change over, the next 26 years, none of which do I see stranding these assets in any way, shape, or form, or having them retire before the end of their 35-year useful life.
Thank you. I have no further questions.
All right, at this point, we're gonna call it a day. We will be, I'd like to come back on the record in the morning at 9 o'clock. I'd like to push hard tomorrow to get through as efficiently as we can, just in light of the weather that's impending. We have, I guess, about 4 hours of cross-examination time indicated for the rebuttal witnesses remaining. And so I would ask that you all go home tonight and do your best to get your cross questions tidied up and ready to go so that we can move through quickly tomorrow and adjourn as early in the day as we can so that we can all get out of here. All right, before we call it a day, any administrative or housekeeping matter? This side of the room? Okay. All right, well, with that, we will be in recess until 9 o'clock in the morning. Thank you.